Good morning. Folks are starting to roll in. This is the Colorado Energy and Carbon Management Commission. It is September 19th. It's 9:01, and we will start with a roll call.
Commissioner Ackerman,
Here.
Commissioner Cross,
Here.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
Commissioner Shea.
Here.
Mr. Chair, you have 5 commissioners present.
Great. Good to see everybody. And we have a quorum. And we are undertaking docket 2406-00145. Note for the record, I didn't even have to look at a piece of paper to know what the docket was. That's unusual, but that's because we've been doing a lot of work on this docket. We are rolling back into cases in chief rebuttal closing. We've been doing this for a day or two now. And we start with Larimer County and Mr. Sura, who conveniently has visualized. The visual panel is yours. Do you have your witnesses with you?
I'd like to check that. Is Dr. Collette here?
Yes, I'm here.
Oh, wonderful. Okay. Well, I'm going to share my screen and get started. So thank you once again. This is Matt Sura representing Larimer County. And today we're going to have a presentation by Dr. Collette on air quality impacts at greater than 2,000 feet from oil and gas development, alternative rule 604 concept, enforcement of NOx intensity standards on producing operators, return of rule 311, and the role of the pre-application conference. And so now I'll introduce Dr. Jeff Collette with the Department of Atmospheric Science, Colorado State University.
Thank you, Matt, and thank you, commissioners, for the opportunity to address you again. Next slide, please, Matt. So in the few minutes I have today, I'm going to talk to you again about a couple of different papers that we've published. One you've heard quite a lot about, the Koo et al. Paper from earlier this year that I spoke about. And for example, Dr. Tammy McMullen in Koga's testimony spoke extensively about this publication as well. The other one you haven't heard about yet, this is an article that recently completed independent scientific peer review and is being scheduled to appear in the next few weeks in Environmental Research Communications. And this one deals more with using the same Broomfield observations to quantify source contributions of VOCs from oil and gas development and other sources. Next slide. A few things I want to touch on. The first one is just to come back to the importance of benzene, thinking about its spatial distribution and the need for benzene monitoring, especially in DICs. And here I point to Dr. McMullen's testimony with Koga, where she correctly identified benzene as the key component driving HAPS exposure risk around oil and gas operations. She also pointed out that emitted HAPS exert the largest impact locally, which I also completely agree with. This is one of the reasons that we really need local measurements of benzene to understand what's there before new emissions are added. Because these concentration impacts are so local to particular sources, having a measurement somewhere else on the Front Range does not tell us very much about the likely concentrations in a particular area. And this is especially true in the DIC because many studies have shown us that these communities are often burdened with additional air pollution sources. So we continue to call for local baseline measurements of benzene and then benzene measurements also during pre-production and early production operations because of the high risk of this compound and because measurements from elsewhere in the basin are not necessarily very helpful in understanding these pre-existing conditions. As you've discussed a number of times with different groups, Reg 7 does require baseline and operations monitoring, but despite the importance of benzene, it does not specifically require that benzene be measured, even in populated areas. Next slide. The second issue I wanted to touch on, also referring to Dr. McMullen's testimony, She did a nice job outlining the history of observations, including some of ours, and modeling work that helped inform the Commission's adoption of a 2,000-foot presumptive setback distance a few years ago. As she pointed out, that health risk analysis sponsored by CDPHE identified actually the greatest risk for acute or short-term HAPS exposure. In her testimony, however, Dr. McMullen went on to focus primarily on longer-term weekly measurements, looking extensively at our measurements in Broomfield and pointing out correctly that those weekly measurements did not exceed the 3 parts per billion chronic exposure health guideline value for benzene. That's, of course, a good thing. It's not unexpected based on the analysis in the prior health risk study that longer-term exposures were less likely to exceed health guideline values. I'd like to point out, though, that the operations we studied in Broomfield had many best management practices that were implemented, including especially grid-powered electrified drill rigs, closed-loop tankless fluid handling systems that I testified earlier, reduced flowback emissions by 90%, and they shouldn't be necessarily assumed representative of all operations that you might permit. The other thing I really want to emphasize, though, is that in those observations, we saw greater potential for exceedance of health guideline values in Broomfield for acute exposure, even under these fairly well-controlled operations. And this was consistent with the earlier health risk analysis predictions. Next slide, ma'am. So I thought I would share some data with you just to illustrate this. These are data from Broomfield. And as Dr. McMullen mentioned, we make in this study with our partners Ajax Analytics measurements of 15-second plume compositions. This is not the only measurement being made, however. We have continuous photoionization detectors operating, and you can see an example at the bottom panel here of a timeline where you see very level response and then this sharp increase and decrease with the plume that crossed our sensor over a period of 15 minutes or so. During the detection of that plume, we automatically collect one of these 15-second canisters, and that canister we bring back to the lab and we measure its composition and concentrations. And this allows us to calibrate the response of that photoionization detector for that specific plume at that specific time. And we can then combine this information to determine things like the 1-hour benzene concentration. And in the top panel, I'm showing you here all of our 15-second measurements for different operations in these plumes on the x-axis, and then the 1-hour calculated benzene concentrations on the y-axis. And you'll see here there's a line at 9 parts per billion, which is the acute health guideline value presented by ATSDR, often used by the state of Colorado for exposures of an hour or longer. And you can see that many of these points fall above that 1 hour health guideline value for acute exposure. I should point out that most of these are observations relatively close to the pad. There is one point here with the arrow in the Anthem neighborhood, which is about 1,100 feet away. In the design of this study, we did not have a lot of monitors out at 2,000 feet because we're trying to detect emissions when they happen close to the pad and better understand what operations those are associated with. So there's definitely still a need for more monitoring at 2,000 feet and beyond. Next slide. The other thing I want to talk about is this new article that's forthcoming that looks at the attribution of benzene and other species to particular sources, and also looks at the spatial extent of influence of operations from an individual well pad. So here we use the same weekly data collected across Broomfield at several locations of 49 different VOCs. And we use this statistical model called positive matrix factorization to analyze those. And what this does is it allows us to find patterns of VOCs that are associated with each other that we identify as source factors. You can think of these as sort of fingerprints of different source types that are apparent in the observational data set. We identified several factors that are listed here. One is combustion. You can think of that primarily as traffic, a more background source. And then in red here, several different factors associated specifically with oil and gas operations. One of these is a drilling factor with the emission of those larger alkanes I told you in my early testimony were associated with synthetic drilling mud outgassing. We then take these factors and we can construct source contribution timelines for each location we monitor in Broomfield during development of different well pads. And we analyze those results to quantify the contributions of oil and gas versus other source types to benzene and other compounds near the pad in adjacent neighborhoods and at our more distant background site, about 3 miles from the oil and gas developments. And we can also use these observations to characterize the distance over which we can see well pad emissions influencing air composition. Next slide, Matt. So this slide addresses the sources of benzene in Broomfield. There's a lot of information here that I don't have time to explain in detail, but each of these panels is a location. The bottom one is our background site at Broomfield Commons, about 3 miles from the developments. The Livingston and Interchange panels are near pad locations near those 2 well pads. And the Anthem panel is a neighborhood monitoring site about 1,100 feet from the Livingston pad. And what's shown here are the sources contributing to benzene. The top of each of these panels of that timeline is the amount of benzene, and the colors correspond to the different sources. And you can see, for example, if you look at our background site at Commons, most of it is gray with sometimes a bit of green. The gray is essentially traffic contributions, and the green are a more regional background contribution. If you look at the other 3 panels, you see a very different color panel. Our color pattern, particularly if you look at the top panel, Livingston, you can see the timeline for pre-production operations roughly overlaid there. And you see these other colors, which correspond to different oil and gas sources, including our drilling factor and others, contributing most of the benzene during those time periods. At the right, these pie diagrams show over a 2-year period the relative contributions of ONG, oil and gas, versus non-ONG, non-oil and gas sources at those locations. And you see both at the near pad sites and in the Anthem neighborhood, the majority, even on average over 2 years, was coming from oil and gas with much higher contributions even during some of the pre-production operations. Next slide, Matt. This is my final slide where I want to show you how we've looked in this paper at the footprint of well pad emissions. And here we have 2 panels. They're both relatively showing the same information. What we're looking at here is in the green boxes, the contributions, the concentrations measured of certain sets of VOCs during drilling operations at the Livingston pad. There are 2 sets of boxes for each site, which is shown roughly by distance across the x-axis. The boxes on the right that are yellow, if you look at the bottom panel, these are when drilling is not happening. And there we see no spatial gradient in the pattern of these concentrations associated with drilling emissions. The green boxes are when drilling is happening at Livingston. And here you see, as you would expect, the highest concentrations near the well pad, but you see elevated concentrations out to 1,100 feet in the Anthem neighborhood, continuing out to more than 3,000 feet in the Wildgrass neighborhood, and especially at the Thunder Vista School, which is nearly 4,000 feet away. So we do clearly see the influence of emissions from particular operations at individual well pads well beyond 2,000 feet when we do this kind of extensive monitoring. That's all I have for you today, and I'll turn things back to Matt.
Excellent. Thank you so much, Dr. Collette. Larimer County supports the 2,000-foot setback in DICs with the off-ramp that they can drill with informed consent or through a variance process. But we wanted to offer an alternative that would address the substantially equivalent issues for all proposals within 2,000 feet of a residence, both inside and outside a disproportionately impacted community. This proposal that we're going to be showing you currently is an alternative to 604B that utilizes an existing framework and existing rules. It provides additional protections for disproportionately impacted communities. It will not create additional work for staff, and importantly, it will create a report that will help the public review and understand the proposal. What this does is require additional protections that are consistent with having an industrial development move next to a home or a neighborhood. You could think of this as a human habitat protections for specifically when the drill rig is placed within our immediate impact area. What it'll be addressing are the existing factors that are already in Rule 604, independent review requiring use of all ESPs, air quality impact mitigation, water quality impact mitigation, an emergency response plan, public welfare with the noise, light, dust, etc., transportation plan, complaint response requirement, and again, the disproportionately impacted community protections. I'll send these slides, of course, so you'll have a chance to look at over this, but I'll just quickly review. The first thing we changed was to remove the term substantial equivalence, which was never defined, but as was stated yesterday, the statement of basis and purpose back during the mission change rulemaking made it clear that what substantial equivalence does not mean is that there must be protections equivalent to placing the facility 2,000 feet away. It has been problematic, and as both commissioners and industry, we're not sure that what was necessary to demonstrate substantial equivalence. This section sets up the expectation that the mitigation hierarchy will be used by first avoiding, then minimizing and mitigating impacts. It also states that an independent expert will be selected by the community liaison and CDPHE liaison, paid for by the operator, to determine if the OGDP adequately protects public health and welfare specifically. The expert will write a report of their findings in understandable language that will be part of the public record. The issues that will factor into the decision by the director and the commission are in the current draft, are left in the current in this proposal, but are slightly modified. In the alternative location analysis requirement, there's a change to require a finding that the location selected is actually the location that is most protective of public health, safety, welfare in the environment, including wildlife. We have changed G to call it a community outreach plan. The language has not changed at all, but requiring a plan operationalizes the requirement into a written commitment. All enhanced systems and practices were required, regardless if you are within the non-attainment area or a disproportionately impacted community. The practicability exceptions were not changed. Air quality mitigations are required, as well as well monitoring. Water well quality monitoring, already required, will be offered to every well owner within 2,000 feet. An emergency response plan is required if not already required by the relevant local government. At a minimum, there needs to be at least 2 emergency contacts and plans for notifying neighbors in the event of an emergency, and an emergency evacuation plan for those within 2,000 feet. Public welfare concerns of noise, odor, light, and dust are evaluated through the cumulative analysis and addressed through the already required plans that are part of a Form 2A. There is a requirement for a transportation plan, if not already required by the local government, and a complaint response plan that requires someone to answer the phone, investigate the concern, and respond within 24 hours. The DI community protections evaluate and address according to Rule 315B, as well as the complete list of the efforts made to communicate with residents, as well as how many residents signed the informed consent. If more than 30 residences within a DI community are within 2,000 feet of a working pad surface, or 15 residences are within a semicircle, the operator must negotiate a community benefits agreement. Now I'll turn to just some of the other issues that we have touched on earlier. Rule 311, Larimer County still has a strong support of the rules as written in June. We believe that you should adopt parts of the proposed Rule 311 that is prospective in application. Industry has suggested a new rulemaking for more opportunity for stakeholder processes. And that is fine, but something should be put in place now that can later be altered. The state should stop the practice of issuing permits that never expire. We offered this poor substitute for the very thoughtful approach proposed by staff. We hope you will accept the staff's draft. Larimer County was excited to hear about the great work done by allied local governments in Oxy. We agree with a lot of what we have seen in the red lines and look forward to hearing the presentation today. One area of disagreement, however, is that Oxy takes a position that you do not have the authority to enforce compliance with NOx intensity targets. That cannot be true. In the Oil and Gas Conservation Act, the Commission is mandated to require operators to take actions to assure compliance with NOx intensity targets. I have shown this language to you before, but I'm not sure how it could be made more clear. It is in section 3, which begins, the Commission also has the authority to require operators to take actions between May 1st and September 30th. This is a new authority that was granted to you by the legislature. As I said, we believe you have all the authority you need. Again, this is how we would suggest assuring that a non-drilling operator are meeting the NOx intensity targets. If your attorneys do not believe that you have sufficient authority, that would be helpful to know. There is time before the next ozone season to clarify this issue and ensure that you have the authority you need. And finally, Larimer County agrees with Weld and Garfield counties that the pre-application conference is not an appropriate time for the public to attend. It is simply an exchange of information where the operator can discuss a possible proposal and the local government can speak directly about potential land use conflicts and the application requirements. Having said that, it is also not the time to make any decisions, particularly a decision that would be contested, like the size of an impact area. As you can see in figure 6.1, this is common review procedures, and anything that comes through planning department is going to have to go through this process of a pre-application conference and then a sketch plan. And the sketch plan is really a more concrete proposal, but it's not yet an application. And they float that sketch plan in a neighborhood meeting, get inputs from that neighborhood meeting that then informs the decision of what they're going to put into the application. And it's that neighborhood meeting, if it needed to be changed, say an impact area size needed to be changed, it's in that neighborhood meeting where that could come about, and there would certainly be an opportunity for public input there. I don't think, however, that it will serve Colorado to have an impact area debate with every application. My own personal belief, and I've reviewed this with staff within Larimer County, is that the easiest way would be to take the approach suggested by CPW. Determine the biggest area that you think might be necessary and make that the standard. If the operator wants to do something less, it has the burden of proof and may be required to reanalyze and resubmit their plans. And now we're ready for questions. Thank you.
All right, thank you both for going first this morning. Commissioners, the panel is open for questions. Commissioner Messner.
Thank you, Mr. Sura. Thank you, Dr. Collette, for providing some interesting red lines and thinking outside of the box, and is always appreciated in these. I wanted to first ask questions to Dr. Collette because I want to better understand some of the information that you're providing. And so I wonder if we could bring up the slide that had the, I don't know how to describe the bar charts though, or
The last one, maybe where.
the last one.
Yes,
Yeah.
yes.
Well, how about, let's start with the one before this one. That one. So can you talk me through this one a little more? Because I guess I want to understand the axes a little better and kind of what this is telling you.
Yes.
So that I can better understand your points.
Yeah, and apologies for having to kind of move through this quickly. So each figure, that the x-axis is the benzene concentration, and then the y-axis, the vertical axis, and then it's just time on the other axis. And so there are a bit over 2 years of data included here, and then each panel is a different location. The colors show you the contributions to the benzene concentration from different source types identified in our analysis. So for example, the gray is combustion, which is predominantly traffic. The sort of yellow color is this drilling factor that's closely associated with some of these synthetic drilling mud compounds outgassing, is sort of the fingerprint for that factor. And then there is in each panel a dashed sort of black line. Those are the benzene observations at those locations. And then when the model reconstructs the observations perfectly, the colors will stack up to that black line. If it's missing a little bit, you'll see a little bit over or under that black line with the reconstruction from the source apportionment model.
Okay. And this model or this slide, it's telling you kind of information about long-term exposure versus short-term exposure, or what is this telling you?
Yes, so the time resolution in this plot is 1 week. So each week there's a point in the timeline for each of these panels that shows the breakdown of contributions to benzene averaged over that week. This particular analysis is not looking at the intermittent plume exposures that are more relevant to the acute 1 hour exposure.
Okay. And then in the next slide, you're taking the information. Well, maybe talk me through this one a little bit, because I'm trying to figure out if you're taking the information from short-term exposure versus long-term exposure and then compiling into this, or talk to me a little more about this one.
Yes, so this also uses the weekly data that are collected at as many as 18 sites across Broomfield at different times. So we can basically look at each of those boxes shows basically the distribution of concentrations at that location measured at weekly time resolution. And the green boxes are just during the period of drilling at the Livingston pad. So we have, a couple of months there of data for each location at weekly time resolution. And we look at the concentrations as a function of basically distance in Broomfield at these different locations. So again, this is more relevant to longer term, some weeks or months exposure. This is not, again, capturing the intermittent plumes that cross our monitors, typically lasting of order 30 minutes or so.
Okay. And then explain to me again, I understand the drilling factor VOCs, I think. Explain to me again what the complex alkane factor VOCs are.
Complex alkane factor is another factor associated with oil and gas operations that breaks out in the statistical analysis. We see it, it includes, for example, some branched alkanes, some other, that's why we call it complex alkane versus the linear hydrocarbons like propane and butane and so forth. These are often seen during drilling operations as well. They may come from, for example, degassing of material picked up in the pay zone when the drilling mud comes back to the surface and other sources, but they show up associated with oil and gas operations as well.
Okay. Thanks for that. I have a better understanding, at least, of what you're presenting here. I wonder if you could, in conclusion, kind of share what this is. What does this tell you?
So this particular figure is basically allowing us to see, you know, something that's been predicted theoretically, that there should be this spatial gradient in concentrations as you move away from the source. But it's also telling us that, you know, I think in some of the earlier testimony, I heard comments like, we can't see impacts away from the near pad monitoring. We do see these impacts, changes in air quality out to, you know, 3,000 feet and beyond in this case.
Okay. Thank you, Dr. Collette. Mr. Sir, I also had a couple questions for you on kind of the structure of your proposal for 604B. And so talk to me again about the applicability of this. So where do you see this 604B red line applying, and how do you see it applying?
Well, it would just simply replace the 604B4 that is there now, which is a substantially equivalent off-ramp to the 2,000-foot setback, presumptive setback. And so, and because substantially equivalent really has never been defined, this is taking away that really, I think, awkward phrasing and tell it like it is. This is supposed to be additional protections when drilling rigs and oil and gas development are closer to homes than the presumptive setback. And what are those? What are the actual showing that they have to meet to be able to drill without informed consent? And so it is the type of protections that are already required in a number of local governments. And in fact, I worked on 2 applications over the last year that had all of those same protections. And one happened to be in a disproportionately impacted community and happened to have a residence within 1,200 feet. So I think that again, as I mentioned, I think it's better to have informed consent be the requirement. But if you wanted to look for another off-ramp, this is a way to do it. And you know, to make those kind of municipal type regulations required at the state level for any time they're going to be drilling near a home within 2,000 feet of a home, regardless if it's in a disproportionately impacted community or not.
Okay. And how do you, with this red line change that you're proposing, how does that tie into the direction and mandate given to us by the legislature for this rulemaking?
Yes, good question. Thank you. It ties in directly in that it's using the information that is gathered through 315B and the cumulative impacts plans that are required and is requiring essentially that a showing that the cumulative impacts have been analyzed within that area of the neighborhood, and that the cumulative impacts are not going to cause any concerns for public health, safety, or welfare. And that's a showing that you currently don't have right now in your current regulations. It's, there's very specific protections as well that would be conferred on the people within the residents within 2,000 feet of an oil and gas location, like that they would have an opportunity to have their water well tested, like they would have an opportunity to receive the noise monitoring that is required. Anytime an oil and gas location is within 2,000 feet of residents in RBU, they're required to do continuous noise monitoring. What doesn't happen is that the residents in that area don't get that information. This would allow them to have access to that information if they wanted it. It just essentially takes what is already in the rules and applies it in a more concentrated manner that's going to be more protective to public health and safety when you've got oil and gas locations so close to human habitat or residences.
Okay. And then in there, and I'm going to pick apart just one piece of the red line, and I haven't had a chance to fully read the red line yet, so I'll take some time to do that. But you mentioned the community benefits agreement, which I love the idea of a community benefits agreement. I still am struggling a little bit with how we can utilize that in our decision-making structure, as it's a private agreement between residents or organizations and an operator that may have elements in it that aren't directly applicable to our rules, particularly if we're looking at ways to potentially mitigate potential impacts. Does that question make sense?
It does make sense, and I appreciate the question.
Yeah.
I think that a similar requirement, would be to have a surface use agreement in place. It's an agreement between two parties that you don't have anything to do with, but it really makes things better if the owner of the land, wants to have the oil and gas operation there. This would be similar in that it would be an expectation that they would have to show, and there wouldn't be any outline as to what would have to be in that agreement. That would be up to the parties. There is, a draft provision that Green Latinos put forward, and I think Conservation Colorado also supported, was to have the community liaison be available to help negotiate or shepherd, have those parties get together and negotiate that agreement. And this would be a perfect opportunity to use it, because you've got an impacted neighborhood that is in a disproportionately impacted community. And I think that it is right and correct for the operator to do a little bit more for that community, given that it is a DIC.
Okay. And then one other question around kind of this independent third-party public health expert. And I had brought up the idea of something like this, back in April with some of my comments, and even based on some testimony from CDPHE acknowledging that ultimately we're responsible, ECMC, for determining whether or not an application is protective. Help me understand, in your perspective, who is these public health experts, and are they readily available, and how would that work?
Yeah, thank you for that. And I just want to acknowledge that I did hear you say that, and this is a compilation of all sorts of borrowed ideas from all sorts of presentations and red lines that I've heard over the last, the whole summer. So yeah, I readily borrowed from all sources. But who would be the expert? There are right now engineering experts that, well, industry employs to write their plans that would have the capability of doing a report like this. There may be a need to have more than one expert in that there are some areas of expertise, say noise as an example, or air quality, that might not be in one shop, might not be in one firm that can handle that. So they would bring in other folks as necessary, but ultimately it would be a team that would have the ability to determine whether or not the proposal was including all the cumulative impacts and was going to, avoid first, minimize, then mitigate, and ultimately be protective of public health and welfare.
Okay. Thank you, Mr. Sir. I don't have any further questions.
Thank you.
Following up on that question, and then Commissioner Cross, I'll recognize you, but keeping us in line. I'm struggling with the concept of engaging a third-party expert, but ensuring that ECMC is ultimately making decisions. And so can you help me a little bit with your thinking on that front, Mr.
Sure.
Sir?
Yeah, thank you for the question. All that the expert is doing is preparing a report. And that report will go to the director. The director will use that report to make her recommendation to the commission, and that will also go into the record. What's helpful about having a report like this is that if it's written in plain language, it'll also be something that the community can feel good about understanding how they're being protected. Rules since the mission change have done a remarkable job in bringing ECMC and Colorado to the forefront of protective regulations for oil and gas. And a lot of folks don't recognize that, but this will give them a concrete way to understand how the regulations are protecting them and how the plans for that operator is putting forward and the ESPs that are being required are going to further protect their public health and safety. And so it is not a decision at all. It is certainly making their assessment as to whether or not public health and safety are going to be protected, but ultimately that decision is yours.
I might call upon our Attorney General to see if they have any perspective on this idea. It's obviously new and novel, and it's at first blush, but is you Davenport, are you available?
Yes, Chair, you're asking about the concept of the independent expert.
Yeah.
Is that accurate? Okay. So this is an idea that I've just started thinking about, but I do have some legal concerns regarding two things. The first is the requirement, if it's adopted into rule, to have a third party opining on whether or not an application meets the commission's rules and whether or not ECMC has the statutory authority to compel such an analysis. My second concern is also whether or not ECMC has the statutory authority to compel anyone, operator or otherwise, to pay that third party to do that analysis. I'd note the Act is pretty specific on what can be charged by ECMC to applicants or other persons, and I'm not aware of a specific authority to do so in the statute. So I'm not, just to be clear, I'm not necessarily suggesting that I think there's an absolute statutory prohibition right now on that. I'm raising concerns about this and think that it deserves some additional review to ensure that if the commission is interested in this idea of a third-party expert, that we're clear that we have the statutory authority to do it.
Okay. Well, and I applaud Mr. Sura for thinking outside the box and coming up with creative ideas. I would suggest to AG Davenport, keep giving it consideration. This is new this morning. We've got quite a bit of time before we get to, final deliberations. But I appreciate the perspective from both sides, and appreciate the thinking outside the box on that front, Mr. Sura. Commissioner Cross, you had questions?
Thank you, Mr. Chair, and thank you for that. I will admit, I think a couple of my questions about this independent reviewer have been answered, so I'll try and ask a couple additional clarity questions on this. One is, I'm kind of curious about the selection process as well. You said it would be something that would be approved by the community liaison and CDPHE. Have you talked to CDPHE about their thoughts on being involved in this kind of process?
No, because I just wrote it last night.
Okay.
No, the comment was made that, this needs a further look, and I would acknowledge that everything that I just, described needs further investigation. And I'm sharing this language as fast as I can with conservation organizations, allied local governments, and, it will now be available to all parties. But yes, it absolutely needs further investigation. And if there is a problem with having someone outside of ECMC do this analysis, then I would think that, yeah, you would probably need to have a group that is just focused on this issue and preparing this report, because again, this needs to go above and beyond the kind of protections that we typically, or the kind of review that we typically give an OGDP, because human lives, are being affected because it's so close to their homes.
Okay. And again, I think for clarity purposes, they're not making a binding decision. It would still be our decision. It's more of a, hey, here's things that we found that we considered, et cetera. Would there be the potential in kind of what you're envisioning, parties challenging that review, asking for a different review based on findings? I'm just, again, trying to understand kind of what you're picturing in this.
Yeah, that would be as we do today. There are parties that will challenge the findings of the director in her report to you. And, sometimes those challenges are upheld, most of the time they're not. So yeah, I think that everything can be challenged as it can today. In fact, anybody that comments on Form 2A or an OGDP and any one of the plans in there is challenging those plans and whether or not that they're adequate.
Okay.
So yeah, they would certainly be scrutinized that way.
Okay, that's helpful. And again, following up a little bit on what Commissioner Messner was asking as well, with talking about the community benefit agreement. And I'm going to admit, I think you were going through some of your slides quickly, so I was trying to take some notes on that. So if you could maybe pull up the slide that was talking about that again, I'd like to try and understand that a little better.
Do that. Okay, here it is. I'll share my screen. So it's only mentioned here, more than 30 RBUs are within a disproportionately impacted community, are within 2,000 feet of a working pad surface, or 15 RBUs are within a semicircle of the working pad. And again, this is only required if it's enough of a population to be considered a neighborhood. And I chose 30 residences within the whole full radius of 2,000 feet from the working pad surface, because that's about 10 acre density. One residence per 10 acres. And similar to the old, I think it was called an urban mitigation area, you can also have that same density in a semicircle or a half circle at 15 residences in that area. So that's and for somehow language got cut off here, so I'll have to again, I'll fix that slide and make sure that you can read the whole thing.
Okay. And so to understand it, I know Commissioner Messner was asking some questions about it. You said no specifics required in the agreement. That kind of be up for the parties to discuss. And in a situation like this, obviously we as a commission can't force parties into an agreement. And so would it be just an automatic denial if they can't come to an agreement?
Yeah. And that's how this is written and how we're expecting it. Again, you know, the community is being impacted. It's the equivalent of, you know, somebody drilling in your neighborhood. You would want to have something to say about that. And if there was nothing you could do about it, you would like to have some benefit from it. And I'll admit that I'm not an expert on community benefit agreements, but I've read what is available online at the Department of Energy, where these big energy projects often require community benefit agreements, and they seem to work, and they're required by the DOE. So I think that we could probably find somebody from the DOE that has that experience that could talk about a little more, you know, nuance as to how it would work.
Okay. And kind of what I'm getting to here is this would in some ways work the same as the informed consent proposal that with the 604C, that if you can't get the community to sign on, then it's a no-go within the 2,000 feet.
Again, yeah, that's right. That's correct, as written. And again, it's a disproportionately impacted community. So that'd be correct. However, you know, how you develop the community benefits agreement, I would assume that everybody that is within that semicircle or the full within 2,000 feet of the working pad surface would have a vote, you know, and if that were the case, then there would be more of a majority rule. There wouldn't be one person that could stop that development from going forward. It would have to be, you know, a majority.
Okay, and I guess I'm just trying to understand a little bit how we would enforce that kind of, here's what you can agree to, here's what you have to agree to, here's what it takes to agree to something, majority rule versus unanimous. I'm trying to understand a little bit how that would work.
It would be none of that.
Enforcement capability.
It would be none of that. Wyoming requires surface use agreements. And so it's very similar. Either you have a surface use agreement or you don't. And if you show up without a surface use agreement, go get a surface use agreement and come back to us with an application.
But we're not talking about a surface use agreement here. We're talking about something in proximity. And so, and that's what I'm trying to understand is it wouldn't be an operator using the land. So we're trying to talk about, okay, being near, trying to require someone to sign to an agreement when we can't require agreements for people, especially if they're not using their property. And so, and that's what I'm trying to understand here, and to try and explain how we can say, all right, you guys can be considered to have entered into an agreement if you have 29 out of 30, or do we have to say 30 out of 30 or 16 out of 30? And that's what I'm trying to understand.
I think it would be majority. And again, it's a private agreement, like a service use agreement, that's a condition precedent as to whether or not you can have an application, you know, where your application will be considered. Or, you know, they can go through all that and still go through and get a variance. I mean, the variance is always open to them. Or they can find another location, you know, that's outside of a disproportionately impacted community, which would probably be the best idea. Again, there are probably a lot of questions about, you know, how that would work, but I don't think that you would have to answer any of them, in that it would be the entities themselves that would be working out the agreement, and they could decide what that agreement contains. And so long as it is an agreement that is signed off by, yes, this is an agreement, a community benefits agreement that has been negotiated in part by the community liaison, it would fit this description and therefore be valid.
And then I think one additional question before I go to some clarifications from Dr. Collette, and that's with the NOx enforcement. And we heard yesterday from allied local governments that they've spoken with Oxy about a revised Form 2D proposal that we're going to see, I don't know, maybe today or tomorrow, and that kind of satisfied their concerns on this. I was wondering if you've also spoken with Oxy about their revisions during the break to see if you had thoughts on their proposal and whether this would handle the assure compliance that was discussed.
I haven't talked to Oxy. I have talked to allied local governments and have read the red lines that were specific what the allied local governments and Oxy agreed to. My understanding is that allied local governments did not agree to removing the provision allowing the director to enforce NOx intensity on producing operators. That wasn't a part of their agreement. What their agreement was about was the forward-looking or future-looking opportunity for the director to ensure compliance with an upcoming ozone season. And they came up with some good language that I hope that that you all like. I think that it's good in that respect. This other respect, I don't agree. I just don't agree that they got it right. And I think you do have the authority, and I hope that you use it.
Thank you. And for Dr. Collette, I want to try and also ask some clarifications building on a little bit of what Commissioner Messner was talking about. First, and perhaps Mr. Sir, if you could pull up the first slide that talked about the fractions, the percentage of oil and gas that was shown. That one, yeah. So one of the things that I wanted to understand here, so we have the light alkane, the complex alkane, the acetylene, and it shows on the right the pie chart with the percentage that is it definitely from oil and gas or likely from oil and gas is what these are coming from.
So these are the factors that we found that have signatures of VOCs that are consistent with oil and gas emissions. And also because we have this spatial network, they're consistent with emission sources at the locations of oil and gas pads.
Okay.
So I would say they're very likely from oil and gas.
Okay. And with respect to looking at the percentages, I'm wondering if you can also talk about the totals, because I understand, looking at this as, 60.9% is likely from oil and gas at this distance. But I'm curious at what kind of conclusions you have about the totals you're seeing here, as opposed to the percentages.
Yes, so the totals here and the observations at this weekly time resolution of this data set have values below the long-term, the chronic health guideline values. The point here is that because concentrations are below that value, doesn't mean that there's not an impact in terms of, in this case, benzene from those sources. And that without those emissions, people, for example, in the Anthem neighborhood, would have experienced less benzene than they did. So while it hasn't exceeded a chronic health guideline value, there is clearly an impact of those local operations on benzene levels in those neighborhoods.
Okay. And I think just for clarification, I just want to understand, did Ms. Fury from CDPHE say there's no impacts beyond 2,000 feet, or was the impacts are significantly declining after 2,000 feet?
I didn't hear Ms. Fury's testimony. I heard some testimony in the COGA discussion talking about not seeing impacts.
And then if I could get clarifications again on, and I believe it's the next slide. Yes, so, and again, I know Commissioner Messner was asking about the complex alkane factors versus the drilling factors. And you said it's the complex alkane factors are often seen during drilling as well. I'm curious if you could clarify what you mean by as well. What else are the complex alkane factors seen from?
So these are compounds that are things that are found in oil and gas. And we see that some of these in drilling mud or the drilling fluids. Some of these are things that are in the hydrocarbon deposit that's being accessed. So they can come out in different times. It's not strictly limited to drilling operations. This particular analysis is looking at drilling where we see a clear signature of this set of compounds during that particular operation.
And one of the things that I'm curious about in the graph you're showing here is it has the Thunder Vista and the Wildgrass, and you're actually seeing more VOCs from something further away than something closer. And so I'm curious what might explain that discrepancy as you're showing this kind of decrease as you talk about further distances.
Yeah, thank you, Commissioner. That's a good question. And actually, if you look at the first two boxes, you see a similar thing, right? Where the concentrations are a bit higher at Livingston 1 than Livingston 2, even though it's further away. So wind direction is important in this, right? If the wind never blows towards a monitoring site, you're not going to see those emissions. So on average, while things decrease with distance, it's not uniform in all directions. It depends on the particular meteorology, especially the wind direction associated with the monitoring period.
Okay. That's helpful for understanding that.
Yeah, and those two sites are in quite different directions.
Okay. And then maybe you won't be able to answer this question since you said you didn't listen to CDPHE's presentation, but one of the things that I was curious with your thoughts as well was CDPHE and APCD specifically spoke about some of the difficulties with the baseline monitoring, specifically adjusting for many different variables, whether it could be meteorological variables. There's a lot of different things that could come in. You know, you might have different baselines closer to some roads or not, and things like that. And so I was curious, and again, maybe maybe not seeing the CDPHE presentation, it's a bit of a putting you on the spot here, but I'm curious kind of your thoughts of how you adjust for variables when even APCD has said trying to conduct that baseline monitoring is even difficult for them with the camel, et cetera.
Yes, I did not hear their testimony specifically, but I'm familiar with these. We all face these kinds of challenges in thinking about doing baseline monitoring, and especially for something like HAP, which has very specific local emission sources that govern its concentrations. It's tricky, right? And there's a compromise in deciding how to do it. You know, ideally, you would monitor for a year at high time resolution and be able to look at these factors. And you wouldn't do this at one location. You'd do it at a lot of locations. But of course, it's not so practical to do that. And so our proposal to do 10 days of monitoring within the impact area, within the DIC, is definitely a compromise, right? It's not the perfect answer, and that's why we suggested that the threshold to trigger longer monitoring not be the health guideline value, but be some value lower than that. We proposed 1 part per billion of benzene, which is, 30% of the or a third of the 3 part per billion long-term health guideline value. I would say, though, that not monitoring is not a good solution, because we have very little idea what the benzene concentration is in these areas without doing some monitoring. And while monitoring for just 10 days is not perfect, it does allow for some variation in meteorology, which is an important factor, both wind direction and mixing and wind speed, which will affect how quickly things are transported away from sources. So it's a definite compromise to try and come up with something practical, but still much more useful than just assuming the concentration is equal to what it is, 30 miles away in some other place where CDPHE has done longer term monitoring.
And so if it hits that 1 part per billion, then the longer steps in, even at that, the natural there would be higher than 1 part per billion anyway.
Yes, so most of the time when we monitor, we find benzene concentrations between maybe 0.1 and 0.3 parts per billion if we do a lot of monitoring. So 1 part per billion is not typical, and it would be an indicator that there may be an important source or sources that are elevating concentrations in that region and would merit monitoring for longer. And we propose then going to 4 months of monitoring to get a more representative data set. So again, it's sort of a stepwise process. It's a compromise, but we think it's much better than simply choosing not to monitor because we don't have the perfect strategy that's practical to implement.
Okay.
I might add that Kate Fury did mention that it wasn't the worst proposal she'd ever read, but she was actually going off of the first proposal that we put forward and not the refined proposal that we finally submitted in a rebuttal statement. And I'll also note that in reaching out to Air Pollution Control Division, they were not available and not willing to talk to any parties on this rulemaking. They said that that was going to be the position they took with all stakeholders. And I'm not sure if that's true, but they certainly weren't willing to talk to me about this proposal.
Thank you. Those are my questions.
Trying to get off mute so that I can recognize Commissioner Oath.
Okay, thanks. Thank you all very much. Most things have already been addressed and clarified, so I think I just have 2 things left. On impact area, I think what I understood from your presentation today was you're noting that you didn't feel like the impact area is something that is appropriately determined at the time of the pre-application consultation meeting. And so if I got that right, I'm wondering when you think it should be determined in the process.
Thank you for the question and the opportunity to clarify. Well, for one, really no decisions are made at a pre-application conference, typically, at least in my experience with Larimer County. It is an opportunity to share information, and the half-baked, a quarter-baked proposal that is brought forward by any developer, whether it be oil and gas or otherwise, understands what the challenges might be, what some of the land use restrictions might be, and what the application might look like. And similarly, the local government gets information about what proposal might be coming down the pike. But that's it. I mean, it's just an information exchange. And if you wanted to make decisions there, I think rightfully you would have to open it up to everybody because a decision is being made. And Larimer County wouldn't want to make a decision among its staff because that's not their job. They don't make decisions. Those decisions are made by the Board of County Commissioners. And so what our proposal is that allow that pre-application process to be what it is. And if there needs to be a review and deciding of, whether or not an impact area needs to be enlarged or shrunk is at the neighborhood meeting, where you have an opportunity to talk about a little bit more baked proposal. And the neighborhood gets an opportunity to weigh in. And at that point, I think that there would be enough information to say, okay, now that you've had that neighborhood meeting, you can go forward with the application, and here is what we heard from the neighbors, and this is going to be your impact area. My preferred solution is to have it just be something that is as big as possible, that as big as we think we could possibly need. And again, to have the operator have the option of trying to reduce it, but then, bearing the burden of proof that in reducing it, they were not going to be harming public health, safety, and welfare, or missing impacts that would otherwise have been noticed.
Okay, that's helpful. I was just trying to focus in on the process. So I think what you're saying is, yes, some discussion potentially at the pre-application consultation meeting, more discussion at the neighborhood meeting, followed by a determination, but closely thereafter, but not trying to say it should be later after an application is developed or something.
No,
Okay. All right.
I agree that as an operator, you would want to have that information so what you're being requested to provide, the information you're being requested to provide.
Thanks. And then I'm sorry if I missed it, but I'm wondering if you shared thoughts on, and thanks for your proposal and, kind of new creative thoughts around addressing 604. We heard another idea yesterday from Adams County. Sorry if I missed it. Do you have thoughts on that alternative?
As I understood it, and I haven't read it, I've only listened to the presentation, is that it's very similar, but it's only applying. Well, it's very similar, but in two distinct differences. One is that all the ESPs would be applied only in the case of an oil and gas location being within 2,000 feet of an RBU within a disproportionately impacted community. It was really specific about protecting disproportionately impacted communities and wouldn't apply broadly as this proposal would. And the other is that he was really specific about not allowing for the practicability off-ramp. And in our proposal, that practicability issue would still be available as an out for an operator if it didn't make sense to provide electric drill rig in the middle of nowhere where there's a rural community that's being impacted, that's also a disproportionately impacted community, or not. It still doesn't make sense, I don't think, to require electricity where it doesn't make sense, and it would be, burdensome and wasteful to provide it there.
Okay. Thank you. That's all.
Sure.
Commissioner Messner.
Just one more question, and appreciate all the other commissioners' questions. As I heard from AG Davenport, and there's some challenges perhaps around independent third-party public health analysis, but also still acknowledging in my mind the importance that we have some public health expert reviewing applications. What it would be your reaction to having that a staff level position instead of a third party analysis to, I guess, get around any challenges associated with operator funded third party analysis?
I'd certainly be open to it, so long as this evaluation is distinct from the evaluation of any other OGDP, because it's really specific to public health and welfare. And I believe that would be helpful for the public and for your process to have a report that results of it, that really goes through details as to how public health, safety, and welfare are being protected by the proposal.
And it would really just be another referral that we already do, internal and external, as far as evaluating and providing comment or report on the particular application, only associated directly with public health.
Correct.
Okay, thanks.
Thank you.
Further questions? Commissioner Ackerman?
I don't have any further questions. Everything on my list has been addressed by another commissioner, but I did just want to thank Mr. Sura and Larimer for significant and substantial engagement in the process. Again, sound a bit like a broken record, but find it to be very helpful and appreciate the conversation.
Thank you, Commissioner.
All right. We thank the stakeholder for their presentation this morning. Mr. Sir, if you could stick around, I'm trying to figure out like process next. At least one commissioner has a hard stop at 10:45 to 11. And so you're next with Western Colorado Alliance, and you've got about 19 minutes. Do you think you could get your case in chief done between now and 10:45? And then we would break and then come back for Q&A?
Absolutely. We've got 19 minutes.
Let's roll then. Can you bring up your witness?
Yeah, it would be Dr. Allward.
I believe we're working on bringing up Dr. Allward. And now we have Dr. Allward. You are
Okay.
recognized, Mr. Sura.
Excellent. I'm going to share my screen here. Thank you again, Commissioners. Matt Sura, representing Western Colorado Alliance. Here are some of the issues I'll be touching on today. First, the issues that were included in the helpful but non-exhaustive list of issues that was compiled by the staff. However, there are some issues that were not included on the list, but we believe merit your thoughtful attention. So issues that made the list, removal of CICs, elimination of lesser impact areas, definition of reasonably foreseeable future development. That must include all attendant activities, including roads, pipelines, and gas capture plans. Issues that did not make the list is consideration of all activities that are required by new oil and gas development, threshold limits that are missing from the rules generally, threshold limits specifically for reclamation, and water quantity, not just quality, should be a resource that is evaluated. First, the CIC proposal does nothing for the Western Slope. It would not be terrible if the proposal was to have a cumulatively impacted community be a no surface occupancy area, as it just is so cumulatively impacted already that it can't afford to have any more oil and gas resources or otherwise be there. But that's not the proposal. And as written, I think that CICs and the position of Western Colorado Alliance is that CICs should just be eliminated. So this is our proposed red lines. We've proposed this language that would ensure additional development is required by an approved OGDP are considered reasonably foreseeable development. This is necessary because any well that produces gas must either liquefy it, haul it out, burn it for crypto mining or computing services or for energy production or other cloud data centers, or build a pipeline. And every one of those has their own impacts that should be part of that cumulative impact analysis. This is an issue that was already raised by CPW. They believe that a cumulative impacts evaluation should include all attendant infrastructure like midstream pipelines. An issue that was not mentioned in the non-exhaustive list of issues is the need to expand analysis to include these gas capture plans developments. And I hope you've had a chance to watch this video and listen to the noise of all these Bitcoin mining operations are making. We hope that you will please include gas capture plans and cumulative impacts evaluations. So here's the language we have proposed to specifically address this issue. We have changed the language to read a quantitative and qualitative description of the anticipated impacts of any attendant activities such as midstream pipelines and gas capture plants development. Another issue that we've been requesting did not make the list is a threshold limit for cumulative impacts. I was heartened to hear CPW representatives yesterday state, and I quote, "Addressing cumulative impacts requires a baseline analysis and threshold limits." Some of these limits are already established in law and simply need to be acknowledged in the rules. For example, we have a greenhouse gas intensity targets that must be met. Others may need further discussion, but the way to start that discussion is to put them in the draft rules. I would like to discuss a specific threshold proposal we have made about biological resources. Reclamation inspection status report by operator, which is available through COGIS database, is either not being used by ECMC or ECMC is no longer tracking reclamation status. We've asked for a formal review or compilation and analysis if this reclamation success data to be included in the CITER database. If we do not have the staff to determine reclamation success, we believe our proposal to require analysis of reclamation success within the impact area will address that. Our next suggestion will ensure reclamation success occurs. In this, we have biological resources cumulative impact threshold limit. And the commission will deny an application if it determines that an operator's interim and final reclamation failure rate is greater than 10%. All of the operators' oil and gas locations and access roads throughout the impact area will be considered. No reclamation status will be considered failure unless the operator supplies third-party quantitative analysis to verify reclamation success to the satisfaction of the director. And again, we hope that this will ensure reclamation success. The director, as a condition of approval, could still allow for a new oil and gas development if they haven't met that threshold. But part of the condition of approval would be that they continue reclamation efforts in the areas that have not been reclaimed within the impact area. We also want to bring attention to the water quantity issue and believe that it should be considered separately from water quality. Separating water quantity from quality serves as a placeholder for incorporating the work of the produced water consortium. We also ask for threshold limits to be set so the public, operators, and the commission understands the limits by which cumulative impacts will be measured. In this one, we state that water quantity, the commission will deny an application if it determines that the proposal will contribute to unacceptable impacts to a river, stream, segment, or wetland that will harm a state or federal endangered species or Colorado species of greatest conservation need. Or the proposal would further push the region out of attainment with the produced water reuse target for the area set by the Produced Water Consortium. Now, I'd like to introduce again Dr. Richard Allward, who is former COGCC commissioner and a senior ecologist and owner of Arid Lands LLC.
All right, good morning.
Dr. Allward is joining us from vacation, and I appreciate your being here and continuing to follow these proceedings.
Once again, I participate from a different time zone. So, commissioners, I'll be very brief. Largely, I want to say that I support many of the suggestions that were offered by CPW and the wildlife hunting and angling groups. And I'll just highlight a couple of those points. Impact areas, the objective should be that they're science-based, not an arbitrary one-size-fits-all circle. In any other case, that would be unacceptable to industry. to have this one size fits all that has nothing relevant to do with the resources that are being protected. Simple should not overweigh biology. The impact area needs to encompass the entire area of disturbance. And one of the things that CPW reminded us was that all existing disturbance must be included in the measurements. And recall that impact areas are not something that, for example, operators will be monitoring over the long term. It's just the area for evaluating cumulative impacts. So an appropriate and predictable impact area will not require significantly more effort on the part of an operator to evaluate. And since the ECMC's mission is to protect, the impact area can be adjusted, but an impact area of inadequate extent may result in irreparable harm. Okay. And then in regards to cumulative impacts, again, the existing plus new plus reasonably foreseeable impacts and surface disturbance in case of wildlife of all sources of surface disturbance. So the maximum extent of the disturbed surface for those impacts, including access roads and pipelines and flow lines that will be a part of the development. And the existing disturbance can be reduced if and only if reclaimed areas meet the current reclamation standards. So, and then a couple points on biological resources. We need to set a schedule for rulemaking, hopefully as soon as 2025. And this rulemaking should be concomitant with reclamation rules, because the way we see this is measuring cumulative impacts is dependent on having rigorous reclamation requirements and knowing the success of reclamation. An area that's only partially reclaimed or has inappropriate vegetation on it has not been returned to anything close to resembling habitat. And so it must be measured as an existing impact. When this rulemaking comes up, we should adopt an inclusive definition for biological resources and then narrow it as appropriate in the rules. This is how it was done with wildlife resources. The definition for wildlife resources includes nearly everything, but the rules and the high priority habitats are specific to those wildlife that we know we need to conserve and that we know have some information on. One thing where I would like to step out from what other groups have said is with the interim standards, if we develop some interim standards prior to a rulemaking for biological resources, we should use both the PCA B1 which is outstanding biodiversity significance, as well as B2, which is very high biodiversity significance. The B1 are very limited throughout the state and by and large are in areas that have either already seen a maximum amount of oil and gas development or may not see a lot in the future either. B2 still is very high, and I don't think we should exclude that. And a habitat-based approach needs to properly define what is habitat. The areas of the habitat classifications in SWAP are really not appropriate for the biological resources that we're concerned with. For example, if bees are your organism, your pollinator, your invertebrate that you're interested in, you need to consider biodiversity throughout its area of habitat that includes flower availability throughout the season, as well as nesting habitat. So to use a classification like pinyon juniper may not be appropriate when you're talking about bees and their habitat requirements. So that's largely what I would like to cover. Just one real quick thing, if we do reconvene a biological resources working group, I think it must include very specific objectives that will provide information for an imminently scheduled rulemaking. So that's all we've got here for now, and I'd be happy if you have time for questions.
Let's roll into questions. Again, we have a hard stop at 10:45 to 11:15 for at least one commissioner. We've got about 10-15 minutes between now and then. Commissioners, this panel is open for questions. Commissioner Ackerman?
Thank you, and thank you for joining us, even on vacation, Dr. Allward. It's great to see you here and appreciate your expertise and your time. Thank you. I do have a few questions, and they're pretty specific, so I don't think they'll take lots of time. But and this one, maybe Mr. Sura might be partially directed at you as well. But on this point of reclamation factoring into cumulative impacts analysis, and particularly if there are thresholds set that, you know, as you mentioned, Mr. Sura, there should be a denial for all who are not in some standard, and I think you mentioned 10%. How does that proposal account for operations that are on schedule but still in the process of reclamation and not technically complete?
Well, what we had proposed in red lines is that the requirement is that I think that their reclamation success within 2 or 3 years, and we were going to allow for, you know, up to 5 years, you know, to allow for additional time, expecting that they're continuing to work on those areas and reclaim them. And in fact, the rules require that they continue to work on them until they are reclaimed and meet that 80% of precondition threshold. But what Dr. Allward has found in his research in the Piceance Basin is that most, if not all, of the oil and gas locations that are out there are not being reclaimed after 10, 20 years. And if that's the case, then again, we need to be cleaning up our mess before we're allowed to, you know, another application, I would think. You know, certainly we require that in other respects. An operator that is, you know, clearly not in violation of a lot of rules and continues to violate rules, you know, may not get another application. And in that, in a sense, is what we would want you to consider here. The application could still be granted, but it would be granted with conditions that they would have to, you know, work to and show progress at reclaiming the locations in the impact area.
Thank you. That's helpful, and appreciate you bringing the concept of reclamation into cumulative impacts. That's something I've been considering as well. On the water threshold question, we went through this pretty quickly, and so I may be missing, like I did on that last one, some of the detail. But I think what you had suggested is the evaluative criteria would be if there is a negative impact on river or wetlands or riverine systems, which is a pretty broad standard. Did you propose or come up with some ideas on potential evaluative criteria that would determine whether that impact was negative? Again, as has been pointed out in these hearings a number of times, any human impact certainly can be construed as negative in some form or another.
Absolutely, and not tied to the language, but want to start the conversation. You know, clearly there are also references to federal standard that, you know, if a proposal will harm a stream segment or wetland that is habitat or is home to state or federal endangered species or Colorado of greatest conservation need, you know, that proposal needs to consider that. And if it's not, and there's, you know, going to be damage to that habitat, then it needs to be denied. The other issues about unacceptable impacts to a river, you're right, we haven't defined those. And maybe that is something that could be done through a stakeholder process, but ultimately it's your decision as to whether there are unacceptable impacts to public health, safety, welfare. And some of those have strict guidelines and others are more that, using your expertise and evaluating the cumulative impacts of an area, your belief is that the impacts have gone too far. And that's a little bit subjective, and maybe that's uncomfortable for folks, but that's the position you're in.
Yeah, thank you. I appreciate that. I certainly note that that's also the position that we're in with regard to substantial equivalency and having some considerable discussion about whether subjectivity is an appropriate standard. And so hence my my thoughts on narrowing to some degree the scope of evaluative criteria on an issue.
I agree.
And I think thank you, Mr. Sura. I really appreciate those responses. I think the remainder of these may be for you, Dr. Allward, and I'm cognizant, Mr. Chair, of the time and moving as quickly as I can. I think what I inferred from your discussion on the definition of biological resources, I'm not sure if you heard the definition proposed by CPW and supported by the wildlife hunting and angling groups, but essentially they recommended adopting a definition of biological resources at this time in this rulemaking that includes rare plants and invertebrates and their terrestrial and aquatic habitats, and then moves forward, as you said, to further approach how we protect those species. Again, as you're out, I'm not sure if you heard that, and if you didn't, I don't mean to put you on the spot, but I couldn't quite tell if you were supporting CPW's approach or doing so with caveats.
And I didn't recall all the details. I did listen to much of their testimony. And I think there's some shortcomings in just limiting ourselves to rare plants. But since we're also considering the habitats they require, and the habitats that invertebrates require often involves the entire vegetation community. And so I think that is encompassing what's crucial in protecting biological resources. And so, yes, I do support this.
Thank you. I appreciate that clarification. And along with that, you also stated that you, on the biological resources working group, stated that there should be some specific objectives and maybe not a broad approach. And I'm not sure if you heard CPW's suggestion on that the reconvene working group, should there be one, should be focused upon pondering and thinking about they suggested it as a 1300 series akin to the 1200 series, but focused on biological resources, and an HPH-esque patterned type program should be the purview of that, or at least the direction given to that group, and wanted to get your thoughts on that.
Yeah, so something that's, an objective like that moves beyond the definition or what resources are available into towards what species should be considered. And I know CNHP has a lot of information about some of these rare plants and what their habitat requirements are. And so I think a group like that could move forward in a very constructive manner, especially if that group knew that ECMC was going to be taking their recommendations and developing a rulemaking process around it.
Thanks again. Always appreciate your insight. One more question, and that's this discussion. This one's I understand a significant question and maybe more time than we've got here, but as I kind of ponder the CNHP designations, PCA designations, you mentioned inclusion of B2 with B1. And then the habitat types as listed in the SWAP that are types of habitats intended to more broadly protect these species in question. I'm kind of trying to weigh how we go about interim protections here. And I think the statement that you made was that you don't feel that the SWAP habitat type designations might be as applicable for protection. I think they might be arguably a broader interim protection than PCA approach. And so just kind of wanted to get your thoughts on if you had to pick one of those, would you still go towards the PCA approach?
Well, I don't know how it would be implemented. so that would be some of it is how do you, what conditions do you put on a application that says they're going to be in desert brush versus within one of the PCAs. And I think the conditioning may be more, what conditions you put on something might be easier to come up with something that's effective if it's a PCA, because we know that's got some biodiversity concerns, and we probably have what species are in there, at least what types of, whether they're insects, flowers, whatever. And so whereas if you were just we're gonna have conditions on pinyon juniper, I don't really know what those would be and how we would, look at the impacts in that. It would be much more complicated, I think. If they are truly interim, I think I would be satisfied with either approach. If we knew that this was just a short term.
Yeah, those are really helpful comments. Thanks so much, Dr. Alward. Again, our time is a bit short here, so I'll cut off there, Mr. Chair. Thanks.
Yeah, actually, we've got another 5 minutes, so I think we can probably get through questions here. So Commissioner Ackerman, if you have more, please go ahead. Otherwise, I'll recognize Commissioner Messner.
I do have just one more, if that's all right.
Go for it.
And let's see, it's escaped my mind just a second. Give me 1 second here. We better move on. It may come back to me, Mr. Chair.
All right, Commissioner Messner, and then we'll come back to you, Commissioner Ackerman.
Thank you. A couple of questions about water quantity. I think I need to ask some clarifying questions, particularly where the Produced Water Consortium is implicated. So I wonder if you could pull up that language first. One, from a water quantity standpoint and potential impacts, like Commissioner Ackerman indicated, I understand intent here, right? So I understand intent, and I think water quantity is a consideration for cumulative impacts, but also understanding, at least in my understanding, that generally, almost always, if not always, there is a water right associated with water that's being utilized for all oil and gas activities. And I know that there's a number of different water rights that may be utilized and or access to municipal water. And so I'm trying to figure out how to tie the water quantity and potential impacts to these resources that you've identified to the complexities of water rights and seniorities and considerations from the Division of Water Resources in addition to federal agency. It feels very complicated. And so maybe help me understand how that in your mind would all tie together.
Thank you for the question. It is really complicated, and it's made less so in areas of the Western Slope where the federal government itself had said that there are restrictions as to water use in this segment of stream to support endangered fish, as an example.
Which they would already have a water right associated with that. So they're monitoring that for that kind of baseline water right for either aquatic species or even recreation in stream flows or whatever it may be, right?
Yeah, in those cases, it has led to timing restrictions on oil and gas development in some cases, and in other cases, it has required those oil and gas developers to find other water sources. And so, again, I think it's probably in our context most important to have this as a placeholder for the work of the Water Consortium. Because right now, I don't think the Water Consortium's work fits neatly into something that's labeled water quality.
Okay. And then the other piece in there, I think, is BB, where you talk about evaluation of whether the basin and the proposed oil and gas operation is meeting the produced water reuse target set by the consortium.
Mhm.
So those targets that at least initially the recommendations that are coming from the consortium are going to be targets for reuse and recycling, not overall targets for water quantity. And so I guess I'm struggling to see, at least with the existing language, how you would evaluate from a water quantity standpoint whether or not an operator may be meeting any targets that the commission ultimately determines in a later rulemaking, as it's not necessarily, I mean, it does correlate to a reduction in overall freshwater use,
That's right.
but the focus is really, from what you've got in that language, is on reuse and recycling targets. And so, I mean, help me just understand, at least from your perspective, how you see that working, and I can give it a lot more thought as well.
Yeah.
Because again, I understand intent here. I'm just not sure how that language works. So
I understood the purpose of the water consortium is to increase water recycling and reuse, because a lot of that water is right now being disposed, and that is a waste of a precious resource in Colorado. And so really it does come back to water quantity, we believe, and that's why we put it there. But wherever it goes, I mean, the work of the water consortium is basin by basin. It is a cumulative analysis. It should be part of this cumulative impacts rulemaking.
okay. No, I appreciate that. And I'll think a little more about that, because, you know, the overall goal of the consortium is reduction in freshwater use in oil and gas operations, and a corresponding increase in reuse and recycling of produced water. And so that does tie directly to water quantity, and I acknowledge that. Placing it in a regulatory area, though, I have to think a little more about how that works and how that gets structured. So the only question I had. Thank you.
In the last minute or so, any further questions? We'll always, we can bring you back for questions after the break too. Let's plan on doing that. Mr. Allward, go ahead.
Good. If anybody's got any questions for me, it will be after the break. Please let me know. Otherwise, I'm going to go load the car.
Any further questions for Dr. Allward, Commissioner Ackerman?
Thank you. While we've got him here, Mr. Chair, I apologize, but maybe I'll give a quick thought to him here and see if he has any quick thoughts for me. But the thing I was pondering when we stopped was, again, the use of CNHP maps as a consultative trigger for CPW. You know, I just want to kind of get your reaction to this line of thinking. CPW being the entity now with statutory authority over invertebrates and rare plants, but they don't necessarily have or provide or have existing data pertinent to those areas. And so I worry about that as a consultative trigger being a consultative kind of empty field for CPW. And on top of that, worry about setting a presupposed standard if we do reconvene a group to ponder an actual program. And I wanted to see if you had any thoughts associated, particularly with the use of data that CPW might not procure.
Yeah, so I'm not sure I fully grasp all the parts of your question, but I'll try to address it, and please ask for follow-up. I think we could do something, and I've talked with David Anderson, CNHP, and like with the HPH maps, we had to have a rulemaking to adopt them. And then those maps are static until a new rulemaking agrees to an update. And CNHP could work with CPW on the development of maps that meet the requirements, and they could pass muster through a rulemaking. Is that getting at your question there?
Yes, it is. I think that, you know, that certainly starts to get at it. So I appreciate those thoughts, Dr. Allward. Thanks a lot for your response.
And with this, if just one real quick, the Barrens mapping is included with the National Land Cover Database that is hosted on Codex. So There
Thank
is
you.
already a live map for that.
Thank you.
Thank you.
All right, with that, we will take a break until 11:15. I would note to everyone that we're going to take up Madhvi Chitor at 11:15. It's a good time with her school. So she'll be next, and appreciate the presentations from the stakeholders this morning. We'll see you at 11:15.
Yeah, I just spoke to the chair. He's unable to, he's had an unavoidable and unexpected conflict and can't attend the hearing for the next hour or so. He wants to assure everyone that he will go back and listen to the course of the hearing that he missed in that regard. We'll need a chair in the interim, and Chair Robbins has also requested that we take a lunch break from around 12:15 to 1. That will allow him to come back after that lunch break.
Thanks, Kyle. I'm happy to chair in his absence. Just here for an hour. So if that works with everyone else, we can continue moving forward.
That sounds great, Commissioner Messner. Do we have Elias on tap to kind of help step through? I don't know if we've got mixed up from our regular agenda or not.
Elias is in a meeting, but I am here in his stead. I'm Jana Jacobs, the hearing officer assigned to this matter.
Okay.
And we are starting with Madhvi Chitor, who is a student. And then after we have finished with Madhvi's presentation, then we'll proceed if you wanted to finish your Q&A with WCA. And then we'll go from there down our list.
Great. Thank you, Ms. Jacobs. Ms. Chitur, thanks for being here with us today. Happy to hear your thoughts. So go ahead and start when you're ready.
Okay, thank you, Commissioner Messner. Good morning, all commissioners. I am Madhvi Chitor, 13-year-old eco warrior, youngest UN Child Advisor, 2024 Time Kid of the Year honoree, and voted Best Upcoming Peacemaker by 14 Nobel Peace Prize laureates. I am the founder of 501c3 nonprofit Madhvi for Ecoethics and the Ecoethics Global Movement. I fight for every living being, humans, flora and fauna, fundamental right to clean air, clean water, clean soil, clean food, and great health of my generation and future generations. Thank you for doing some adjustments in the order of hearing and accommodating me today. My thanks to the hearing officer, Ms. Jana Jacobs, for coordinating this. I also thank all you commissioners for your efforts and that of Ms. Sabrina Trask and her team in this cumulative impacts rulemaking. I also want to bring it to record that I had reached out to all parties via email. I heard back from attorney Ms. Morgan Brown of Greenhouse Connection Center, attorney Ms. Lauren Swain of Physicians of Social Responsibility, and also from Ms. Jamie Jost of Oxy Inc. Thank you all. Today, in my presentation, I will reiterate my requests from my September 5th presentation and also my position on some items on the issue list. Number 1, biological resources. The current 2021 rules have used the term biological in 3 ways: biological integrity, biological substance, and biological resource. Hence, the 100 series rules must have definitions for all 3 phrases. Number 2, please kindly include wash areas, gulches, and ditches, along with wetlands and other water bodies. In the 315A2CII. These are an integral part of our ecosystems. We need to explicitly mention these in the rules in order to conserve them. Repeatedly, we see that these smaller water bodies are destroyed during any anthropogenic activity or land use, construction, or disturbance. Number 3, please enforce the monitoring and cumulative impact evaluation of sulfur dioxide, surface temperatures, tremors, and ground shaking in the 300 series rules. I've mentioned the occurrences in my red line document. I had discussed this with Commissioner Karen McGowan and also have given testimony since November 2023 that surface temperatures must definitely be monitored in the oil and gas location and also in the impact area. Commissioner Karen McGowan at the time complimented me that I was the only one who had mentioned that. Now, if these suggestions are implemented as rules, ECMC will be the pioneer in doing so, so please kindly oblige. The density of oil wells is directly proportional to the magnitude of tremors felt. For example, 160 oil wells in the Larry Range is very, very significant. Number 4, please include in the definition of cumulative impacts explicitly soil quality, tremors, and surface temperatures. Why should we monitor only what is required in the statute? Soil is the silent supporter of life itself on this planet. Soil quality is very, very important, as soil quality directly impacts our food chain itself. Our crops, vegetables, fruit, our farm animals, game animals, beef, dairy, etc., etc. And the ECMC cannot ignore it. Please enforce number 5. Please enforce soil layer evaluation up to 50 feet below the surface. A USGS report found VOCs and hydrocarbon concentrations at depths of 50 feet below the surface. Number 6, please increase impact area to a 3-mile radius. And in fact, I would request to ECMC to consider defining 2 types of impact areas, rural and urban. Number 7, I request ECMC to mandate that the operator also provides a 24/7 emergency contact number to the community within the impact area, and that is explicitly stated in the rules. Number 8, in the rights conveyed in section of 314 rules for the CAP and 309 C2A and 309 C2B, if the commission approves a CAP, the operator should separately evaluate cumulative impacts for each individual oil and gas development plan proposed within the CAP. CAP rules section does not mandate any information on the working pad surface from the operator. The working pad surface are huge disturbance creating structures and will contribute to the cumulative impacts. So when an OGDP is submitted, a new cumulative impact report must be presented to the commission. Number 9, please characterize what is no significant land use changes in the CAP. Number 10, in the various 300 series rules, I request that ECMC implements that the distances are measured from the perimeter of an oil and gas location boundary and not from the working pad surface. Number 11, I request you to modify the current definition of oil and gas location to include what all it can encompass within its perimeter. The reason I'm requesting this is that in rural areas like in Western Colorado, I have seen individual oil wells in close proximity to roads and houses. Does that mean that houses have been built within the boundaries of an oil and gas location? Hence, I'm requesting ECMC to modify its definition of oil and gas location. Number 12, please include even Colorado Water Control Board or any other appropriate organization responsible for our water resources and for our soil in their collaborations and discussions for rulemaking. Number 13, also please include state wildlife action plan habitats. Number 14, I plead with you to create a rule such that the owner of the land must not be allowed to be bribed or bought over by the oil and gas industry to circumvent the setbacks. This is because we are all connected, and one person action can impact others too, and pollution has no borders. I have submitted my feedback on the various issues in the issue list to the ECMC in a document, and it has been uploaded to the portal. That concludes my presentation. Together for our planet. Thank you.
Thank you, Ms. Chatour, for your presentation and the information that you've provided. Commissioners, are there questions for Ms. Chatour? Mr. Tour, I'm not seeing any questions, but appreciate your participation, the work that you've done in developing your presentations, and the in-depth analysis and red lines that you've provided as part of this rulemaking. I think they're very helpful in better understanding your perspective and your suggestions for the rulemaking. So thank you for that.
Thank you very much, Commissioner.
Thank you. With that, Ms. Jacobs, I'm not sure who is next on the agenda.
So it's up to the commission. If you had additional questions for Western Colorado Alliance, we can bring those folks back. If you were finished with that Q&A, we would then move on to TEP Rocky Mountain.
Okay, commissioners, are there further questions for Western Colorado Alliance? I don't think so. So I think we can move on to TEP then.
Just one moment, we'll get folks elevated.
Mr. Jewell, is it just you or are there others that need to be elevated?
Just me, kind sir. Thank you.
You bet. With that, the floor is yours.
All right. And good morning, commissioners. Michael Jewell with Jewell Jimerson Natural Resources Law on behalf again for TEP Rocky Mountain LLC. Again, it's just me, but I have TEP's full expertise and support behind me with this statement. And during the break, we took direction from the chair to work with partners and stakeholders to heart. And to that end, while reiterating clearly, TEP is my client here. Happy to say, though, that I am joined in harmony by Karis, now QB, Laramie, Fielding Hill, and other West Slope operators who have been engaged with the concerns that are unique to the Piceance. But more importantly, we're unified to the important matters across Colorado regarding responsible oil and gas development, regardless of basin. This harmonized position is most acute when I will talk about impact area, which will take the majority of my time. Before I conclude with a few final roundups and do my part to maintain this nice cadence we have marching to our timely conclusion of closing and rebuttal statements. But to preface, and more than a thanks, but a commendation to the chair, you commissioners and staff, particularly hearings manager Thomas, Officer Jacobs, and Ms. Amaro, not only for a smooth rulemaking, but creating a tone that's kept perspectives sharp, heads cool, despite the obvious divergences. It takes determination and focus, and TEP appreciates that grit. I would offer one redirect, though, to that end, but a supportive redirect, in that TEP does not see the implied negativity apparently imbued upon a large portion of the people of Colorado. They are not powerless to speak, incompetent to act, ask questions, call community liaisons, understanding where there's a bias, hire a lawyer, or the like. In the culture of the West Slope, as I mentioned briefly last week, TEP has seen the opposite of anything, an engaged community that embodies the pioneer spirit. And we meet with them when concerns are raised. And I know our industry partners are no different. Because again, I find it preposterous to think anyone wants a dirty environment. I say this also personally, as colleagues have also done, a father of 2 children myself. Now imagine how those poor souls have to endure dinner time conversation in our house. Their dad is a pointy-headed lawyer and a public health professor. Mom is a research pharmacoepidemiologist. Their future is not something we want mucked up. So skirting the rules for short, marginal, and dubious profit gains is bad business. And our workers, from the boots on the ground folks to the boardroom, that would imply bad work against their own pride and their life's work. This is not how any of us, left, right, environmentalists, conservationists, view our lives. Everyone wants a higher standard of living. We all want what we call in public health, quality adjusted life years increase that comes from those top 3 advances we talked about from the history of public health. Broad spectrum antibiotics, yes, widespread water hygiene, but the access to clean and readily available energy being number 1. And this is from the WHO, not me. So please take that mindset when you deliberate. I require my graduate students to wrestle with the hard concepts of rights versus health, regulation, innovation, and passion. Hold them all in tension and optimism for the human spirit without allowing fear or pessimism to take hold. These concepts, as diametrically opposed as they may seem, they work together. So of course, this never means to give up the fight to improve and apply growing scientific understanding, as I said before, to defeat negative externalities. Energy development and public health can and do go hand in hand. We're doing our part. So to my main point, impact area. Going back to our pre-hearing statement, we stated that the Piceance Basin negotiates significant challenges to topography, along with the differences in three main buckets. One, the nature of what we do is natural gas. The intensity of what we do, our drilling methods and infrastructure is a little different than the rest of the state. And the scope of what we do, our operating lands and our non-attainment area is different. It's a sharp contrast that's made in the Piceance. So this qualitative factoring should avoid pre-application guessing games in the case-by-case application requests that drain staff time and should favor instead a working baseline standard. We reframed this in our presentation last week a little bit in 3 points. I'll quickly review here for our closing. Topographical relief. The acreage radial mile is about 2,010 acres, but in the Piceance, we usually see about 2,400 acres because of that elevation relief. Could be up to 3,000 acres in some instances, but at 2,400 acres, that's about 20% more of a regulating effect than what you would see, say, in the Wattenberg. In both CPW and BLM note, this elevation and topography actually have built-in protections. Those tree bluffs and elevation gains are natural barriers that reduce impact. Number two, non-attainment. The default idea of the impact area hinges on the fungible nature and free-flowing ability of air and potential air impacts. You don't need to be reminded again, though, we're not in non-attainment. If Colorado were not in non-attainment at all, we probably would not be starting even with a 1 mile. So it seems logical then that the Piceance will start with some basis without that interjection. And lastly, number three, federal resources. The West Slope lands are understood better because of the extensive NEPA conducted on a supermajority of our lands and the abundance of RMPs that can be equivalently referenced in the review of your permitting processes. But since that opening statement, a few supporting and conjunctive statements have been made that are worth addressing here. First, regarding air with Kate Fury and APCD, as you've heard, and when it comes to air, that 1 mile radius is somewhat arbitrary. California itself, 1 kilometer or 3,280 feet. No one's going to fault California for not being progressive on environmental regulations. But she noted that long tail, which is essentially a regression curve. This must be noted as potential impacts drop off significantly after 500 feet. Potential emissions will dissipate and dilute to amounts that are extremely difficult to scientifically connect to effects on people or other species. The importance of appreciating this dilution of emissions, and not to mention other impacts like sound, light, or other dissipating effects, means that increased linear distance does not mean directly proportional linear protection. I know it's late in the rulemaking day for a crash course on epidemiological foundations, but simply stated, to avoid the cardinal sin of confounding, risk of exposure is not the same as the odds of an exposure, and the presentation of a potential risk factor never translates into presentation of symptoms. Furthermore, many social determinants of health are co-factoring in circumstances where large populations and contributors to negative health outcomes are present, particularly in the core studies, most of which are retrospective studies that have been highlighted throughout this hearing. But the key point to remember is that the potential for any health impacts regresses, as the experts have stated, after 500 feet, or how a much more where we are now with non-attainment and topography provides that natural protective cover. So quickly, land CPW noted that the working path should be the primary elevated concern. Some comments yesterday, it seemed to me to be taken outside of context there, but I'll leave that to you to sort out, not have any argument there. But it seemed clearly stated to us that the primary impact should be judged by the working pad. Yes, admittedly, including pipelines and roads. But pipelines and roads are important, but not fatal, because pipelines are typically buried, planted over, rarely ever conceived again, or a permanent barrier or obstacle. And even that remediating effort of pipelines are a benefit in the Piceance because they're in arid portions that are improved. Roads typically already exist and harmonize with wildlife who don't really differentiate whether or not it's an oil and gas road or for some other purpose. And as you've seen with most, if not all of our applications, new roads are actually very rare and kept to an absolute minimum, and the locations of which are even dictated by topography or the limitations of ridge lines. And lastly, on land, there's a bit of a qualitative turn, and I do not nor cannot challenge the direct testimony of Mr. Molvar. I'm not a wildlife biologist, but it's fair to point out the content of the studies that he pointed out of habitat selection patterns and habituation. I want to balance that with another part of the story that should be raised. Coexistence and adaptability are also proven. Wildlife are far more rugged and resilient and evolutionarily tuned to live alongside of us. But hear me well, I want the record to show this is when we do our part responsibly, and that's what my client intends to continue to operate. This point is balanced by actual science because we see that numbers of herds are still continuing to improve. So that point would be far different if oil and gas operations were necessarily associated with big game species death, herd stability problems, or extinction threats, which we're not seeing anything to that extreme. So therefore, suggestions of NSO and the like are like the proverbial swatting of the mosquito with a baseball bat. Let's focus on narrowly tailored solutions where problems actually exist. And right now, we're doing a great job of avoiding, minimizing, mitigating. And lastly, with water, the Anglers Group pointed out Huck 12s and other standards for water that invite a look about a half mile, which our Form 2A already requires us to do. So the only issue we see is that we look at air, land, and water. These multiple standards are starting to invite a large cluster where simplicity will achieve the end that's intended. So not trying to sound like earth, wind, and fire, nothing intended there. But therefore, to bring home our pre-hearing statements, presentation, and synthesis in this closing, we have a simple solution to propose by TEP and the West Slope operators, with thanks to WLRG setting the table with Commissioner Robbins yesterday, and also Mr. Dean, who recognized that maybe a carve-out would work for the West Slope. And that proposal is this: a statewide 1 mile impact area, but now with the popular off-ramp or step down, as I prefer to say, to 1/2 mile if the proposed OGDP or cap meets the dual criteria of, number one, it's outside non-attainment, and number two, has topographical relief with that acreage discussion I had earlier. Now, this is distinct from a separate Piance rule because not all areas outside the Front Range will always be in non-attainment, because if so, this off-ramp would not apply. Also, not all potential locations in the Piance have the topographical relief that I indicated. Granted, most probably do, but there are some that are located on flat ground. And note, please, this is a scaling back, negotiating forward to you from our 2,000-foot ask, because we want to collaborate and invite further discussion on this to arrive at an equitable solution for all operators. And that's our philosophical rationale. The application of a statewide rule must have equitable effect. Being inclusive of our operational diversity and applying equitable regulatory effect despite our differences. Where this inclusive off-ramp applies, it's only having the same or similar net regulatory effect as if our lands were located in non-off-ramp locations where there are fewer effective acres that lack elevation protections, non-attainment status, or other associated protections like the federal oversight. Statements made by CPW and APCD yesterday have underlined this position strongly, so we hope you'll give this hard consideration. We're only asking for parity, not special treatment, so that we're not unfairly disincentivized in an area of the state that ironically holds fewer opportunities for cumulative impacts on Colorado communities. So 30 seconds on a few miscellaneous points. On biological resources, we said our piece on that matter. Appreciate your and staff striking that definition so far from this rulemaking. We continue to believe a separate rulemaking is not only necessary, but required to have such a precise definition that would be appropriate. There's too much to iron out, too much data, and too high stakes that we need a narrowly tailored and well-crafted definition, and collaboration toward that end is the way to win. On rules 311, 314, TEP would love to get back to the cap planning if we can work with you on an idea that will work. We anticipate Karis and Laramie might be making some comments there that we will support. So to conclude, in step with other parties, we're happy to email or file a one-page submission of our impact area language proposal if that is to your liking. Thank you again for your time and thoughtful consideration. Best wishes on deliberations and concluding well.
Thank you, Mr. Jewell. And I, for one, always want to see written documentation and red lines. That helps me and as I evaluate stuff. So if you're willing, would certainly support that. Commissioners, The floor is open for questions. Commissioner Oath?
Thank you. And thanks, Mr. Jewell, for that idea on the impact area. It was something I had been pondering also, but your specificity is helpful. On the second element of it, the area has topographical relief. Is that it's just not a term I'm familiar with. So is that a well-defined, well understood, clear sort of assessment of what qualifies as an area with topographical relief?
That's fair. And if I had a map of the region, it might be useful to point out some examples, but most of the locations that Terra and Karis have, QB have, they're in areas that in our most recent OGDP applications, you could see they go up and down in elevation, and that's what we mean. So when I say that they cover 2,400 acres, I think we could rest assured that you could see how they go up and down, and kind of that pancaking, if you will, is what we mean by topographical relief. And so when I mentioned collaborating on that definition is one that probably could be open to some increased specificity to make sure that is clear. But I would probably venture to say 95% of our recent past 2 years and future applications will be clearly in that mode.
Yeah, okay. And that's fair too. Like, I mean, I can imagine some that are obviously yes or obviously not, but it's what are those, how is a determination made for some that are sort of in between? So you say further work would be needed or could be helpful to further flesh that out, given where we are in this hearing. Do you have a suggestion on how that would play
Well, I
out?
can go back with West Slope Koga and our operator partners and get you a firmer definition. I know our planning folks are the ones who have the protractors, if you will, and can
Yeah.
get a firm definition, not the attorneys.
Okay, well, I think maybe piling on what Commissioner Messner said, if that having something in writing would be helpful, perhaps if, you work on that piece of it and before you submit that to us, that'd be helpful.
Will do. Thank you.
Thank you.
Commissioner Ackerman?
Thank you, Mr. Chair, and thank you, Mr. Jewell, for being here. Appreciate it. And just kind of pondering, and again, I appreciate the further thought and effort that all parties continue to put into trying to whittle us down to some good solutions here. And this is along the lines a little bit of Commissioner O's question about topographic relief. And I certainly had that point to make as well. I agree with her that we would need to understand better what topographic relief means. And I do think that we've heard from CPW and probably CDPHE on air and wildlife that topography makes a significant distinction. And so I hear you there. I'm a little perplexed on water. When CDPHE presented to us, they talked about 1 mile likely being insufficient. They also didn't agree with the Huck 12 designation as being appropriate, but they counter proposed, I believe it was a 2.5 mile radius specifically for water, and talked about possible downstream extension of 5 miles distance from the source if it's within a surface water supplier zone, from what I recall. And they did that in alignment with their Zone 3 protection standards. To me, the topography issue maybe becomes a little less applicable when it comes to water, because you actually have probably accelerated movement of water with topographical relief. And so I just wanted to see if you could address your thoughts on water, if you have any.
In full disclosure, it's come up less in our applications, Commissioner Ackerman. Not that it's not important, but some of our more recent applications just haven't had as many runoff streams or seasonal streams, or when they have come up, they just haven't been as active as they have been when the last assessments have been done. So I think I would just need to come back with a review from my client and maybe build that back into the definition, or as a option in the definition that we get back to you on.
Thank you. Appreciate that. That's all, Mr. Chair. Thanks.
Yes, sir.
Commissioner Cross, any questions? I've got a couple of questions, Mr. Jewell. So understanding that a lot of stakeholders are proposing different impact areas, and for me, the impact area is the area of evaluation. So it's not a setback; it's an area of evaluation for cumulative impacts, but kind of resource specific. So as Commissioner Ackerman indicated, I think from CDPHE we heard 2.5 miles to potentially extend 5 miles as applicable in particular situations as an area for evaluation. I think from CPW, we heard some consideration for evaluation of impact areas associated with the oil and gas operations, including an extension for new service disturbance for access roads and pipelines as a mechanism for evaluating potential cumulative impacts. And, I think from an air standpoint, it's been all over the board, but I think, and I want to make sure I understand your proposal correctly, but I think what I'm hearing you say is that irregardless of the resource, you want to go to a default half-mile area for evaluation, understanding that there are some expectations. Sorry, I think I misstated your position. You're okay with a mile, but want to have a step down to a half mile to acknowledge areas that are outside the non-attainment and allow for some topographical relief. I'm having a hard time tying that to what we're hearing from other stakeholders or expert testimony on the need for, from an evaluation standpoint, looking at things more resource specific rather than a kind of default radius. So thoughts on that?
Thank you, Commissioner Messer. I'm hearing two tracks as well, to be fair. There's one track, I believe, that is simplicity and comprehensive, which is the track I'm proposing, which is one I'm hearing from industry, but also it sounded like we heard yesterday as well when Commissioner Rollins, who's not here to defend himself, with that 1 mile being a good starting point, or at least one worthy of discussion, which is I'm running with here. And that could be inclusive of all impacts, air, water, and with that is what we're proposing. There would be a step down because the impacts are just not the same when you're in a non-attainment area. So I think that's been established fairly clearly. I will give to you that water has been one we've been looking at a little bit less than terrestrial impacts and air. So I think that can warrant some further discussion, but I think it's one that at least Terra is equipped to evaluate and provide assessment, with some ease. But at the same time, I think having a predictable and clear, comprehensive area makes things easy for staff. It makes things predictable for operators, and it doesn't relieve the comprehensive expectation that you will have on operators to look at that comprehensive area and to report it predictably each time they have an OGDP or CAP to you.
Okay. And then I think one of the other things that we heard, particularly from CPW, at least I interpreted it, was one of the benefits of defined impact areas and perhaps having them more broad than I think what you're proposing is ultimately the collection of data that helps inform the potential cumulative impacts for not just an application that's being submitted, but that data being available to inform databases, whether that's the CIDR database or Codex or whatever database that may be, to make perhaps better decisions on either impact areas or applications in the future. And I'm open to your thoughts on that element and the importance of that in kind of determining impact areas.
Yeah, and if I'm tracking that same conversation, I'm not 100% sure, but correct me if I'm wrong. it sounds like depending on the species, depending on the circumstance, that impact area could be rather wide and actually well beyond the scope of what a given operator might be proposing. And that is what seems problematic to Terra and the West Slope operators. That's why I focused on another comment by CPW that the primary assessment should be done at the working pad. If we pick on big game a little bit, I'm not sure that picking on the entire migration area of elk for the entire West Slope is the appropriate assessment when you're focusing on a 1 mile radius from a working pad for the elk in that area. So we don't want to stretch the jurisdiction that far when the immediate scope of impacts is indeed definitely something that's far more narrow.
Okay, thank you for that. I think those are questions that I have. Any other further questions? Well, thank you, Mr. Jewell, for being here and providing testimony and rebuttal.
Thank you for your time as always. Appreciate it.
Thanks. I guess Ms. Jacobs, I'm not sure who's next, understanding that we got 23 minutes. I don't know if it makes more sense to take a little longer break until 1 o'clock or whether we have someone that could fit inside 23 minutes. I think ultimately I'd like to defer to whoever next would like to do.
We have Colorado OG Society scheduled to go next, and they have 6 minutes and 39 seconds. And then Laramie Energy, Cirrus Piance, and Fielding Hill together only have 2 minutes, 45 seconds. So those are the next two parties that are up. My understanding is that Mr. McGowan with Colorado OG Society is ready to go.
Okay, well, let's do that then, and we'll keep rolling here and see how far we can get lunch.
We're promoting people right now.
All right, good afternoon. Can you hear me?
We can hear you, Mr. McGowan. If everyone that you need is elevated, you're welcome to begin.
We are. All right. Thank you, Mr. Chair. It's good to see you all again, and we will, as Miss Janet noted, we only have 6 minutes. We'll be brief, and we have a closing statement. So we'll try to knock this out to keep moving. Good afternoon, and hello again. And Commissioners, my name is Chris McGowan. Again, I represent the OG Society. We are a group of mid and small family legacy operators here in Colorado. We wanted to come back again today to use our time to provide our closing arguments regarding the cumulative impact rulemaking. And again, we will note we appreciate your diligence. We know this is time consuming, and we know these are always difficult and a challenge to bring all the parties together and make everyone happy. So we appreciate your efforts and endeavors in this matter. Today in our closing statement, we would just like to reiterate some key points that we believe are relevant to your discussion and the final rules overall. To begin, we would like to acknowledge some progress that has been made. We do agree with the sentiments of our other industry partners that have previously testified about the positive aspect of the newer August draft rules. We believe their comments more than adequately reflected our agreement with the positive changes, such as striking certain provisions, limiting others, and allowing for a better tailored set of rules that was more narrowly tailored to achieve the desired results. We think this is a reasonable and appropriate step forward towards getting a set of rules that are more appropriate and aligned with the statutory intent and spirit of the law. As highlighted in the presentations by industry partners, specifically those operators who are still developing oil and gas wells in the state, we believe that there are still outstanding concerns or issues that do need to be addressed. We believe that it is always of best interest to listen to those in the regulated community who are telling the commission what is and what is not possible to implement, or what is reasonable for that matter. We believe those operators that are developing oil and gas still in Colorado accurately reflected many points on the amendments to the rules as a whole that would benefit the industry at large. We would note that we do not necessarily agree with every position taken or stated, and we would note that our operators oftentimes do have different needs, interests, wants, or limitations than other operators of larger or mid-sized operations. However, we are also realistic that we would prefer the commission to focus on the larger scale, outstanding big ticket items as they were remaining, and focus on those issues and resolution of those outstanding problems rather than focus on just smaller issues that may not provide as large of a benefit to the industry at large. In other words, we too, our members too, want to find a reasonable solution that allows everyone to develop, not just certain operators. Again, we will not reiterate each of the previous points made that we do agree with or don't disagree with necessarily, as that would be redundant and we are not here to waste the commission's time. However, we would again reiterate that we do believe the most recent narrowed version should be the baseline with which any rules are developed, and with any expansion needing justification why it is necessary or reasonable, and justification as to why the proposed expansion of a rule is a reasonable approach in addressing that particular pressing issue. To be clear, to answer a question that was posed during our presentation, we do not believe the commission is prohibited outright from implementing rules. We believe there's a statutory mandate. Rather, we simply believe that the rules that are made must be appropriate and strike an appropriate balance, taking into consideration not only the authority granted, but the restrictions on that authority already contained in statute, along with previously adopted rules and the outcomes that those rules have provided as articulated by this commission. Operators spoke to many issues covering setbacks, reporting, cumulative impacts reporting, permit timing and approval, standards by which permits are reviewed, and more. Each of these areas of the rules are, according to the commission's own words, the most strident in the country, and they were imposed for the health, safety, and welfare of the community and wildlife resources. Therefore, we believe that before expanding on those areas, as requested by many of the other parties to open this rulemaking and the proponents as they were, we believe any expansion would need to be done and in a manner that's justified, necessary, and reasonable. One way to put it is if the proposed rules were not necessary and reasonable previously or in previous rulemakings, for example, what has gotten worse or what problem has arisen that makes them necessary and reasonable now? Specifically, we believe harm would need to be better identified before expanding the rules in any fashion. The term necessary as a factual and legal context means something that is required or justified, but also would imply that something is lacking. In other words, we again would encourage the commission to first evaluate what rulemakings have previously been undertaken and have been successful, which over 5 years has covered again a half dozen agencies in every single rule series in the ECMC Code of Regulations. What subjects were those? What subjects have previous rulemakings addressed, and what results have been achieved? Indeed, perhaps one approach to this rulemaking would be to focus more on the data collection regarding what has already been implemented, as opposed to looking for reasons or ways to expand the rules that are already in place without the showing of data that represents the needs to be done to protect public health. Again, for example, we acknowledge air quality issues exist. We acknowledge that oil and gas does contribute in some fashion to those issues. However, important context is needed, again, which is our point. For example, oil and gas is but one of many sources, including transportation, other industries, and a host of other sources that have been identified in multiple studies, all of which oil and gas cannot, all of these additional ancillary emission sources of which oil and gas cannot control and should not be held liable for. Further, we believe it is important to note that the oil and gas industry has consistently reduced in one fashion or another its overall emissions. Additionally, we believe there is important context surrounding certain proposals, and some proposals fail to acknowledge certain realities. By way of one example, a lot of focus has been placed on certain parties on the mandatory electrification of drill rigs. This is allegedly one way that operators can reduce emissions. According to a review of available sources, the Colorado inland rig count was approximately 15 as of March of 2024, a decrease from 20 a year earlier, which is a 6.2% decrease from the previous week in March, and more importantly, a 25% decrease from the previous year. In 2022, according to the EIA, the total net electricity generation in Colorado was 4,344,000 megawatt hours, 29.5% of which was generated by natural gas and 17.9% of which was generated by coal. Colorado consumed 5,000 barrels of petroleum, 9.9 million cubic feet of natural gas, and 482,000 short tons of coal for electric generation. The point being is that electrifying all drilling rigs may induce emissions directly from the rigs on site during drilling, but has any consideration been given to an additional power requirement that results from all electrification? In other words, the majority of Colorado's electricity still comes from natural gas and still in a measurable percentage coal. Thus, does electrification, each drill rig represents approximately 300 to 500 kilowatt hours per day of use, or 100,000 per day of use. Really, does a full electrification ultimately really provide benefits that are being alleged? In other words, does it reduce all air emissions, or are we just simply reshuffling them around? Likely not. And this is but one example of the context that is often lacking when rules and their alleged solutions are being discussed. This is also true of the parties that we believe would be wise or pertinent to test the legal boundaries of the commission's authority. We believe, as do others, that the commission's proposed rules present certain issues regarding the development of a set of rules that goes beyond the authority and intent of the statutory words and intent. In other words, we believe this could pose a significant conflict whereby there are conflicting permit structures, enforcement, or other significant ambiguities existing in the rules. In other words, the outcome would be a set of rules that are not in alignment with certain statutory provisions, including possibly the Colorado APA. For example, one area we would hope the commission revisits.
Mr. McGowan, your time is exhausted.
Oh, that's fine. Sorry, I did not, no, apologies. I was pretty much done anyway.
It's okay. I'm gonna let you finish. I just wanted to acknowledge that now you're on my time instead of your time so that you can finish your last few sentences here.
I appreciate that, Commissioner. Apologize, I have literally a few sentences less. Basically, please apply the considerations we've listed as we've discussed to other proposals by the opponents of the industry. Please deny the request for expanding setbacks, imposing broader informed consent, or other expansions requested during the opening stages of this rulemaking. DICs need to have a community to consider further protections as necessary. Just a broad application of rules with no data showing direct impacts is neither necessary and reasonable. We appreciate your time and hard work on this matter, and we hope that we get a set of rules that considers all relevant factors, data, and consideration. And we believe that will be the final result. Thank you.
Thank you, Mr. McGowan. Commissioners, are there questions? Mr. McGowan, I don't see any questions, so thank you for your thoughts and your presentation.
Appreciate it. Thank you very much, Commissioners. Best of luck.
Thanks. Ms. Jacobs, I think we have Laramie Energy up for a couple of minutes next, and I think it looks like we should be able to squeeze them in before 12:15. Am I correct there?
That's correct. Laramie Energy, Cirrus, Piance, and Fielding Hill. They have 2 minutes and 45 seconds. We'll start getting those folks promoted.
Thanks. Ms. Hill, feel free to start whenever you've got the folks here that you need to start.
Looks like we're all here except for Chris Clark and Katie Middleton. I can give comments though while they elevate them if you'd like.
I think that'd be great.
Okay. Good afternoon, commissioners. I'm Holly Hill with Fielding Hill, and I'm here advocating for Karis and Laramie, who both fully endorse Tara's position and red lines for the impact area. The parties also fully support the recommendation CDPAG made regarding considerations for disproportionately impacted communities. Furthermore, the parties request that the commission consider reinstating the current alternative location analysis rules, by which an operator is able, if an operator is able to obtain a NEPA documentation, they can provide that at the OGDP stage. Lastly, the parties request that the commissions reconsider reinstating the June 14th draft for Rule 311, which offers immediate relief for both Karis and Laramie in their permitting efforts. And if that cannot be achieved, the parties are requesting that the considerations in Rule 311 be discussed after the Produced Water Consortium rulemakings. And that concludes my statements. And then we've got Katie Middleton and Doug Dennison. I don't see Chris here for questions if we have any.
It looked like Mr. Clark declined his invitation to be elevated, but certainly if Ms. Jacobs, if you want to send it to him again, maybe he hit the wrong button. Commissioners, are there questions for this presenter? Mr. Cross or Commissioner Cross?
Thank you, Chair. I just want to try and see if you want to expand any on TEP's topographical proposal.
Yes, we've been emailing back and forth on that, and we kicked around some footage elevation differences, but we've ultimately landed on let us as the operators prove that to you, to the commission. And the first step in tackling such relief would be the pre-application consultation. So we'd have the community liaison, we'd have CDPHE, we'd have CPW, we would likely have BLM if we're on federal lands. And at that stage, we can kind of discuss what our thoughts are on that topographical relief to see if they would agree or if they have any concerns. So then we kind of have a good idea of what we're going to be bringing before the commission when we seek OGDP approval.
And I guess with respect to the impact area, can you explain a little bit the topography issues with assessing the impact area?
Yeah, so a lot of times operators are avoiding some of the ridges that are out there on the Piceance Basin, and they're in the valleys. So you've got these basically larger plateaus that are protecting the oil and gas location from any sort of sound impacts nearby. A lot of the siting that West Slope operators are doing are not near residential homes. That's a pretty rare instance. And most of the lighting and noise and odor plans we're putting together right now are not showing many impacts past 2,000 feet. So we think that the half mile makes a lot of sense in being able to assess impacts to wildlife and any sort of resources or receptors that would be at that point.
Thank you. I think those are my only questions.
Other commissioners with questions? I've got one question, and this is just so I better understand your perspective on the topographical piece, and understand that some locations are sited in valleys, and there are some that are up on ridges. And is there a consideration as you're evaluating the potential topographical considerations of impact areas that if it is on a ridge, it may actually need to expand because it may have more impacts than if it was in a geographic area that maybe was more confined by those ridges? Does that make sense?
Certainly. So you're saying if we're up kind of on those ridges, we'd need to consider a larger impact area to assess because.
I'm asking the question.
Yeah, I think that's a fair question. And I think that's a fair ask. When you're not going to be protected by those walls of the natural topography, I think it's a fair ask to have to assess a larger extent.
Any other questions? Well, thanks for your presentation and the information that you've provided. And if you've got any red lines that you'd like to submit, we are always open to those.
Great, thank you so much.
So commissioners, I suggest we take a lunch break till 1 o'clock. And I think that, is that the right time, Ms. Jacobs, that was requested, is to take the lunch break until 1? Is that when Chair Robbins thinks he'll be able to return?
I believe that, yeah, Chair Robbins had recommended lunch until 1 o'clock.
Okay. Well, let's do that, and we'll see everyone back here at 1. AG Davenport, did you have a comment?
Apologies, Mr. Chair. I just wanted to confirm that I did speak to Chair Robbins, and he did request until 1 o'clock for a lunch break.
Great. Well, we'll see everyone then at 1 o'clock.
All right, welcome back, folks. This is the Energy and Carbon Management Commission, docket 24406000145, or whatever the docket is that involves cumulative impacts and enhanced systems and practices. I believe we're starting off the afternoon with rebuttal closing from Civitas. You are recognized.
Thank you, commissioners. I just want to confirm that we have all of our team elevated.
I see Nathan Bennett and Kathy Stearman. Anybody else?
We should also have Lila Hubbard. She's available only by phone right now.
Ms. Hubbard, if you could raise your hand, the hearings officer will recognize your phone number.
I don't see Lila Hubbard or a phone number in the attendee list, but we will keep an eye out and make sure that she's available.
Okay, thank you. Good afternoon. I'm Mike Smith, a shareholder with Brownstein Hyatt Farber Schreck, appearing on behalf of Civitas Resources. With me are Nathan Bennett, Civitas Director of Permitting and Compliance, Kathy Stearman, Civitas Director of Air Programs, and Lila Hubbard, Civitas Natural Resource Specialist. To begin, Civitas would like to confirm its support for the industry proposed red line submitted to the Commission on Tuesday of this week. Civitas believes that the proximity factor of 1/2 mile proposed by industry further strengthens the proposed protections for DICs. We encourage the Commission to adopt the industry red line. Civitas would also like to note to you its support for a proposal regarding Form 2D, which Oxy will be presenting as well. Civitas appreciated the Commission's encouragement for the parties to engage in discussions to explore potential areas of compromise. And in fact, Civitas engaged over the recess with parties on several issues. Of note, Civitas spoke with the allied local governments regarding its CAP proposals and the wildlife hunting and angling groups regarding its thoughts on the Colorado Natural Heritage Program's Codex tool and other issues. While unfortunately we will not be able to support the allied local government's position regarding expansion of the Form 2F and Form 2B light concept, we appreciate their concerns and believe that they will be addressed by the rules proposed by staff with the new Form 2F and the cumulative impacts analysis that's required of all OGDPs. We're also committed to continuing the discussion with the allied local governments. With respect to the wildlife hunting and angling group's proposals, we believe its suggestions to create specific biological resource lists that would trigger consultation make sense. We also generally believe that the biological resources could be mapped and or identified like high priority habitat and addressed by EMC and CPW in a similar fashion as high priority habitat. We look forward to workshopping the wildlife hunting and angling group's ideas and suggestions for consultation lists and uniform data practices, including the use of the most sensitive potential areas of concern in a later stakeholder process surrounding biological resources. We also continue to agree with staff's red line comments to its August 2nd rules, explaining that biological resource issues will be informed by CPW's expanded mandate in House Bill 24-1117. In that bill, legislature identified a lack of data regarding biological resources and tasked CPW with studying rare plants and invertebrates to determine appropriate conservation and management measures that will ensure the ability of these species to perpetuate themselves. We think this information will be valuable and the CPW is better positioned than ECMC to be making policy decisions about biological resources. We also want to note that it's not as though the can is entirely kicked down the road. Throughout the OGDP and CAP cumulative impact requirements, the rules require operators to provide key terrestrial habitat types where their oil and gas location is proposed based on the habitat types identified in Table 4 of the 2015 State Wildlife Action Plan. These are new requirements, which Civitas supports. Civitas also supports the prompt reconvening of a biological resources working group. Now moving on to Civitas's rebuttal presentation, we'll address two narrow areas. First, the definition of industrial resources, and second, Rule 316's enhanced systems and practices. Civitas supported COGA's opening position that the definition of industrial facilities is too broad in violation of the APA. Staff's definition circularly defined industrial facilities to mean, quote, a facility that conducts industrial or manufacturing operations, end quote. But it didn't define either industrial or manufacturing operations. COGA supported defining an industrial facility as meaning, quote, a stationary source facility for which emissions and or water discharge permits are required by the state. A facility is an industrial facility only if its permits are available on a publicly maintained website with search functionality, end quote. Commissioner Oath asked some thoughtful questions about whether this definition might still leave room for ambiguity, as there are many types of air and water permits. In response to questions from Commissioner Oath, Civitas has workshopped a new definition that would specify exactly what qualifies as an industrial facility. The definition on this slide, providing that an industrial facility means any source of emissions mapped by CDPHE tool available and requiring a permit from CDPHE or use requiring an industrial stormwater or commerce and industry water discharge permit from CDPHE and available at the CDPHE tool available at, and I omitted from my description the hyperlinks included on the slide. This definition satisfies the APA and provides operators, ECMC staff, the commission, and stakeholders transparency to know what qualifies as an industrial facility. And just one note, we did include the exact URLs definitions or URLs in this definition. So when you go back, you can understand what these are referring to, but we understand and appreciate ECMC's preference not to mention specific URLs in case they change, requiring modification of subsequent rulemaking proceeding. This definition could just as easily say tools available on CDPHE websites, and that would be acceptable to Civitas. The second topic we'd like to address today is enhanced systems and practices. To be sure, sorry. Mr. Bennett testified during Civitas's opening that the ESPs in Rule 316 C4A 1 through 4 would be unreasonable regulations because they are infeasible and carry unintended consequences. And you heard Koga also testify the same. Civitas wishes to just reiterate Koga's position on this. It's true Civitas does operate some locations that are tankless and constructs facilities to be tankless or have as few tanks as needed for safety and oil pipeline takeaway capacity where possible. Civitas believes these practices should be encouraged by the commission, but not be mandatory. And we also heard this week that CDPHE agrees with that position due to several feasibility issues. In the course of this hearing, you've heard from only one company that suggests that all 4 requirements might be feasible, but even then, that company requested that the start date for ESPs be delayed. You've also heard from one company that testified, similar to Civitas, that a produced water tank prohibition would be infeasible. Civitas spoke with unrepresented peer companies who advised Civitas that it agreed with Civitas's position that the 4 requirements should not be mandatory. It's important to acknowledge that oil and gas companies necessarily operate where they own minerals, including ownership through leasehold. The location of the minerals dictates where operations are possible. And if the minerals are located in areas where there's not a pipeline infrastructure or midstream company that's both capable and willing to connect, the companies owning minerals in those locations simply cannot use pipelines. Some companies have acreage positions that lend themselves to pipelines and or they own midstream companies, so they don't have to worry about whether they can secure a third-party gatherer. That's simply not the case for every or indeed most Colorado companies. Mr. Bennett also testified to the many reasons why renewable or grid power is not practical for all permanent production equipment. As he noted, both solar and wind power are intermittent, but oil and gas operations are not. Moreover, regardless of the renewable technology employed, substantial surface disturbance is required for power generation and storage. For example, a solar array sized to power an oil and gas location could add an additional 8 acres of surface disturbance to an oil and gas location. It's important to stress that storage, usually with large batteries, is a requirement given the intermittent nature of renewable power generation relative to the constant need for power at an oil and gas facility. Additionally, the footprint necessary to site the batteries is not included in the previous example, so sites could grow by even more than 8 acres. This all indicates that ESPs are not just infeasible in some cases, they can be counterproductive. I also want to point out 2 legal issues with requiring ESPs, given the challenges I just mentioned and that you heard about last week from Mr. Bennett. First, none of the recently passed legislation has unwound the requirement under the Oil and Gas Conservation Act that regulations be reasonable. Section 34-60-106 2.5a of the Colorado Revised Statute states, in exercising the authority granted by this article, the commission shall regulate oil and gas operations in a reasonable manner. I submit to you that it is unreasonable to adopt rules with which compliance is impossible. Second, the rules violate the APA. The state APA provides that rules which are impossible to comply with are arbitrary and capricious and run afoul of the APA. Courts have held that it is arbitrary and capricious to require compliance with a regulation when compliance is impossible. Based on both the practical and legal issues associated with ESPs, Civitas respectfully requests that the Commission strike Rule 316 C4A 1 through 4. Thank you. And with that, we'd be happy to take any questions.
All right, the panel is before us for questions, commissioners. Commissioner Cross?
Thank you, Mr. Chair, and thank you for this additional information. I think the first thing I want to touch on is the very last point you made, Mr. Smith, and that's looking at striking those ESPs. Do you want to strike the idea of the ESPs or just the mandatory nature of the ESPs?
I think the mandatory nature of them, and thank you for the clarification. The mandatory nature, Civitas agrees that ESPs can be helpful and they are utilized in some cases, but they cannot be required in all cases.
Okay. And going into a little detail on a couple of the ESPs that were specifically talked about. One was going into the use of tanks if they don't have their own pipeline, their own midstream capabilities. And I brought this up briefly in the opening statements, and it was raised again by CDPHE, by Ms. Sorensen yesterday. And so I wanted to try and touch on as well the use of pressure vessels as part of that stabilization process. And so perhaps, Mr. Bennett, this might be a question best geared towards you, but could you go into a little more detail on some of the pressure vessel versus tanks issue on that?
Thank you, Commissioner Cross. Appreciate the opportunity to follow up on previous testimony. Simply, while pressure vessels could be used in lieu of tanks when an oil gathering pipeline system services a location, deploying this concept is far more complicated than just switching one for another. Simply stated, without tanks, stabilization has to be achieved elsewhere in the process in a non-high vapor pressure gathering system. There are a number of different ways to accomplish this. For example, higher temperatures on your treaters. However, that may introduce other variables that need to be addressed and require additional equipment to be incorporated into an operator's on-pad operations. The bigger challenge with using pressure vessels in lieu of tanks is the absence of hydrocarbon storage. In those instances, when a pipeline has an upset condition, for example, pressure issues, oil spec issues, etc., when that pipeline is taken down for maintenance, or when that pipeline is behind schedule from a new build or gathering system connection standpoint. In those instances, the only option would be to shut the facility in, which has myriad complications of its own. And so that's a way of me agreeing with Ms. Sorensen's testimony that a pressure vessel can be used in lieu of a conventional hydrocarbon storage tank. However, the facts and, more importantly, I guess, the operational requirements to do that are far more complicated, as I stated, than just switching one for the other.
Okay, that's helpful. And I guess building on the idea of kind of the ESPs overall, I guess I'm curious to know Civitas's position. You know, as we heard from Green Latinos yesterday, they were fine with some proximity approaches with respect to some of the procedural aspects that have been discussed. But when it came to some of the more substantive, like the ESPs, they were still wanting to try and apply that in DICs overall. I was wondering if you could address some of the issues as you think with respect to that approach, the substantive protections versus the procedural protections.
Appreciate the question, Commissioner Cross. And if I understand it correctly, as we indicated in our initial testimony or case in chief last week, incorporating ESPs is not just as simple as saying, hey, we're going to connect this location with a pipeline, correct? Regardless of where that location is. As we kind of work through the process and the legal requirements necessary to obtain a pipeline right away, oftentimes it's extremely difficult, as you've heard us testify and others as well, including CDPHE. And so while we endeavor to use whatever best practices we have at hand wherever we operate, there are instances where things are just not feasible from a community standpoint, from a landowner standpoint, and in many instances, or maybe I should say some instances, an operational standpoint as well. So I'll ask Ms. Stearman if she has anything to add to that, and I do apologize if I misunderstood the nature of your question.
Nothing to add, Mr. Bennett, except for that there are other things that Civitas is always willing to do outside of the ESPs. That's why, you know, some best practices are always important to us. Whatever we can do to affect the tanks in a different way, those are always on the table for us.
And then I think my last question, again, goes to some of the prior submissions that have come in, especially given where a lot of Civitas's assets are, primarily are assets near Adams County or in Adams County. I was hoping to understand if, one, you spoke with Mr. Dean from Adams County about some of their recent proposals, and two, if you had thoughts on either kind of his initial proposal of some of the, we'll call it the tiered approach to the informed consent, or the one that was discussed yesterday with the kind of the informed consent with respect to the ESPs.
Again, appreciate the question, Commissioner Cross. Admittedly, I have not had the opportunity to talk with Mr. Dean following his testimony and red line submittal yesterday. I was able to catch his testimony, and his concepts are interesting, but we have not had the time to apply those concepts to, you know, future theoretical projects that we may have in and around Adams County, for example. And so I think it's premature for me to comment on, you know, the application of what he is proposing. I will ask Mr. Smith to offer any commentary should he have any as well.
Yeah, thanks, Mr. Bennett. The only other thing I would add is, you know, one concern is, you know, requiring ESPs if an operator is unable to get informed consent is, I think, a poor substitute for the current substantial equivalence provision. As industry has stated and CDPH agrees, the ESP should not be mandatory. But Adams County's proposal appears to effectively make them mandatory because of the significant challenges in obtaining informed consent. I think Mr. Dean himself had acknowledged that informed consent is virtually impossible for any type of project. So for that reason alone, I think it's quite concerning, but I think we do appreciate the problem solving and appreciate the conferral.
Thank you. I believe those are my only questions.
Other questions, Commissioner Oath?
Thanks. Just a question on the industrial facility. Thank you for taking another look at that and the new proposal. Just because I'm not able to follow the URL now, I think I understand what you're getting at with the water reference. But for the air permit reference, could you just explain, are those major source permits, or what is that referring to?
Thank you, Commissioner Oath. I think I can take that. It was our attempt to try to use some sort of a geospatial ability to search. And I know the APCDs had a variety of revisions of the kind of APN applicable air source publications in the past. We're not married to this. If there's something that would come out that's a little bit more searchable or a little bit more relevant to the pollutants that we want to search on, we're open to that. But the link that's in there, if you follow it, you'll see it at least allows you to look at it from like a map structure as opposed to trying to dig through by AIRS IDs and go that route.
Okay. I will see what I can find out. Thanks.
Other questions for the panel? Commissioner Shea?
Yeah, thanks. Mr. Commissioner Cross touched on this question. It's regarding the additional enhanced systems and practices slide that y'all had. If you want to go back to it, you can. And I think my question is for Mr. Bennett, because I just wanted to get a little more detail on pressure vessels. And I understand your point in the very beginning where you talk about, not using pressure vessels or mandating them when pipeline takeaway is not there. But I guess I just want to understand a little bit more. And then you talk a little bit about tanks facilitate liquid stabilization. And I was just curious, like, if stabilization can be done on site, do you have any opinions on using pressure vessels instead of atmospheric storage tanks?
Thank you for the question, Commissioner Shea. I certainly appreciate the perspective that you bring, and not only the merit of your question. Admittedly, I don't necessarily have an answer to your question. I know it's a conversation we've had with our facilities teams as to what our options are as it relates to tanks, or the concept that tanks may no longer be permissible in certain constructs. And as I mentioned in my testimony today, they have indicated that it is potentially possible to utilize a pressure vessel. But our concern is, how many pressure vessels, if you will, would be needed to take the place of an atmospheric tank where you get the residence time you need before producing into a dead oil pipeline. And that's something that arguably will vary by geographic location, will vary by our operating parameters, not only of the wells that would potentially be subject to that, but potentially existing wells on that same location. How do you marry those systems together with a common, endpoint, that being a third-party midstream system? And so I think over time, we will continue to refine our understanding of what our needs are from a facility basis as infrastructure continues to be constructed within the basin and provide additional opportunities for takeaway in various locations.
Okay, that's helpful. Thank you. And I know you say in here there's safety concerns during upset conditions. Can you just expand on that a little bit for me?
Certainly, and appreciate the follow-up question. So safety concerns are wrapped up in a couple of different buckets, one of which obviously is operational safety. If your location is shut in immediately, based on automation and those parameters that you would set for your operating conditions, what those tolerances are, and you do not have the opportunity to continue to produce into a tank and really step that production down. There are some things that arguably could pressure up your equipment, result in a form of, I'll call it a water hammer. Well, in this case, it might be an oil hammer or some form of a pressure hammer, quote unquote, that could, push, in some instances, the limits of your technology from an integrity standpoint. And so eliminating the best we can, or engineering out a kind of a very unique event like that is of utmost priority for us and industry as a whole. We want to ensure that our facilities continue to operate safely and are designed to handle instantaneous changes in flowing conditions, et cetera. One of the other concerns that we have in the event that a location is not tankless and has to be shut in when your pipeline, or when the pipeline is in an upset condition, is restoring production of those wells after some form of a shut-in time, right? So although, as we've heard and will continue to hear, that the DJ Basin is not a water-heavy basin relative to other producing basins in the state, wells do load up with fluid if they're shut in. And once that well is loaded up with fluid, as you know, to reestablish production, you need to unload those liquids, which at times comes with an emissions piece as well. When you're talking about swabbing or other forms of operations to remove that hydrostatic column from the wellbore. And so by having the ability to continue to produce into a tank during an upset condition, you avoid, in theory, the need for workover operations or other methodologies that may be necessary to restore production after some form of a shut-in time.
Okay. So would something like temporary tanks be able to solve a little bit of that, to have, you know, tanks on site that aren't used, that are atmospheric, that aren't used day to day, but they could be there for those upset or emergency type conditions.
Appreciate the follow-up question, Commissioner Shea, and that certainly is an option. At the end of the day, that sort of equipment would still need to be included in your Form 2A and your equipment counts and the various plans associated with OGDPs, and could occupy, space, if you will, that might be utilized for something else. And so rather than have a permanent tank on location that's not being used or would be used periodically during certain types of operational upsets, it's still a preference to produce into those dedicated liquid hydrocarbon storage tanks rather than have them as the kind of the exception.
Okay, that's helpful. Thank you.
Other questions for the panel? Commissioner Ackerman?
Thank you. Most of mine also have been touched on, but I just have one follow-up associated with Commissioner Oath's question as well. And I understood, Ms. Stearman, the kind of the methodology that you employed, but and we will hopefully get a chance to take a look at those links. But for us and the folks that are listening, it's tough to kind of evaluate on the fly what you're talking about there. Can you summarize or give us some idea of the framework that sets for industrial facilities? Give us some examples of what those industrial facilities would be under that listing.
Yeah, thank you, Commissioner. To answer that, what we'd be looking at are stationary air sources that have either an air pollution emission notice filed or an air permit. They would be covering priority pollutants like PM 2.5, PM 10, and NOx and VOCs as ozone precursors. Those are the air analytes that we permit. And so that would allow us to have some sort of at least a spatial, because we don't know the impact area yet. We're trying to determine how are we going to actually go get this data. And I think that's our biggest concern right now. Obviously, we're not going to be driving in circles. We have to have a place to kind of go look for this. But it relates very heavily to how we look at air sources specifically. And this is something that we've been using for kind of like local sources for years through the APCD.
Thank you. That's very helpful. And then how does that correlate with CDPHE, who doesn't define industrial facility, but does define industrial waste? Do those generally line up with those facilities that are classified by CDPHE as having industrial waste?
I don't know if I can answer the industrial waste question, Nathan or Mike. Do you guys have anything to add?
Commissioner Ackerman, thank you for the question. The only thing I might add before Mr. Smith may have some commentary is based on my interpretation, and perhaps this is incorrect, Commissioner Oath can keep me honest here, is I would argue that an industrial facility or the types of permits that you would see at these various tools that CDPHE maintains do not necessarily create, quote, industrial waste, end quote, as I understand the definition to be.
Thank you. I appreciate that and agree. And so we'd be talking about kind of a category that has not yet been defined and trying to redefine, or not redefine, but this is an attempt to kind of slim down the definition that's been proposed in regulation to something that's identifiable via a CDPHE source, correct?
Appreciate the follow-up. And I may hope to answer your question with what I'm about to say. I would suggest that our definition of industrial facility, proposed definition as it appears on this slide, is actually perhaps more broad than if it was focused on, quote, industrial waste, end quote. Based on some of the nuances that Ms. Stearman mentioned in her earlier response.
Thank you. Appreciate that. And my question was associated with the industrial facilities definition currently proposed in the regulation, as opposed to industrial waste.
Understood. And my apologies for confusion. We believe that the currently proposed definition of industrial facility is too ambiguous to really identify or allow us to focus on the types of facilities that we believe should be incorporated into the rule under this definition.
Thank you. I appreciate that discussion. And just one last clarification. Based on the current proposed definition in the regulations for industrial facility, you're not making the assertion that this would be a broader definition than that, if I understand correctly.
Thank you, Commissioner. I think that's a fair characterization. I think this definition is more refined perhaps than what is currently proposed in staff's August draft.
Thank you. Thank you, Mr. Chair. Nothing further.
Great. Commissioner Messner?
Thank you. This is a question for Mr. Smith, and I'm trying to get my head around I guess the pushback on enhanced systems and practices, and I think what Civitas expects this commission to do in this rulemaking, as at least in my reading, we're clearly directed by statute to require enhanced systems and practices to avoid, minimize, and mitigate emissions of ozone precursors from operators at newly permitted oil and gas locations in the 8-hour ozone control area in northern Weld County. And it's not try to do it or consider doing it or may do it. We're required to do that. And there has to be some certainty in the enhanced systems and practices that get developed. And so how does that, at least in my interpretation, mandate tie together with your desire to have flexibility in the enhanced systems and practices, I guess?
Yeah, thanks, Commissioner Messner, for the question. It's a good one. Just to clarify, Civitas does not oppose enhanced systems and practices, just object to them being mandatory based on the significant challenges, practical challenges associated with them. And we heard not just from Civitas, but other operators as well as CDPHE itself as to how challenging these are and how they cannot be utilized in all cases. So again, we would submit that they can be beneficial, and we recognize that they're they may be a tool, but the mandatory nature of it is problematic.
Okay. I'm having a hard time still tying that together with this requirement that some level of certainty happens within the enhanced systems and practices, and that there has to be kind of a more certainty than we'll consider, right? And so, I mean, open to any other thoughts on that, but I will continue to struggle with that. So I just put it out there.
Yeah, I'm not sure we could offer specific regulatory revisions at this time off the cuff to address it, but defer to Mr. Bennett if he has any other thoughts on the ESPs.
Thank you, Mr. Smith and Commissioner Messner. Appreciate the question. I'll keep my remarks extremely brief. In perhaps the context in which I'm about to frame what I am going to say does not address your question head on, so I'll apologize in advance. But in short, if there is a target, whatever that target may be, and for the sake of argument, let's just say NOx reduction, and I'll ask Ms. Stearman to chime in if necessary. Rather than subscribing or requiring, mandating certain things to happen, we believe that an operator can accomplish those reductions through things other than X, Y, and Z, right? And so that the technology is ever changing, ever developing, ever evolving. And rather than mandate something that may not work in every situation, we believe it's better to encourage those things and allow us to meet those goals through any combination of best available technologies that are out there.
Okay, well, I appreciate the response. I still think in this particular one, there is a mandate for enhanced systems and practices. I think that could be looked at a lot of different ways, and I'll continue to think about that. Thank you.
Further questions for the panel? All right, I'm not seeing further questions. We thank the panel for their presentation and the information they provided to us in this important rulemaking. Commissioners, up next is Koga with a pretty big panel. Let's give them 5 minutes to get impaneled, and we'll return at 1:41. All right, welcome back. Colorado Energy and Carbon Management Commission. It is 1:41 on Thursday the 19th, and we are taking the final closing and rebuttal comments and the cumulative impacts and enhanced systems and practices rulemaking. On the deck now is the Colorado Oil and Gas Association and the American Petroleum Institute for Colorado. The video is yours.
Thank you, Chair Robbins. Good morning or good afternoon, everyone. My name is Mark Matthews. I'm a shareholder at Brownstein Hyatt. Koga and API appreciate the opportunity to present to you this morning, and we join with other stakeholders in applauding your diligence, patience, and attention to detail during this rulemaking. In terms of our presentation, I will first be discussing some of the testimony you have heard over the past couple of days regarding Draft Rule 604C and several proposals alleging to make this rule more palatable by replacing it. Jim Martin of API will then introduce Dr. Tammy McMullen, who will address air impact studies and monitoring data since the mission change rulemaking and some of the testimony you've heard over the last couple of days. Mr. Martin will then discuss issues related to the appropriate impact area. Christy Woodward will then discuss ESPs, and Chris Koklischer will conclude our remarks by discussing certain NOx issues and is available to discuss related air issues during questioning. I will start by discussing prior draft rule 604C in the context of recent legislation. I've listened carefully over the past couple of days and haven't heard anyone question the arguments we made in our opening remarks that the legislature demonstrated its distaste for a siting ban on oil and gas activity within a DIC by not passing House Bill 241330. As you know, this bill would have created a new ban on oil and gas wells within DICs and ozone non-attainment areas by precluding the issuance of a construction permit. Now, as Colorado Sierra Club stated yesterday, there may be several reasons why the General Assembly does not enact legislation, and for this reason, courts have appropriately held that drawing inferences from legislation that is not enacted is more speculative than drawing inferences from the legislative intent from bills that are enacted. That said, I do think some speculation is permissible here when the House bill banning oil and gas activities in DICs failed in committee the same week that the Senate bill taking the exact opposite approach to oil and gas activity in DICs was signed into law. Next slide, please. Oh, no, go back one. You got ahead of me. All that aside, no one should have any problem with our gleaning the intent of the legislature from the Senate bill that was enacted into law. And that bill, as we all know by now, requires that the commission shall administer this Article 60 to minimize adverse impacts to DICs that are negatively impacted by oil and gas operations. In the enactment of this bill, the legislature spoke clearly. The ECMC should examine applications on a case-by-case basis to determine in the first place whether a proposed oil and gas operation has potential adverse impacts on nearby residents in a DIC, and if the project does or is likely to have such impacts, ensure that the operator effectively minimizes those adverse impacts. This legislative mandate to the commission cannot be reconciled with prior draft rule 604C. By contrast to the Senate bill, the prior draft rule does not ask the commission to determine whether a proposed application has adverse effects on a nearby community in a DIC. It does not ask the commission to address how the operator can effectively minimize those adverse impacts. Indeed, the commission is taken out of the approval process altogether. The operator must either get unanimous informed consent or he cannot get approval for the project. I submit this is not what the legislature intended. Now, We have heard from some stakeholders that 604C isn't a ban because it only requires informed consent. But no one can deny that requiring unanimous informed consent of all owners and tenants within 2,000 feet of a working pad surface in a DIC would often act as a ban. Please switch the slide. As you've heard several times now, unanimous informed consent is often impossible to obtain. I won't go through all of the different reasons that informed consent may not be obtained. They're summarized on the slide. And Mr. Dean of Adams County, as you heard from Civitas yesterday, once again reiterated how difficult and often impossible it is to obtain informed consent. And as the oil and gas liaison of Adams County, I think he speaks with a lot of credibility on this issue. And perhaps recognizing the problems that they have with informed consent and making informed consent sole requirement, several stakeholders propose alternative permitting processes for operators who can't obtain informed consent. And while they offer proposals to essentially supplant the substantial equivalency test with some alternatives, those stakeholders suggest that it is the industry that is seeking to relitigate the mission change rulemaking by questioning the 2,000-foot setback and the substantial equivalency test. I want to be clear here that COGA, API, and the industry members are not seeking to change 604B4 or the substantial equivalence test. While we did think during the mission change rulemaking that the 2,000-foot presumptive setback was not warranted at that time, industry has learned to live with a provision. Indeed, after almost countless guidance memos, slow accretion of precedent, and numerous permitting process improvements over the past 5 years, industry, the ECMC, and indeed this commission have finally come to a period of relative stability after the sea change of SB 19181. And it's against this backdrop that certain stakeholders seek to substantially change the standards by which permits are denied and approved in this state. I will now address 3 proposals that we've heard for replacing the substantial equivalency test. First, some operators seek to cure the problems with requiring a 2,000-foot ban without informed consent by providing that the operator can obtain a variance. There are several points about these proposals I'd like to make. First, it's unreasonable and unnecessary to use the variance standard as the OGDP permitting criteria when there's no evidence in the record that the substantial equivalence standard is not working and does not adequately protect public health, safety, welfare, or the environment. Christy Woodward and Dr. McMullen testified during our opening presentation that this is simply not the case, and the commission has been successfully using the substantial equivalency test to approve locations within 2,000 feet of residence. Dr. McMullen will make the same point again today. Switch slides, please. Second, there's an incredibly high bar required by the variance provision to obtain approval. An applicant, excuse me, an applicant requesting a variance procedure pursuant to 502A will have to make a showing that, among other requirements, the requested variance is necessary to avoid an undue hardship. The undue hardship prong would require an operator to demonstrate that it would be prevented by a ban from a reasonable opportunity to develop the minerals without a variance. This is an inappropriate and incredibly hard demonstration for an operator to make in the context of seeking approval of an OGDP permit. Any application could be rejected under the standard based on the availability of virtually any alternative location. Questions should instead be whether the operator has offered sufficient protection for public safety, health, and welfare, and not whether this is the only possible location. Obtaining a variance also requires demonstration that there will be, quote, no net adverse impacts from the project. Next slide, please. The SBP mentions that in some cases, an operator could propose a variance even if there were adverse impacts, so long as these impacts were offset by some form of compensatory mitigation. I submit that the no net adverse impact is a very difficult standard to satisfy and completely unrealistic to apply to an OGDP application. The no net adverse standard was not employed as a test for OGDP applications in 604B4 during the mission change and should not be employed here. An adoption of that standard will ensure that the permit approvals slow to a trickle. The Oil and Gas Act requires that the Commission to regulate oil and gas operations in a reasonable manner to protect and minimize adverse impacts. Similarly, as we've seen, SB 24229 mandates that the Commission shall administer this Article 60 to minimize adverse impacts to DICs that are negatively impacted by oil and gas operations. The injunction in the Act and the Senate bill to this Commission is fundamentally different than a requirement that a project achieve no net impacts. The mitigation hierarchy baked into the Oil and Gas Act requires the minimization and mitigation of impacts that can't be avoided. The no net adverse impact standard does not employ the concepts of minimization and mitigation. Instead, it requires the avoidance of impacts and the complete offset of any adverse impacts that remain. That conflict, I believe, precludes the Commission from legally adopting the no net impact standard in light of the legislature's use of the minimum adverse impact standard in the Oil and Gas Act. And I think this is the same point raised by Assistant Attorney General Kyle Davenport yesterday. The second option offered by Earthworks requires all operators applying for a permit, whether inside or outside of a DIC, to demonstrate to the Commission that the proposed impacts from the proposed development will be equivalent or less than those from an identical oil and gas development 2,000 feet from all residential buildings. This option requires the determination of whether this standard is satisfied to be made by an independent expert selected by CDPHE and the community liaison. This proposal, therefore, divests the ECMC staff and director of any meaningful role in evaluating the substantial equivalency of an OGDP application. Under the current substantial equivalency test, ECMC staff are the experts who evaluate the operator proposals and whether it meets the substantial equivalency requirement. Handing that critical evaluation over to a third-party consultant ignores the expertise of the staff and eliminates the vital role that staff and director play in evaluating and recommending an OGDP to the Commission. Tellingly, this proposal also seeks to establish a standard for approval explicitly rejected by this Commission. This proposal defines the substantial equivalence that operators have to satisfy as demonstrating that, quote, potential impacts to all relevant resources are equivalent to or less than those from an identical oil and gas location 2,000 feet from all residential building units. This is an unrealistic standard and really akin in a lot of ways to the no net adverse impact standard we just discussed. And the Commission has recognized this. In the SBP for Rule 604, as you can see in the slide, the ECMC stated, by setting the substantial equivalence standard, the Commission did not intend to set a standard that requires the Commission to compare potential impacts of a proposed oil and gas location to an identical oil and gas location 2,000 feet from all RBUs. The SBP continues, such a standard may be unachievable and would elevate distance as the sole or predominant regulatory tool to protect and minimize adverse impacts. The Commission intends for its rules to set achievable standards, including Rule 604B4. Commission also does not intend to create a standard that elevates one method of protection over all other methods. Yet, just to sum up the Earthworks proposal, this is precisely the standard that Earthworks seeks to employ for all OGDP applications inside and outside of DICs. That is a standard the Commission has already recognized as potentially unachievable. Finally, I'd like to address Larimer County's proposal this morning. Next slide, please. Koga API and their industry members did not see this proposal until Mr. Sura's presentation. So we don't have collected thoughts on it. And this is no shade on Mr. Sura. I understand he drafted it last night. That said, we have put together some initial observations about Mr. Sura's proposal. First of all, it starts with a false premise that the Commission's rules do not protect public health, safety, welfare, and the environment, and that staff is not conducting a sufficient analysis of OGDPs. I submit that the Commission knows that this is not the case. Second, there is no mention of regulations and their application being reasonable and necessary. Mr. Sura's reworking of 604B does not use the words minimize adverse impacts or otherwise reference the necessary and reasonable standards. Third, as does the earthworks proposal I just discussed, the proposal divests the ECMC staff and director of any meaningful role in evaluating an OGDP application. ECMC staff and the Commission are the experts who evaluate operator proposals. And we've also heard, I think this morning, legal concerns expressed by AAAG Davenport as to whether the ECMC has statutory authority to have a third party do this review, and whether the ECMC has the authority to require operators to pay for an independent expert. Fourth, and most glaringly, the proposal's extensions of all ESPs, regardless of whether the location is within a non-attainment area or a DIC. Specifically, at least as I read the red line, Mr. Sura's proposal provides that operators will commit to all ESPs listed in Rule 316C, regardless of whether the location is within the non-attainment area or within a DIC. Now, again, I haven't had the chance to discuss this provision with operators, but at first blush, this seems to me a huge expansion of the requirements of Draft Rule 316C. As you just heard from Civitas, certain ESPs in the draft rules are objectionable to operators. At least they're being mandatory in all circumstances. Requiring every listed ESP in Rule 316, including those most stringent ones, outside the non-attainment area and outside of a DIC, I suspect is a non-starter from industry's perspective. And finally, I note on this that requiring ESPs for every OGDP across the state goes well beyond the mandate of Senate Bill 24229 that the ESPs apply to locations, quote, in the 8-hour ozone control area in northern Weld County. Finally, on Mr. Sura's proposal, I have limited experience with community benefit agreements, but I do know they are usually done on a very large scale for significant public projects rather than for smaller projects such as an oil and gas well pad. There is also the issue of who in the community will negotiate such an agreement and whether that person has to be selected or can self-volunteer. And it appears in the proposal that putting a CBA in place is mandatory for an operator to be able to develop its project. If that's the case, there are certainly lots of opportunities for outcomes bordering on blackmail. And in this respect, the CBA requirement appears to be tantamount to something similar to the requirement for 100% informed consent in prior draft Rule 604C. Finally, as articulated by AAG Kyle Davenport, there are at least a couple of legal issues related to the Commission's ability to mandate CBAs. So in sum, there are lots of questions regarding Mr. Sura's proposal, both legally and practically, that would need to be ironed out and given a lot more consideration before it can be adequately evaluated. Now, I know my presentation so far has been negative in terms of criticizing alternatives offered by other stakeholders. So I'd like to pivot now and focus on something more positive, namely the procedural protections given to residents and DICs under the current version of the draft rules. I submit that the draft rules provide substantial procedural protections for DIC and CIC communities above and beyond the already comprehensive existing rules. But I submit that this would be particularly the case given our recent settlement offer to Green Latinos. In that offer, we examined each of the procedural regulations identified by Green Latinos in its pre-filed written testimony I believe there were 11 such rules, and industry agreed in an effort to reach consensus to extend the proximity trigger, that is the distance from the working pad surface to the nearest residence, from 2,000 feet in the draft rules to one half mile. Unfortunately, our proposal was rejected by Green Latinos, and they countered with a proposal that looked very different. And while we're still talking to Green Latinos, I'm not optimistic that we'll be able to reach a settlement. But I am authorized by COGA, API, and their operator members to state that we would agree for our settlement proposal to Green Latinos to be incorporated into the new rules. This concession by operators would expand even further protections for residents in CICs and DICs in the draft rules. COGA filed a red line of our procedural changes with the Commission Tuesday morning, and we will attach our red line to our slide presentation submitted to the Commission. But in a nutshell, we focused, as I said, on 11 provisions in the draft rules chosen by Green Latinos. And for each of these, we proposed expanding the current proximity trigger of 2,000 feet to one half mile. And though the list on the two slides isn't exhaustive, these applicable regulations include 301G1A, expands the proximity trigger for when a community liaison can participate in the pre-application consultation. 301G2G, which expands the proximity trigger in which a 60-day public comment period for OGDPs will occur. Rule 304B2, which increases the amount of information the operator must provide in the Form 2A when the working pad surface is now one half mile from a resident within a DIC or anywhere in a CIC. Rule 304C19, which expands the proximity trigger for when residents will receive a consultation, outreach, and engagement plan and be included in that plan. Again, when the working pad surface is one half mile from a resident within a DIC or anywhere in a CIC. Switch slides, please. And Rule 304D5, which increases the proximity trigger or when the director may not grant an exemption for submittal of information required by Rule 304B. Rule 309C1 increases the area in which residential owners and tenants may participate in post-completeness consultation, and also expands the area in which CDPHE may consult. And finally, under Rules 314 and 315, our proposal expands the circumference and geographic area in which operators must describe potential impacts and measures it is taking to avoid, mitigate, and minimize impacts through the use of the EnviroScreen score. Again, these are procedural regulations identified by Green Latinos in their pre-filed written statement. Operators do not make these concessions to expand the proximity trigger lightly, but are willing to do so to ensure further protection for residents in DICs and CICs. I will now thank you for your time, and I'll now turn it over to Jim Martin.
Good afternoon, Chair Robbins, Commissioners. It's nice to see you again. For the record, Jim Martin from Beatty Wozniak, representing API Colorado here. My first job this afternoon is to introduce Dr. McMullen, who testified for us on direct. We've asked Dr. McMullen to respond to some of the information that's been presented to you on the subject of air emissions and health effects. And with that, I'm going to turn it over to Dr. McMullen.
Thank you, Mr. Martin. Thank you, Commissioners, for your time. Next slide, please. Thank you. So in terms of my rebuttal testimony, I'd first like to refresh your memory, Commissioners, since it's been several weeks, and your memory regarding my direct testimony conclusions, especially as they pertain to the scientific assessment of the body of what I believe is the relevant scientific public health data related primarily to air exposures of oil and gas operations, with a focus on the adequacy of the current setbacks to protect public health in the communities. As you can see here, I'm going to just refresh your memory on the five main statements, but Exposure data that we know of collected in communities near oil and gas development in Colorado have not been at levels of concern from an adverse health risk perspective. Health outcome studies are largely inconsistent, lack cohesiveness of findings, and were not designed to show any causal evidence specifically related to oil and gas health outcomes. Third, health studies from other states can be useful, but they've been primarily brought in, and we need to caution taking those and driving policy decisions as it relates to public health impacts here in Colorado. Relevant exposure data that we've continued to show over the last 7 years, and data that are collected with current regulations show that the cumulative risks of oil and gas related hazardous air pollutants are below levels that would pose health risks at the existing setback distance of 2,000 feet. And all of that data collectively combined demonstrates to us that as of now, based on the best available evidence, that current regulations and operator BMPs per ECMC regulations and Air Quality Control Commission regulations are not resulting in measured air exposures or levels of adverse health risks, and do not identify a health risk at the current setback of 2,000 feet. So that was the basis of what I stated in my main testimony. And today, next slide, please. Today, I just want to address several points that have been in the rebuttal statements of various parties, including the Physicians for Social Responsibility, Earthworks, Colorado 350, and Larimer County, in particular, Dr. Colette's testimony and rebuttal this morning. I will say that I've really appreciated the thoughtful discussions and the data that have been brought in to the conversation, and it's necessary that we look at all of that type of data when making considerations around public health impacts, particularly as it relates to setbacks and adequacy of those setbacks. Well, I appreciate those important data that have been presented and these health concerns from various parties. I recognize it's challenging on how you take this information that appears to be where you're hearing different opinions and how to reconcile that. So I've reviewed these conclusions over the last few days and the rebuttal statements and their supporting studies. And I will say that I have nothing that I've heard from those that give me any indication that my direct testimony conclusions that I've just presented to you would be changed by any means at this time. So in the next several slides, I'm going to present to you why I believe that to be true and provide some clarity to you as commissioners on some of the studies that have been presented. So overall, I'm going to start with very specific statements that have been made throughout these rebuttals regarding public health impacts that really need to be critically evaluated. All these parties have presented a very selected set of studies in what I would consider two categories of data that we use as public health experts to consider what we mean by adverse health impacts, specifically related to, say, air quality and setbacks. Those would be data and that we evaluate them on the strength between exposures and health risks. So first are the health effect data. Those are data sometimes called epidemiology studies that you've heard about, data that look at populations around, around oil and gas facilities. In Colorado, you've also been presented with data of other states. The second set of data that we're going to talk about again is the environmental data. So you've also been presented with a lot of air quality data and environmental data. Both pieces of information are important when understanding what it means about adverse health impacts. So the first set of epidemiology studies or health outcome studies attempt to connect exposures to a health outcome in a population. You've been presented with a selective set of these types of studies, and you've also been presented in a manner as though all of these studies are equally strong in connecting the dots between an exposure directly related to oil and gas operations and the health effects of these communities. These parties have not applied a systematic objective methodology, yet it's extensively and used across public health, especially when it comes to policymaking. They've selected a very limited set of studies, so you've not seen the whole body of literature. However, it is publicly available. And there are several parties that have done systematic reviews, including CDPHE. And why this matters is because it's very critical to ensure that biases and other limitations are fully considered as to the strength of the overall evidence of these studies. So not all studies are created equal. Scientific criteria must be used to assess the weight of those, and that has not been brought up in any of these rebuttals that I've heard over the last couple of days. And many of these studies do not measure exposure. They rely on proximity measurements as a pseudo proxy to measure exposure. We know that just being in proximity to any kind of facility does not necessarily translate and can be used as a causal effect on any kind of industrial operation. And so associations between proximity and a health effect does not demonstrate causality. When I talk about environmental data, as you've heard over the last both direct and in the rebuttal statements from Larimer County, I really want to clarify a couple of other points, and they're specific because there are very clear definitions in public health risk that we use, and they've been misused and what I believe is kind of thrown around haphazardly throughout this process. But yet I believe, from my point of view, it's critical when you're evaluating what you mean by adverse health impacts. For example, it's been stated an air quality impact as though that equates to a health impact. That is not true. An air quality impact is not a health impact. And a health impact is very ill-defined by any regulatory agency. In fact, what we use when we're talking about environmental data and evaluating the health risk is adverse health risk. And that's very important to differentiate those compared to cumulative impacts. And lastly, we've seen over and over data that have been presented as though it's above some guideline number. As I've stated before, an exceedance over a guideline number does not equate to harm. Exceedance over a guideline number by a source does not equate to an exposure or a harm. Next slide. So I'm going to get into a few specifics of what's been brought up. The first is by the Physicians for Social Responsibility. These are compendiums that I'm familiar with since I was there at the State Health Department that have been put out every few years as a growing body of stated to be scientific information. I want to point out to you that the 120 plus studies that you were presented with include media findings. To my knowledge and to anybody in the scientific community, media reports are not scientific studies. They also include studies that relate to other states, other countries, and in fact, even studies that don't relate at all to oil and gas operations here in Colorado. However, just compiling studies does not equate to doing a systematic scientific review of the literature. And it's very well established that when you are using scientific information to establish policy, that systematic reviews must be conducted that weight the quality and the ranking and the biases of these types of studies. And this has not been done in this compendium. So quantity, when you hear growing body of evidence, that's quantity of studies or compiling of news media articles to assert that there is a growing body of evidence just is not a scientific method that we use as public health experts when assessing the evidence. Next slide. Along with that, the Physicians for Social Responsibilities compendium is explicitly biased on their website, stating things like tentacles of harmful energy systems, and the reason that they have done this and expanded their compilation. They've also included, like I stated earlier, hundreds of studies from other countries stated practices and regulations that are not relevant to this fleet. They've stated for the first time in their compendium, they've compiled additional studies on indoor air quality and health impacts of gas appliances. So I ask you, Commission, are those studies relevant of gas appliances to what we're dealing with here in this rulemaking? Next slide. The next that has been brought up is a recent study by Dr. Lisa McKenzie, and Earthworks brought her study up in their rebuttal statement. This study is similar to other McKenzie studies and other studies that have been done before. And while it's useful information to consider maybe where we need to look next or consider what could be causing these findings, again, you have to dive a little bit deeper than take it at surface for face value. So this study alleges that the health effects have been shown to occur with air pollutants and noise, and that may be why there's an increase in populations of 80 years old and older, and only primarily in women, experiencing increases in existing atrial fibrillation events. They did not occur in younger populations, nor did they occur in men. And this, according to Dr. McKenzie's study, was within about 2,000 feet. The previous studies linking atrial fibrillation, for example, really relate to very specific air pollutants. When you evaluate systematic reviews of studies looking at these atrial fibrillations and air pollution, you actually see increased rates showing higher associations when you look at all the studies combined in a systematic method with men and with people less than 65 years old, with the strongest correlation of exposures to particulate matter. However, one of McKenzie's previous studies, where they actually measured particulate matter near well pads in Colorado over the last few years, are inconsistent with their own conclusions, as the particulate matter measured by her study near oil and gas well pads were all below ambient air quality standards for every phase of operation. So when you look at these studies, as a scientist, we have to think about how could there be a connection with exposures, and what exposure would it be that could be causing it? And so, for example, they also talk, in Dr. McKenzie states that the analysis of this study population as a whole does not of an association between exacerbation of atrial fibrillation and proximity. So while you've been given pieces of information, I want to provide you with the full context of these studies. Next slide, please. And I just have here additional limitations of the study that I'll continue to move forward with here. Next slide. So the other study that's been brought up is Wisner's 2023 study. I've spoken to the commission about this study in depth at Broomfield hearing, but I'll again just bring the main findings up to the commission. The Wisner study that's been cited by Earthworks in their rebuttal. Again, this study used self-reported symptoms, which has standardized knowledge in practice of epidemiology and public health, is that these self-reported symptoms have a high risk of bias based upon the subjectivity and the way surveys are designed. They're not the same as a diagnosed medical condition by all means. And these symptoms are not specific to oil and gas. And multiple other concerns and limitations with this study, including residents that happen to be most concerned, their heightened concern around air, odor, and noise within a mile on average were significantly higher. So their level of concern was just as highly correlated with distance, which causes you to see that depending on how you bias the questions that you ask survey participants can lead to confounders in results. Next study. Another claim by Earthworks in their rebuttal is that the monitoring and modeling data found pollutant concentrations above acute health risks at distances of 2,000 feet or greater. We're not sure exactly what Earthworks is speaking to, except this CDPHE 2019 study that they refer to. And I will remind the commission that the CDPHE 2019 study never conducted any air monitoring data. It used emission data, but there are monitoring data. So the conclusion is not clearly based on that study. And again, like I spoke during my direct testimony more extensively, is that the modeling data was evaluating these worst case scenarios, specifically under high-end conditions that, like we've said before, were back almost a decade ago and are not necessarily relevant to today's operations. Next slide. Earthworks has also brought up an admitted record from the COGCC in the 2020 emission change rulemaking, stating that there's evidence that the administrative record stated highly likely to be attributable impacts based on proximity to oil and gas and development, and that the body of research is growing and robust. Again, this goes back to my initial statements around specific health outcome data are not environmental exposure data. The data were not collected that demonstrated exposures to oil and gas related compounds and health risks. And again, these studies have been largely inconsistent, have not been designed to show causality. And while I'm not dismissing them in their entirety, they're very important pieces of the information that we use to assess scientific evidence. But you have to understand the quality of the data and how that information can drive you to go and collect actual data. And so relying on all the thousands of data points that have been shown to you on actual in communities over the last 7 or plus years, I believe, really take precedence in considering protective nature of the current setbacks. Next slide. And lastly, this was another study by Leanne Hill by Earthworks. I won't go into a lot of detail on it because I could not find this study anywhere in the peer-reviewed literature or online or on Leanne Hill's website through Berkeley, through her organization in Berkeley as a paper. However, again, the same principles apply. I do not believe that it's been a published systematic peer review study. And so there's limitations in being able to draw many conclusions from that. Next study. So now I want to shift to the environmental data and what you heard today from Larimer County and Dr. Collette. So when I shift to the environmental data, primarily there's been a lot of focus on this Broomfield study. And again, it's like I said in my direct testimony, the study brings some value and also ground truths, a lot of the things that we had found with the modeling data. I've said it before, Earthworks has used this as a rebuttal statement, and so I bring it up here again to you as the commission, just to say what I said earlier, is that when they speak about best management practices are emitting concentrated plumes for short periods, and then it's left unsaid, that leaves you thinking that must mean health risk or health impacts or adverse impacts or harm. You cannot just say that something that's been emitted in a plume right at a well pad by a source directly translates to what it means to public health risk. They have to represent exposures. They have to be averaged over appropriate times to compare to exposure guidelines. And while these patterns are consistent with patterns that we've seen in different oil and gas operations, the inference to health risks is just scientifically flawed. Next. And so today, Dr. Colette's rebuttal testimony brought up some additional, I think, great set of studies that his team have conducted over time regarding air emissions and air quality from well pads during different operations. One of his statements was that most high values were observed near the well pads, and more generically stated that there were still more observations greater than 2,000 feet. Again, out of context, this is from a public health expert perspective, it's sort of meaningless. It tells me something's changing and there's changing emissions at the source, but what does that mean to public health? And again, as in his paper states, these benzene levels have been below the health guideline values at areas that represent community exposures. So in and of itself, the data cannot just be used to just make assumptions about public health risks or adverse health impacts at 2,000 feet. Next. And lastly, this new piece of data that he presented today on sources of benzene in Broomfield. To my knowledge, what I believe Dr. Colette was sharing is that there's you can apportion out what may be benzene or other types of volatile compounds that are coming from the oil and gas well pads compared to other sources. So source attribution and apportioning it. Some of the conclusions that were brought up today around the majority of benzene was near the well pads, and also that there was some single measurement at 1,100 feet that was above a health guideline value. So again, I'll reiterate, this information may be important for us to understand profiles of air quality changes near oil and gas facilities during different types of operations. But it does not equate to what we know about exposure and health risk. If the data were appropriately evaluated and averaged and applied the risk assessment principles that EPA uses, CDPHE, and the CDC as we apply as health risk assessors, then you would evaluate the data appropriately. And I've shared that earlier and before. And what you see is that there are no acute or chronic health risks at 2,000 feet or even closer based on their data. So I just iterate again that it's scientifically flawed to take and extrapolate these air quality data and make assumptions about health risks. Next slide. So this was one more study stating that the well pad emissions footprint extends beyond 2,000 feet. As you see, the extensive gradient that he demonstrates here over distance, well pad emissions does not mean that's what somebody's being exposed to. So what this means of total VOCs as a public health risk assessor, an exposure scientist, is ambiguous. You have to evaluate the actual data of the compounds and understand what the measurements are, how long they've been collected, et cetera, over time to really get you an estimate of exposure. Next. So just overall, when it comes to the environmental data that have been presented to you by Larimer County, I just want to reiterate that simply measuring a chemical because we can measure it in the air and we have technology to apportion what comes from one industrial operation versus other sources of emissions, and then comparing that to a health value is by far not a public health risk assessment. It is missing really critical information to contextualize what we mean about public health risks. A change in emissions is not an exposure, and defining an air quality impact or showing emissions that extend beyond 2,000 feet does not equate to a health impact or harm. More information has to be contextualized under those situations. Next slide. And so I just want to leave the commission with my last really set of slides. Again, I won't go over my conclusions, but my rebuttal testimony conclusions are the same as what I shared in my direct, because despite all of the additional data that have been shown over the last few days in my review of that data, again, my basis of my conclusions remains the same, that current regulations and operator BMPs are not resulting in consistent evidence of measured air exposures at levels that we would be concerned about from a health perspective, and do not identify that there's been evidence of health risks or harm at current setbacks of 2,000 feet. And not only is that my opinion, but if you look at all of the studies and the data that are publicly available by CDPHE on their website, it's consistent with their findings. And I will leave it at that. Thank you. Thank you for your time.
Thank you, Doctor. And oops, sorry. Someone else want to jump in there? If not, I'll jump back in. Christy or whomever's running this slideshow, I think I jump into impact areas and a couple of things before we turn it over to you. Thank you. So one of the large understatements we've heard in this rulemaking came from, I think, Commissioner Mesner this morning about basically saying something to the effect that impact areas or the subject of impact areas, we've heard a lot about it from agencies and stakeholders. And I think that's, like I said, an understatement. It is with some trepidation that I jump forward into that very same subject, but I hope we can shed a little more light on where industry is on the subject of impact areas and perhaps move this conversation forward. We come out largely where we began, which is that a 1 mile default is the place to start, while building in a provision by which the director can enlarge or reduce the impact area based on site-specific factors. So first, there seems to be some agreement, at least I believe there is, that for wildlife data analysis units, they clearly are just too big to be useful as an impact area. A data analysis unit can be as much as 1 million acres, as the CPW mentioned in their testimony way back on Tuesday. And that's far beyond an appropriate scale to understand the cumulative impacts of a poor solitary OGDP. By the same token, it seems as if hydrologic unit codes are unworkable, as they can encompass an entire watershed, an area that can range from 10,000 to 40,000 acres in size. With the help of Google, I did a little math and found that at 40,000 acres, the impact area would be roughly 62.5 square miles. And for us, that raises the question of whether an impact area based on a hydrologic unit code can feasibly even be done. Excuse me. Ultimately, we're concerned about whether something like this can be implemented in any realistic manner, and frankly, we don't think so. CDPHE acknowledged last Tuesday, or this Tuesday rather, that using air quality monitoring regions would be way too big. I believe they suggested 1 mile might be appropriate, but there may have also been some caveats attached to that. So where does that leave us? I honestly no longer remember who suggested an impact area for watersheds as 2.5 miles. It could have been CPW, it could have been CDPHE, but I don't remember hearing a clear explanation of the basis for that recommendation. But here again, it seems a consistent default value is a good place to start in defining an impact area. I want to emphasize, though, that staff and CPW and CDPHE and relevant local governments and stakeholders will all participate in deciding on the appropriate scope of an impact area for each OGDP application, and we expect those agencies' recommendations will get some deference from staff. And so far as we can tell, CPW has never been shy about making its views known, and that's same is true for CDPHE. That's their opportunity to suggest something larger or as you heard from some of the Western Slope operators today, smaller than a mile. Finally, we also have some concerns about CPW's suggestion of a circle, but with, I'm going to use this phrase, an appendage. I'm not sure that's the right term, but it's the best I could come up with at the moment. But an appendage, if you will, for things like roads or pipelines. Again, we think that this is something that CPW should be talking about during the pre-consultation stage with the director and with other agencies and with stakeholders. But beyond that, there's some uncertainties associated with roads and pipelines that suggest to us that a default that includes such an appendage might not be the best step forward. For example, in some parts of the state, the action agency for a right-of-way for a road or a pipeline or an electrical line will be the federal land manager. In other circumstances, the surface landowner may have a lot to say about road alignment or pipeline alignment, or where you put an electric line. Relevant local governments will certainly have a lot to say about things like pipeline corridors. An electric utility may have a lot to say about where a highline power line gets constructed. And I'm sure there are other contingencies that I haven't even thought about that will raise questions about how an impact area is assessed. But we see those unknowns as another argument in favor of consistency, always leaving open the director's ability to take CPWs, CDPHEs, the federal land managers, and other views into account. We think that a 1 mile impact area makes sense. It provides some predictability as well as consistency. It's implementable, and that's really important for operators. It will capture air impacts, and we believe it will capture the significant wildlife and water impacts absent some anomaly that suggests something different is in order. There's a few other reasons why we've come to the conclusion that 1 mile still makes sense as a default, and again, an emphasis on a default value. Commissioner Cross mentioned that we need to avoid consulting around every application, and we certainly agree. I'll emphasize that we think in most cases, a mile will capture potential impacts, that it represents a manageable task, but that a default value of 1 mile also lends predictability to the process. It gives the operator at least a context within which their preliminary work can proceed. But a critical point, and I'm going to keep emphasizing this, is that the director has the discretion to enlarge or conceivably narrow an impact area where that's appropriate. CPW, and for that matter, CDPHE will always, no, that's not true, will often be involved in pre-application consultation. If either agency thinks the director needs to modify the default impact area, they can make that case at that point. A number of parties have stressed the importance of getting the agency's views, and the process embraces that. The same goes for relevant local governments, which really have a lot more to say about roads and pipelines. But it makes sense to settle on an impact area when all those parties are in one room together. That just makes some common sense. Now, let me talk for a minute about process related to impact area designations. Earthworks addressed some of these issues, but it's important to recognize they said more than once they oppose a permit by permit approach to cumulative impact analyses, but they didn't offer a fleshed out alternative. But fundamentally, we're stuck with permit by permit analysis in most cases and caps in some other cases. The process suggestions from Earthworks are frankly unworkable and further extend an already protected process. By the time of pre-application consultation, an operator will have a good sense of locations and facility design, not later in the process when a change of direction would involve economic waste of much of the work that has already been done. Later in the process just complicates the entire process. Moreover, implicit in the process laid out by the same parties, and this is important, I think, is an adjudicatory hearing before the commission if anyone, potentially anyone within several miles of a proposed location, disagrees with the director's decision. With all the process and time that such a hearing entails, and there could be numerous such hearings, they would further stress the staff in this commission and create an already protected make an already protected process become even more protracted. and at least one party has hinted at appeals of the commission's decision. I suggest that that's a recipe for regulatory chaos. All of that points to entrusting the director and realistically the staff with the initial decision on impact areas after consulting with agencies and relevant local governments. Now I'm going to digress for just a moment to reiterate that the staff, which includes many subject matter experts who've developed this expertise over the course of a number of years serving on the commission, that they spend significant time and effort in reviewing virtually every facet of every application, from engineering to community outreach to geology to regulatory controls. They're more than capable of evaluating an operator's proposal for an impact area, making their recommendation to the director, and supporting that. Now I'm going to switch to a substantially different topic, and it will only take me a moment, so we'll move quickly through this. But Colorado Conservation Colorado has suggested that distances should be measured from a location boundary as opposed to the working pad location. Now I'm going to admit right out of the box that this is an arcane subject, but it's also an important arcane subject. And amidst everything else we're hearing about this in this rulemaking, we have only begun to understand all the implications of this proposal. But the bottom line on this issue is that the difference between a working pad surface and the location boundary goes far beyond the legislative intent. It goes beyond the scope of this rulemaking, and it goes beyond what was noticed in this rulemaking. This change could have far-reaching implications across all of the commission's rules, from the 100 rules to the 1200 series rules, and should not be under consideration in this limited context. For example, soil stockpiles and stormwater management features are accounted for on the oil and gas location. The actual operations of oil and gas equipment reside on the working pad surface. For these reasons, the more representative and protective measurement to receptors should be from the working pad surface where the actual operations are taking place, and not from the location boundary where you would effectively be talking about soil. Similarly, if we switch from measuring distances from working pad surfaces to the edge of a location, Form 2A measurements throughout the rules would change, requiring at least a modest, if not a substantial overhaul of Form 2A. Another example, the current rules use measured distances for all kinds of things, distances from water bodies. The proposed change would alter measurement points from working pad surfaces to the location for residential building units, for high occupancy building units, for schools, for local governments, for floodplains, and for a number of other features. That's just a short list of the changes that would be needed throughout the rules, from definitions to 1200 series rules. And many of those rules were not noticed for this rulemaking, and this, as I said, potentially very large undertaking with implications that we're only beginning to understand. In short, this is a box of Pandora's, and we urge you not to go there. And with that, I'm going to turn to, I believe, Christy Woodward, and I appreciate your time and your patience with us this afternoon.
Thank you very much, Jim, and thank you, commissioners. I just got the under 10-minute warning, so I'm going to try to go quickly here. But I'm here to address enhanced systems and practices in 316. As you've heard from many, not all enhanced systems and practices can be blanketly applicable to all oil and gas operations, particularly those in 316C 4A 1 through 4. You heard from each of the industry parties a little something different on these ESPs. Some operators can implement them all, some only a few, and some none at all. You also heard from CDPHE that these are difficult to implement in all instances, and I've heard the same from many operators during the OGDP hearings. COGA also represents a wide variety of operators, many of whom aren't parties to the rulemaking, who asked me to share today why these shouldn't be blanketly applicable to all sites. For 316C4A 1 and 4, hydrocarbon storage tanks per CDPHE Regulation 7 are required to be controlled through the use of enclosed combustion devices. These devices are required to lower VOC emissions by 95%. However, testing now required by CDPHE in recent regulation often shows that this is actually 98% or greater reduction in VOC emissions. Operators who either continue to own or historically have owned their pipeline during development could build pipelines that were specific to the vapor pressure, temperature, and conditions of the oils they produced. However, for operators who do not own their own pipeline and often share gathering lines, they are subject to the specifications of the pipeline company and their specific contractual obligations for liquid specification at the transfer meter. Therefore, to get your product to the pipeline specifications required for takeaway, you need hydrocarbon storage tanks to stabilize the hydrocarbon liquid. If you can't get a pipeline to your site, you also need to be able to truck product, and the tanks act as a way to stabilize that product, and importantly, to ensure that trucks are full and limit truck traffic. The presence of these tanks allow for less truck traffic, allow the operation to continue in the event of a pipeline shut-in, and also stabilize the product to meet pipeline specifications when takeaway is available. Further, pipeline construction leads to additional land disturbance, and this should be taken into consideration on a case-by-case basis to assess whether this is the right solution for a given site. For two, electrification. For operators in remote areas without electricity proximate to their locations, electrification isn't always possible. This provision excludes heaters for good reason because they're not commercially available for electrification. We also often use solar panels for small things like pneumatics. However, they still require battery backup for when the sun isn't shining and are relatively nascent technology in some applications. One should also consider the land area required for enough solar and/or wind power to produce the 475-ish kilowatts per hour required of a multi-well pad facility. This can be acres of additional surface disturbance and will also require sufficient battery storage, as oil and gas facilities do not operate intermittently like wind and solar. For provision 3, the same can be true for operators without produced water takeaway capacity or proximity to an injection well. These aren't reasonable or necessary requirements. Produced water tanks have minimal emissions, and if their emissions are high, they're required by the Air Pollution Control Division to be controlled and minimized. It would take a large amount of pipeline over a spider web of surface disturbance to transport produced waters for little emission reduction. The DJ Basin doesn't generally produce enough water in commercial quantities to warrant this volume of surface disturbance or recycling even in many instances. To be clear, pipelines are the safest and best way to transmit product. However, they are subject to local government regulation, landowner permissions, and without proper planning can cause additional surface and subsurface disturbance that should be considered. Their construction also has air quality impacts that may be far greater than the low-level emissions from the small amount of produced water in the DJ Basin. On the last slide, I presented just a few examples of situations where these requirements are infeasible or overly burdensome and therefore not reasonable and necessary. While some of these are possible and warranted in some instances, and they should be encouraged, we don't believe that this should be stricken from the rule, but that an operator should attempt to implement them where practicable, as suggested here in this red line, and to make a demonstration to the ECMC when these aren't reasonable or necessary per 316C4B. As it pertains to closed-loop sand systems, I believe there's some confusion over the term sandbox and sand trap. The sandbox is one method by which clean sand can be delivered to a location prior to the completions operation. As I testified in my direct testimony, this should be struck from the rule since the statutory mandate for ESP should focus on ozone, and particulate matter and silica dust are not ozone issues. However, should you choose to keep this in the rule, I've suggested a more flexible red line here, and this should be put into a category other than ozone, as dust is not an ozone precursor emission source. However, if the intent is to control VOC emissions from flowback activity via the sand trap, as suggested by Larimer County, then additional clarity and red lines are needed. Sand traps are used at the back end of the completions operation when fracking is completed and sandy liquids are flowing back up the wellhead. At this point, there's a sand trap to keep the sand entrained in the liquid form, for lack of a better term, to keep it from chunking up the equipment post-flowback. There are common standard operating procedures and training that are implemented at facilities to ensure that emissions from the back end of the sand trap are minimized via manual valve control. Again, this is a common practice, but standard operating procedures and training are required and have been implemented for many years by COGA members. Clarity is needed here to understand and keep this strictly to ozone precursors and for operators to understand what this language means. Wherein there's confusion on terminology, practice, and even emission sources control for VOCs versus dust, two very different emissions and impacts, maybe the better solution would be to leave the regulation of air quality to the experts at CDPHE and the Air Quality Control Commission. Regardless, I'm willing to help answer any questions you may have or propose additional red lines or suggestions if appropriate. Commission Chair Robbins also asked us for us to come back on the January 1st, 2026 versus 2025 implementation date for ESPs. I polled COGA members, and essentially this extension request was due to confusion over 316C3A4 on sandboxes versus sand traps, the particulate matter issue in 316C3A5, and the issues I covered on 316.4A 1 through 4. All the remaining proposed ESPs can be supported for the non-attainment area as stated and implemented by the commission staff. So initial implementation date of January 1st, 2025. I'll now turn this over to Chris Klokusher to discuss ozone. And I'm sorry, Chris, with just a couple minutes remaining.
Good, thank you. Next slide, please. So I'll hit a couple of high points on ozone. First is that industry is doing its part to reduce emissions. You've heard testimony that we cause 8.6 parts per billion of Colorado's ozone levels. That is not accurate because it incorrectly counts the total impacts from 3 different locations and adds them up, much as if you said we got 2 inches of snow in Denver, 2 in Boulder, 2 in Fort Collins, and so we had 6 inches of snow. That is not an appropriate measure, and neither is the 8.6 part per billion figure. It also counts emissions and ozone impacts from transmission compressor stations that are not subject to your jurisdiction, so it's inappropriate to use. The next point I would make is that you need to have an accurate assessment of the cumulative impacts of oil and gas emissions on total ozone. It is much smaller than you might think. I could run through these slides. These are all slides from the Air Division and the RAC that show that ozone is actually a much smaller contributor, oil and gas is a much smaller contributor than you might think. But in the interest of time, I'll simply say that it's important to balance the benefits of your proposed regulation against the costs and avoid imposing undue burdens. Your regulation should be reasonable and necessary. Finally, I would like to briefly answer Commissioner Messner's question from the prior session to Civitas about a mandate for enhanced systems and practices, and just point out that the statute requires you to adopt a list of ESPs. It does not require you to mandate every facility in every location adopt the same ESPs. And in fact, it tells you to consider the effects of ozone when evaluating each particular location. So again, I'm happy to discuss some of the slides that we have here showing that the ozone benefits of emission reductions have actually been much smaller than other parties have presented, but we would ask you to deny the request of other parties to adopt more stringent air quality regulations than staff has proposed. Thank you.
Thank you, Chris. And I think, commissioners, that concludes our testimony, and we're open for questions.
Okay, great. I just have a couple. I'll start with Mr. Martin. I understand the point about the 1 mile default. You wondered who talked about the 2.5 mile radius, and my notes reflect that that was Tessa Sorensen speaking on behalf of the Water Quality Control Division, and that they felt that 1 mile is not wide enough to identify all impacts, but they agreed that the HUC 12 was too wide. And so they recommended, or she recommended, a 2.5 mile radius impact area, and that aligned with some form of Water Quality Control Division source water assessment protection program. So having reminded you of that, does API COGA have thoughts about using that approach for water?
So it is with some trepidation that I disagree with Ms. Sorensen, but I am compelled to do so. I still think, and I believe there's good reason to continue to rely upon a default value of 1 mile and leave to CDPHE in any particular instance the opportunity to argue for something larger than that, where it appears that the OGDP actually could affect water quality, for example. But using a default of 2.5 miles for water resources, for a water resource impact area, may overshoot what you need in some other circumstances, which is really why we're suggesting the 1 mile default with substantial discretion on the part of the director to take into account what she may hear from either CPW or CDPHE, a federal land manager, or a relevant local government, and expand or in some cases reduce the size of an impact area to fit the application that's actually before them. I hope that answers your question, but let me know if you don't think I hit the target, and I'll make another effort at it.
I think Ms. Woodward wants to help you.
I don't know if I'm going to be able to help Jim. He did a great job, but I went away and we've spent quite a bit of time with operators on the West Slope in the last couple of weeks talking about watersheds in particular and the 1 mile versus a half mile. And as you know, they have very complex topography. They often go out in the field and verify maps and data provided from WSPs and other things. And in many instances, it's very simple for them to narrow that area to be able to do an assessment, even as small as a half a mile, to be very, very effective. And so I think having a standardized 1 mile makes sense, as Mr. Martin explained, but that there are instances where less than that can put boots on the ground and do a far better job than any maps provided to begin with.
Okay. Along the similar line on impact area, I understand the industry perspective is that it ought to be director based and it ought to be early in the process. As drafted, that's the way it is, but there is a fairly deferential standard for the commission to relook at that under a clearly erroneous standard down the road. What's your folks think about that?
To be honest, Chair Robbins, I haven't discussed that with operators. It might be a question better directed to them, but off the top of my head, I think that it's fundamentally important that someone, and we suggest that the director fill this role, but someone make a decision very early in the process, because otherwise, the farther you get into the process with some uncertainty about what the final determinative impact area is going to be, the greater the chance that you're wasting a lot of people's time and a lot of money. And potential they could have to almost start over if the impact area changes. And given the expertise that's been accumulated at the commission, not just the director, but the staff, I believe, and I think the industry agrees, that they have the capacity to take a very hard look at an operator's proposed impact area. There's an opportunity to get advice from all of those other agencies I've mentioned a couple of times in our presentation, and to make a pretty sound, a well thought out, comprehensively reviewed recommendation, or a decision rather, on what an impact area ought to be. And it ought to be an unusual, even extraordinary case where someone turns that around later in the process and really imperils the whole process.
And if I could just add on to that, I think that, some kind of certainty and an understanding of what is expected of us early in the process, to Jim's point, is really important. I think we've spent quite a bit of time transcribing and understanding mission change and substantially equivalent to Mark's earlier point. And so for us to have a known entity by which we can start to approach making this demonstration and making this assessment, while knowing that that area is not going to change, is critical for the success of a functioning program for assessing cumulative impacts.
Okay, thank you. Commissioners, the panel is open for additional questions from you. Commissioner Ackerman?
Thanks, Mr. Chair. I'll jump in with kind of some further exposition of the point that you raised, as well as something on my mind also, and maybe the party has said all it wants to say about that, but I just wanted to ask in a little bit of maybe a different way. It's certainly been suggested to us that starting with a smaller impact area and then expanding to, rather than starting with a smaller impact area, expanding to the largest potential impact area. And I think that could arguably be 2.5 miles, as the chair stated. And then industry would argue to reduce, rather than others arguing to expand from there. And a key part of that argument was that the assertion that the industry has the resources to do so, whereas others may lack the resources and organization to consistently ensure a proper boundary is placed. I wanted to get your thoughts on that, and then maybe some follow-up questions on that same topic.
So Commissioner Ackerman, thank you for the question. I think I understand you to say, well, I'm not quite sure, but are you asking whether we think a default value of 2.5 miles is the right one, or am I misunderstanding?
More focused on the philosophy of why not start with a larger impact area and then argue for contraction rather than starting with a smaller one and argue for expansion.
Ms. Woodward, would you like to take a first shot at that? I need to assemble my thoughts.
I'm happy to. I think that the impact area, like all things in the regulations for the ECMC, should be reasonable and necessary. And I think it should start with an area that's appropriate by which an operator can make a reasonable assessment. Having done a tremendous amount of this work in the 25 years of my career, I can tell you having to look out 2.5 miles for a variety of constituents of concern would be overwhelming. It would be very difficult to do. I think there may be circumstances that warrant that, but I don't think it's consistent for every single one. I also think, and I'm going to fall back on our initial testimony, that there's a tremendous amount of data out there that shows you exactly how far impacts are for a variety of subjects. That may not be wildlife, although in many instances it is. I think watersheds are also definable through topographic mapping. And so I would argue that a mile or less is most appropriate for making a reasoned assessment at the outset.
Thank you. I appreciate your response there. Along those same lines, then, I certainly could foresee situations being relatively frequent, as we've heard in testimony throughout these hearings, that wildlife experts might come in and state on a very frequent basis that the area of impact should be assessed from all operations. And then if they were working off the working pad surface, instead of looking at all operations, they would expand and encompass those operations, which would be a relatively frequent expansion from the wildlife perspective. I could also foresee CDPHE arguing the source water assessment and protection point of the default is 2.5 miles on a relatively frequent basis. And so, what I'm kind of pondering here is if a larger impact area from the working pad surface could encompass those and would be more appropriate, or would you believe that a more appropriate approach would be a very frequent expansion on the part of wildlife and water, but still maintaining a mile from the working pad surface?
I guess I struggled and maybe disagree with the frequent expansion. I would defer to some of our West Slope folks maybe to come back on questioning, or some of the folks in the DJ Basin. But, when you're working in populated areas or where there's MS4s in the stormwater context, I don't see a need to expand in that vicinity. And then I think when you're dealing with the topography that you see often on the Western Slope, I think 2.5 miles is really far. I think you can easily narrow that through some topography. And then I think, you're certainly more of a wildlife expert than I am. And I think I can see, some, again, deferring to other operators on that one. But I think for other constituents of concern that are being encompassed here, a mile is plenty large enough.
Thank you. Yeah, I appreciate your responses. I do feel like we have heard from the wildlife folks, both within CPW and other places, that, the working pad surface is not generally the epicenter of wildlife impacts. And so time will tell, I guess, kind of how that goes going forward, but I could certainly foresee a frequent opportunity for expansion there on the part of wildlife. Appreciate your responses. Do we still have Dr. McMillan on? We do. Thank you for sticking with us. And I really appreciate your expertise each time you appear. It's very helpful for me to help put things in context. One of the points that you made frequently was exceedance doesn't equate to harm. And I understand that and agree with it. I know that that is the case. But I think the question that is kind of out there is there somewhere that constitutes a threshold that could be used as potentially harmful of any given pollutant out there? And I think that's the question that people would ask, is if the requisite concentrations are not that trigger, how do we understand when we are at that trigger?
Commissioner Ackerman, thanks for asking that question in more detail. So one example you could take a look at are the health risk evaluations that are screening level studies, but that have been done by CDPHE's Oil and Gas Health and Response Department over time, as just an example of the way the data can be collected that are representative of exposures. You have to understand that when you collect the data, how do you average it appropriately? What chemicals are you looking at? And then these health-based guideline values are useful in assessing the potential for elevated risk. So I don't want to say that they're not useful for risk assessment purposes. They don't equate to harm in the sense that, we derive those values at magnitudes of order below where we see observed adverse health effects, whether it's animals or human studies, for the intent that if say, for example, an air concentration goes slightly above those numbers, they're health protective, but it does tell us those numbers are used as a guideline for let's investigate further, let's collect additional data. So your public health scientists like CDPHE would look at that, and they would look at how frequent, under what conditions, et cetera, right? So my answering your question on that, I believe guidelines are still appropriate. Those are what we use for risk assessment in the guideline values, and they're specific to chemicals. Now, I believe like what Dr. Collette spoke about was maybe a 1 ppb threshold or something, and I believe he was speaking to total volatile organic compounds, like as a trigger to take some other kind of action. From what I heard from his testimony today, is really saying that 1 ppb, he acknowledged, is not a health-based value, but it's a value at which we're saying, look, something has shifted from baseline air quality, maybe I think specifically with benzene he spoke about, and therefore maybe more data needed to be collected or something like that. I still think there are questions that you would say, where is the position of where you're sampling? How long are you sampling? What does that mean? Because there's multiple factors that go into how we estimate exposure.
Right, thank you. And yes, in answer to your question, I certainly believe that's helping and appreciate the dialogue. And kind of the last clause that you closed with there is where I was heading next. And I should have said, how do we know? I said, how do we know when we're at that trigger? I should have said, how do we know risk or approaching is what I should have said. But my concern is this, as a layperson with regard to public health, is that I understand that procedure and process. I understand those kind of trigger thresholds that are out there for further analysis. But then it starts to feel a little systematically and procedurally prohibitive to really understand broadly from a cumulative impacts perspective when we're at risk. As I'm gathering from these hearings, really the only path forward is to use those, I'll call them lesser instruments, for lack of a better word, to help kind of understand what triggers are, and then send more detailed instrumentation out to a specific site. And then that puts us in a position where we can maybe assess and address specific issues that arise on the ground. But in a rulemaking perspective, I worry that how can we legitimately address cumulative impacts with regard to air on a broader basis and understand where those things might arise and where we might, be too congested, as opposed to wait for it to be so and address it when it arises. Is that convoluted question get through it all?
Because it is a challenging, you're faced with a challenge in the sense of trying to wrap your head around how do you address cumulative exposures with air. Like I presented, I think in the direct testimony, about how we have to kind of partition out these various aspects of what we mean by cumulative impacts when it comes to air quality. But if you're talking just about, say, for example, air toxics, for example, and Reg 7 and the existing air monitoring regulations. I think that was one of the biggest intents of that, was to ensure that data were being collected as kind of a sentinel to see is something changing, in those operations in more real time, such that you're not waiting until after activities are done to make changes. While, there's been some criticism of certain aspects of the methods that are being used and the diverse nature of the different kind of technologies, I still think they're all fundamentally providing the same type of information, which is collect data in more real time during these operations so that you can actually make changes if something is identified in real time. And I just, in my almost 2 decades of being a regulatory toxicologist, I think that's the most effective way of managing risk, whether it's cumulative impacts or not. It's still, that's one piece of this cumulative impact component that I think is currently, with the existing regulations, being managed appropriately.
Thank you. Again, I find your insight very helpful.
Oh,
And
good.
one last question for you then. We had a suggestion that perhaps for cumulative impact analysis from a public health standpoint, that we should consider incorporating some degree of public health studies and health complaint data that's out there in the general vicinity, and wanted to kind of get your thoughts on that concept.
Sure. So I didn't hear that statement. Sorry, it wasn't probably on all of these hearings like you've all have all been. So I'd be curious to know a little bit more, like for complaints beyond the scope of the Health Information Response Program at CDPHE. I think that is a really fantastic program, that there's a helpline that people can call, and CDPHE has the capabilities and the expertise to be able to deploy and conduct an investigation. They're funded also through ATSDR, which is part of the CDC, that is so they have funding to do community-based investigations that will have, and those frameworks that they use evaluate health complaints, the symptoms, and then also ensure that they're collecting data. And so many of those studies that the state have been doing for the last 7 years or so have been oriented around addressing complaints. So there is an avenue for complaints. And in my experience, being the one that started that program there, it's also an avenue that local government, if their constituents are calling and complaining about something, the local government has a resource there with state level experts to address those concerns.
Thank you. And again, thank you for being here. I do have one more question. This is probably directed at you, Mr. Martin. It was your part of the presentation, but certainly to anyone who is applicable to answer. When you were addressing the previous proposals that have been out there and that have been presented to us in rebuttal, and you addressed the Earthworks proposal, I think, unless I missed it, one of the largest focuses on your, and not just that proposal, but on others, was the unreasonability of the variance process for that use. If you listen to Earthworks, they did propose an alternative variance process that was kind of more tailored around the efforts to obtain informed consent and whether the operator had made extraordinary efforts to do so, and demonstrating that that it would be prevented from a reasonable opportunity to develop without a variance, kind of along those lines. Did you hear that part of their proposal with the alternative variance process?
Commissioner, excuse me, I believe that it was Mr. Matthews who addressed that issue, not I. But if you'll give me one moment, I do want to respond to the question you asked me earlier. I believe that if you look at where most of the active oil and gas drilling is occurring today, 2.5 miles encompasses a huge number of data points. And it's potentially going to bury whomever is reviewing that report, presumably the ECMC staff and ultimately the commission, and creates an enormous challenge in trying to synthesize what all of those data points gathered over the course of 2.5 miles means or doesn't mean. So I continue to believe that starting at a 1 mile and building out to the extent circumstances warrant makes a lot more sense. But with that, I'm going to turn you back over to my colleague, Mr. Matthews.
Appreciate that. Thank you.
Commissioner Ackerman, I did address briefly the earthworks variance process. So I am familiar with the proposal by Mr. Freeman.
Thank you. And maybe I missed that. I thought I saw a slide on the regular variance process, but this variance process was the submittal of written communications between the operator and the owner of the tenant.
It was, excuse me. I'm sorry I interrupted you, Commissioner. Actually, it did have some unique prongs to it. One you mentioned, for example, focusing on informed consent, but it was quite clear from what he said and how Mr. Sura interpreted it, that those prongs were on top of the variance process. And it has to be that way, such that under the specific prongs Mr. Freeman mentioned, you make extraordinary efforts to get informed consent, and you demonstrate that there's no other pathway to access the mineral, no other location. But I think, as he would acknowledge, if you don't also include the variance template under 502, there's no environmental standard, right? There's no net impact standard whatsoever. And I think that's why Mr. Freeman said this is intended to be an overlay on the 502 variance process. So the specific criteria he mentioned, I think, is interpreted as being grafted on to the 5 prongs in 502 that I mentioned, both with respect to the specific variance process, but also the specific hybrid that Mr. Freeman offered, if that makes sense.
It does. Thank you, Mr. Matthews. I didn't understand it to be the case at the time, and I may have been mistaken as well, as I asked him why not the regular variance process. And I think he held that up as an alternative. So I think I might either have a misunderstanding, but I do understand and appreciate your explanation there. So thank you for your response.
And Commissioner, in response to your question, I think he said this would be an overlay on top of the existing variance process.
Thank you. I appreciate that.
Thank you.
I think that's it for me, Mr. Chair. Thanks.
Other questions for the panel? Commissioner Cross?
Thank you, Mr. Chair, and thank you for this presentation. I first want to maybe start with Mr. Kolklischer. I know we quickly went through a lot of the slides at the end there. And I'll admit, I think just trying to a quick version of what you were hoping to get across with those would be helpful. I know I saw a couple different things on some of the emissions data. I'm not sure if some of it was about NOx, if some of it was about GHGs, kind of what were being shown in those charts, or what was intended to be shown in those charts.
If you would allow us to put the charts back up, I can spend 20 seconds or less on each one to just show you very briefly what they show in terms of how the changes in emissions and oil and gas activity over time have had a really pretty small impact on ozone levels. So this first chart shows that, and this was prepared by the Air Division, at the NREL monitoring site, total human-caused emissions are responsible for only 29% of all ozone impacts. Most of the impact is from out of the ozone area. And the next slide shows that of that 29%, oil and gas is only responsible for 12%, which works out to about 2.4 part per billion ozone contribution at the NREL monitor from oil and gas. On the next slide, I promise to try to keep this very brief. The Air Division put together this table showing the top sources that contribute to ozone impacts at each monitoring site across the non-attainment area. So this is not just NREL, but looking across the Front Range. Light duty vehicles are pretty clearly the dominant contributor to ozone in the Front Range. followed by, in sort of the yellow or mustard color, the non-electric generating unit, non-EGU point sources. So these are things like paint booths, factories, other point sources, and oil and gas would come in after that. If I could have the next slide, this is showing trends in ozone concentrations over time. So the circles at the top show the ozone design value each year, and you can see it fluctuates in a pretty narrow band in the 70s or sometimes up to 83. At the same time, VOC emissions have fallen sharply, NOx emissions have fallen sharply, oil and gas production has increased sharply, but the increase in oil and gas production really has not caused greater ozone concentrations, at least overall, right? And we're not trying to say that oil and gas does not emit ozone precursors. Obviously it does. I'm not trying to say oil and gas doesn't generate ozone. Obviously it does. But when you're looking at the cumulative impacts of this industry, in light of all the other sources that are out there, other source categories, natural biogenic sources, things like wildfires and meteorology, those factors overpower the impacts of this industry. And so the cumulative impacts from the oil and gas industry are actually pretty muted. And the last chart I would ask to look at is the one Christy showing the bars with the rig count each week. So this is a KOGA chart. Next slide. This slide is a KOGA chart we put together. The blue vertical bars are showing the weekly rig count from Baker Hughes. And then the lines are showing the number of ozone exceedance days each season. So this is plotted by year. And what this chart will tell you is that in 2018, for example, we had a very low number of ozone exceedance days, despite having a large number of drill rigs operating. Contrast that to 2020, which of course was the pandemic. We had a very low number of rigs operating, and we had one of our worst ozone years. So changing the number of rigs that are operating really does not have an observable impact on the number of high ozone days that we experienced. So again, we want to be leaders. We are leaders. We are working very diligently to reduce emissions. Colorado has adopted stringent regulations. Those annual costs to operators for air quality are more than $200 million per year. Emissions are going down. Those are all very positive things. But when you make policy choices about how to draft your rules and which burdens you want to impose on industry, I really encourage you to ask what the benefits will be. How much will it really move the needle with ozone? And since this is a cumulative impacts rulemaking, how will you be able to distinguish? Will you be able to see the difference from the oil and gas emission reductions across total regional ozone? And these slides would show that you are unlikely to see real ozone benefits. So again, adopt reasonable rules. This industry is at the table working to cut emissions and trying to be leaders. But we would recommend that you not go beyond the staff's proposal because the benefits won't justify the costs.
Okay, that's helpful. And I'm curious if, and it may not have ever occurred, but I'm curious if there's even a greater breakdown compared to over the 6-year period shown in this chart, if you were to look at time of drilling, if there's information about how many rigs are operating during the ozone season versus not at the ozone season, if it shows similar information as well.
This chart is the only one that we have prepared. The blue bars are showing each week during the summer ozone season. So this is not looking at spring or winter, just the summer ozone season.
Okay, that's helpful to know. And then if you could actually go, I think it was 2 charts back, there was one with a lot of dots, and that was one that went by quickly as well, and I wasn't 100% sure what that one was showing. Yes, this one.
Okay,
what is this showing?
This chart was put together by the RAC. Again, we're trying to show you data and slides that were prepared by state agencies. So this is not an industry slide. It is a little bit busy. This is data that was put together by actually the contractor that the RAC uses for ozone modeling. Their name is Ramboll. And they presented it at an ozone modeling forum in 2023, where they explained the sources and causes of ozone in the Front Range. On the left, you're seeing changes in the peak ozone concentration each year. So this goes back to 2002, but it's showing it's the maximum design value. It's a little bit complicated how ozone is calculated and reported to EPA. So they look at the 3-year average of the 4th highest daily value during each summer. I can go through that more if you want, but it's the regulatory design value showing how we are being graded for ozone. That's the dark line. And you can see it fluctuates. The legend is written in parts per million. So where it says 0.075 parts per million, that's the same as 75 parts per billion. But you can see fluctuations. The top right shows annual NOx and VOC emissions across the state of Colorado going back to 1995. It would be nice if it showed ozone area emissions, but again, this is what the RAC put together. It shows statewide NOx and VOCs. You can see in 2002 and 2003, NOx in the red peaked at about 400,000 tons of emissions in Colorado. And if you look at the ozone levels in 2002 and 2003, we were looking at high ozone levels in the upper 80s. Since then, NOx emissions statewide have fallen from 400,000 to about 130,000. So NOx emissions statewide have fallen by approximately 2/3. The difference in ozone has been much smaller. Ozone has gone from around 87 to around 80. So seeing a very dramatic 2/3 reduction in statewide NOx emissions has not achieved a real benefit in ozone. It is, declined generally, except for years when we have significant wildfire activity. But this tells me that the likelihood of getting some additional NOx reductions from pre-production activities, the likelihood of those NOx reductions really moving the needle on ozone is small. I'm not saying we shouldn't do it, right? We should definitely meet the statutory targets to reduce NOx. But let's also step back and consider how much you can actually achieve in terms of ozone benefits and how aggressively you might want to pursue additional proposals that go beyond the statute.
Okay, that is helpful. I appreciate it. I think next I have a couple clarifying questions for Dr. McMullen. And as Commissioner Ackerman mentioned, a key part of what you were talking about, Dr. McMullen, is really is kind of two-part. One, the air quality impact versus the health impact, and kind of looking at this in a risk-based manner. And so one of the ways I wanted to talk about the risk and potential benefits of what was talked about by Dr. Collette earlier today was, and again, it was brought up briefly, in the monitoring, looking and if it's above a 1 part per billion on the 10-day monitoring, potentially doing an extra 40 days to see that. And I'm curious your thoughts specifically about that in terms of what kind of benefits we could get in terms of the risk assessment by having the additional 40 days, as opposed to, I think at some point in time, CDPHE and APCD talked about it, potentially years of measuring and kind of what the additional 40 days could do.
You may have to help me. So I have a few specific questions that was he speaking to 40 days of a particular, so this would be an extension of Reg 7?
The way I understood it, yes. I think it was, we currently do the 10-day testing, although he said, you can test for other things as well. But what they'd like to see is the 10-day testing. And if it goes above a baseline of, for example, 1 part per billion, then do additional testing to make sure we have a better understanding of that baseline.
Yeah, saying that, and I think there would need to be some clarifying points there on that, what additional testing actually means. And was that specific to production or specific?
I believe pre-production to get the baseline.
Yeah, the various pre-production pieces of that. I probably can't make any specific conclusions, Commissioner Cross, on that. I mean, to some extent, you can say that additional data, collected provides additional information, right? And that the more data that we have over time gives us a better estimate of exposures. Again, if these are data that are being collected close to the well pads, that's really been more of an objective, even though we're using them to compare to exposure-based guideline values as a very health protective kind of assumption. That's again being used more as like a sentinel, like a way of indicating is something changing over time. I'd have to understand what, let me just say, I don't know any clear reason. I'd have to hear him again on that. I did listen to that, but I don't understand the clear reasoning of why that specific amount of time would result in any like more statistically robust data than we would have. But there are some very clear, let me just say that EPA sets out very clear guidance on running statistical, tests, et cetera, on the generating, like what number of data points do you need to get a robust data set. So I'm sorry, I'm not specifically answering it. I think, again, I just always go back to what question are we answering, or what problem that's been identified that we think we need to solve by altering that. And it hasn't been clear to me listening to these rebuttals. It just hasn't been clear what problem we're trying to solve.
Okay, that's helpful. And
okay.
And I think one of the things that came up as well is, and I asked Dr. Klutt about this, is he said there was testimony in the openings about no impacts beyond 2,000 feet. And I know Kate Fury mentioned a significant decrease past the 500 feet until it gets much smaller after 2,000 feet, which was part of the reasoning from the 2,000 feet. And he had also indicated that you had testified about the lack of impacts as well. And I wanted to try and make sure that I understood better your position on that. Is this purely an issue of the air quality impacts versus the health impacts, or are you saying there are impacts, but they're just decreased? I just want to make sure I understand that as well.
We've made it very muddy for you, haven't we? Using a bunch of terminology loosely. So again, as an exposure assessor, risk assessor, impacts is very ambiguous. What does that mean? I believe Dr. Collette's intention was showing a lot of data regarding changes in emission in air quality as a result of emissions, right? Changes in these measurements that you can measure up and down. That is not what I would say would be a health impact or a health risk. So I've got to translate that information appropriately, the way we use it to translate it into an exposure. So I think where you're going, what I'm talking about in the data that I presented is adverse health risks, which to me, when it comes to the space of air quality and looking at the potential for health harm to occur, that's a more appropriate, definition, adverse health risks, or as stated, I think in the current rules, adverse health impact, right? So adversity means that we're concerned about something that would cause some harm to health, right? There would be, adverse has a definition of irreversible changes of some sort of health metric. And clearly, just because you see changes in emissions, you can't say that's adverse, is what is very right stated. And to be clear, is that answering your question? And that's maybe what I'm saying is that I think what Kate Fiore was speaking to was, one, you see dispersion, right? So the concentrations drop. You could say the air impacts drop over time. And that is also consistent with health risk that significantly drops over short distances, primarily from 500 feet to 2,000 feet.
Okay, so not that there's not impacts, but you're talking about the health risks associated with the air emission change and impacts. Okay.
And that's the thing is, if you're talking about an impact of, do you measure some contribution of benzene at 2,000 feet that they can apportion to oil and gas? Is that what you call an impact? Are we saying zero? You know, I mean, that's like then saying any industrial operations that we permit or that EPA and CDBH permit under the Clean Air Act paradigm is not allowed to emit. I mean, emit is one thing. You have to translate that to what does an emission do, and is it still adequately protective of public health according to the Clean Air Act with an adequate margin of safety, right? So are you having to regulate something based on having a zero of no molecule of anything of oil and gas at 2,000 feet? That was not the intent of the 2,000 foot setback, because we interpreted at that time of adversity, right? So that's where you're probably confused, because I was very confused by the multiple language thrown around.
Okay. And then I think similar to what you said and what Dr. Collette talked about as well, I wanted to ask a question. I don't know if it's helpful to bring up you had some pictures of some of the slides he had, but one of them showed a deep.
I'm sorry, we could bring them up if Jim, you want to bring some of those up. That may help. I'm sorry.
One of them had the decrease, and it was showing, I think, the Livingston 1, the Livingston 2, and a couple others. And I asked him about how there was some, even though some were further, it had larger impacts than some that were closer, or sorry, had larger, I think it's just a couple, the one after this. Yes. So in looking at these, looking at the complex alkane factor VOCs, he had mentioned that, for example, in the two that are circled, the Thunder Vista 1 and the Wildgrass 1, even though the Thunder Vista was further away, it had a higher measurement of those complex alkane factor VOCs. And he said that could be attributed to things like wind blowing in different areas, which is why that may come. And so with what you talked about is, with the dispersion, there can be some associated health risk with it. And as I don't want to testify for you, but as I think you said, it decreases as that dispersion goes out further. But so with things like wind, if it could cause an increase here, would that have similar effects on the potentially associated health risk, such that if there's prevalent winds, there could be a higher risk past 2,000 feet? Not trying to get numbers, but could it have an associated risk?
Yeah, you're getting it very well. So yeah, you can, I mean, looking at air changes over time, like what he shows here by distance, is one piece of information we use to say, okay, now we need to take that number and translate it to an exposure and compare it to values that could indicate, is there a risk or not? So interestingly, that 2019 modeling study, and why we keep bringing it up, is because the study did evaluate conditions such as what you're saying under worst case meteorological conditions, like extremely slow winds where you wouldn't get it to disperse, right, and dissipate, and it would be more concentrated at locations So there's a terrain, etc. Couple of points with that. It all depends on how much, right? How much, how long, how frequent is that measurement of benzene, for example. And just because we're seeing these elevated levels, which I'm not sure what elevated means compared to what, I don't know background, but we have to be cautious on the term elevated. An elevated level of a chemical does not mean an elevated risk. We have to, that's like doing part of an equation. Do you know what I'm saying? And not getting the full thing, but it is an indicator. What I would say is exactly what Dr. Collette said, and it goes back to my basis of my main conclusions again, is there is no one size fits all setback number. It just doesn't make sense because of all of these properties like we're showing here. It depends on the situation, the well pad, the operations, the dispersion patterns, the terrain, etc. And so this idea that there's a magical number that's going to be beyond this, or that there needs to be a 1 mile setback, is just not based on science like that. Rather, it's important to do things like what's already being done, is monitoring those local conditions over time to ensure on a site-by-site basis, operator basis, that is not causing these changes in air qualities that could result in a health risk. So it's absolutely right. This is a perfect example of how it depends and why you can't say there's one number. However, we still, even with all of the data he's presented, all of those same assumptions that we made in the 2019 air dispersion modeling studies to look at worst case scenarios, still did not show that at 2,000 feet, we would have consistent elevated health risks that were, of a concern from a harmful perspective. And that's why that became health protective at that time. And again, like I've shared, Commissioner Cross, we've collected a lot of data over all of these various conditions now, we collectively as a state. And this, over the last 7 years, and tens of thousands of data points to kind of ground truth this possibility, and we're not seeing it. We're just not seeing that effects. So, and I have not been presented yet with any data to show otherwise. Okay.
And so, and maybe I'll try and ask a question as sort of a summary as well to make sure I'm getting it.
Okay.
And in the forms, as the applicants put information in, they talk about what's within 500 feet, what's within 500 to 1,000, what's within 1,000 to 15, and what's within 1,500 to 2,000. Now, none of your testimony says there's not the emissions beyond 2,000 feet. It's just that the emissions decrease such that the risk, the health risks associated also decrease.
You're spot on.
Okay.
So there's not what we would consider the health risks are not above. Okay, so the air concentrations do not get to levels that would be above our health protective guideline values, essentially, at 2,000 feet or beyond.
Okay.
So you're right. It's not that there's not an emission. I mean, but that I don't, that's not regulating adverse health impacts.
So we're kind of looking at okay, so we're looking at two separate issues. Looking at what Mr. Kolklischer talked about, we have requirements to lower our NOx emissions, and we have certain things we're doing to lower those emissions as part of our mandate. But we also have a mandate to regulate in a manner that's protective of public health, welfare, safety. And so for the latter, we're not necessarily just looking at the NOx and other emissions, we're looking at the associated health risks with those emissions.
Mm-hmm. Okay. And also remember that NOx and ozone are regulated as with ambient air quality standards that are health-based, right? So that's what it drives to get to 70 part per billion of ozone. That's what's driving that at a regional air quality level. And so it's similar principles that are used for those standards and comparisons as what we do for a situation like this, where we're talking about air toxics that are less regional oriented, and we're concerned more about these kinds of compounds that are emitted to local communities, because benzene, et cetera, while there's lots of sources of benzene, they're more concentrated over short distances. And that's why it's important to look at these a little bit differently from a source. But they're all still, at the end of the day, whether it's regulating through national air quality standards or regulating using non-regulatory standards and guideline values that we use for these chemicals, is a similar approach. Does that help? So
I think it does.
yeah, so ozone and NOx, the reason they're trying to get those down is a health-based standard already, that's already being done. And then these hazardous air pollutants, I think Reg 7 is really intended to address this local issue and make sure that monitoring is being done during the time of operations to ground truth that site by site specific situation.
Okay. That is
Commissioner Cross, if I could add to that discussion about the NOx levels and the NOx standards. So EPA has an ozone air quality standard, the NAAQS. It also has a separate National Ambient Air Quality Standard, or NAAQS, for NO2. And so that is monitored at a number of sites around Colorado. That data consistently shows that the NO2 values are well below the standard. So as an example, this chart that Ms. Woodward put up shows NOx data, NO2 data, from a monitor run by Weld County at the Missile Site Park, MSP. It's about halfway between Greeley and Fort Collins. They started operations in 2021. They have never observed an exceedance of either the 1 hour NO2 standard or the annual NO2 standard. And that is true even though there is a significant amount of oil and gas activity in that region between Fort Collins and Greeley. So it's really telling a good news story that the monitor that we have, not every location is monitored, but the data that we have shows NO2 concentrations that are well below the ambient standard. That is also true for the state's other fixed monitoring sites, although they tend to be more urban, near roadways, as opposed to near oil and gas operators. And it's also true for the CAMEL data. So the CAMEL, which we're looking at here, has been deployed, collects concentration data near active oil and gas pads, including both pre-production and production. COGA plotted the NO2 concentrations from those campaigns. I would point out that this data has been compressed because the CAMEL will sit unused for several months and it's only used sporadically. So the x-axis here is got the data just spaced out over time. But there are very few, in fact, only 2 1-hour data points across tens of thousands of NO2 readings that have exceeded the NO2 standard measured by the CAMEL near oil and gas activity.
Thank you. This is helpful. And I think moving on from sort of the air issues, I just want to, I think, kind of take a step back and look at some of the specific proposals. And so I think Mr. Matthews, this may go towards you. I know you talked about, and a red line was sent in on Tuesday, some efforts to try and move towards, especially with respect to the procedural aspects that have been proposed by some of the, especially Green Latino, some of the environmental justice groups, moving towards some of that. And you indicated that you've made a move towards that, but still trying to work on seeing if you can come to any agreements. And so aside from the procedural issues, I wanted to try and see if I could better understand some of the ideas or movements you've had on some of the substantive issues. I know Ms. Woodward talked about some of the concerns about the ESPs and being mandatory in all situations, but I was wondering if you had any other ideas or movement or discussions on some of the potential substantive protections that have been talked about.
Well, the only issues in my ambit were the procedural issues, where we agreed to extend out to half a mile on every one of those 11 regulations identified by Green Latinos. I think it would be very difficult to adopt at this stage anything from the 3 proposals that I testified to a while ago, the 2 by Mr. Freeman and the 1 by Mr. Sura. And they all seek in a different way to supplant the current 604B4 standard, and industry is believes that standard should continue. So at least with regard to the 604B4 trigger and the procedural regulations that I discussed, I'm not aware of any other adoption that, and Christy, chime in, but I believe that's true on the ESP front as well. I don't think we've adopted any other proposal or reached any other concession with the NGOs or local governments.
Okay.
Christy, is that
You know,
accurate for ESPs?
Yeah, that's right. I think we just look
Okay.
at the straight applicability. This was much debated at the Air Quality Control Commission when we did NOx intensity. And we really, had this discussion, hundreds of hours of discussion with the division on what's feasible, what's not feasible. We worked with other parties at that time, and we really believe that they adopted the best list of best management practices that they can around pre-production emissions, inclusive of NOx intensity. And I think in general, as we get closer and closer to lowering our emissions and getting, the low-hanging fruit regulated at that department, we're really seeing a need for flexibility and the sort of blanket applicability not being feasible, which is why we see things like NOx intensity and GHG intensity. But no, we didn't engage with other parties on those proposals.
Okay, that's helpful. I just wanted to double check on that. Thank you. I think those are my questions.
Other questions for the panel? Commissioner Oath?
Yeah, sorry, I think just one. And it's for you, Mr. Colclasher. We've spent a good amount of time talking about the NOx data. And a lot of those slides certainly have seen in the past, and often in the for example, in the context of last summer's ozone interim committee, and I know there was a lot of robust conversation about the relative contribution of the oil and gas industry to NOx and ozone, and I guess what I'm wondering is, or my question is, given that the result of that was the legislature determining that the industry is a significant contributor and more should be done, and really just charged this agency with sort of ensuring compliance with those intensity targets and those reductions, and not really engaging in a debate on the merits of that. And I guess I'm really trying to understand what you're trying to tell us with those slides.
Thank you for the question, Commissioner Oath. So our intent was to rebut the testimony that other parties presented, saying that the oil and gas industry was responsible for 8.6 parts per billion of ozone contributions. We'd also heard testimony about the bathtub analogy, saying that the air is full and that you need to do more in order to reduce emissions from the oil and gas industry. And there were also several provisions of the statute and the proposed rules, for example, the enhanced systems and practices that direct the commission and the ECMC director to evaluate sources ozone contributions when determining which enhanced systems and practices to apply. And so we thought it was important to submit the data showing what this industry's contributions have been historically to overall cumulative ozone levels.
Okay. Thanks for that.
Commissioner Messner?
Thanks. I just dropped my pen 1 second. I need it for my notes. Appreciate the testimony, good conversations. I've got four four things I want to chat about here. So the first is going to be the enhanced systems and practices, and I'm continuing to scratch my head on this one. As I mean, I certainly don't read the legislation as requiring ECMC just to develop a list and not apply that list. I mean, it's pretty clear to me in reading the statute that we're required to develop enhanced systems and practices and implement those enhanced systems and practices, and not have necessarily a choose your own adventure of what you think might be work or might not work, but develop something that takes into consideration consultation with CDPHE as well as operators, but to develop a list that is implementable and meets the goals and requirements of the legislation. And so understanding that the list that has initially been developed in this draft rules is an attempt at that. It utilizes the word as practicable, which builds naturally into the language of the rules these concerns that continue to get brought up by industry, that there are times when these things may not be possible, but simply requires an act as practicable and inevitably a showing of why it's not practicable. So what's the problem? I guess is my question, because it seems like we're saying the same thing here, because the as practicable language covers the concerns I think that I'm hearing from industry and still meets in some ways, I think, the statutory obligation this agency has in this rulemaking.
I think that's a fair question. And I think, to be clear, we're not saying no in any instance. There are two that apply to particulate matter, and that's not a no zone issue. I think that needs to be fixed based on the statutory directive, or at least clarified, because the language is confusing. If it's confusing to us, it's confusing to inspectors, and that leads to notices of violation. I think also when we deal in air quality, we're very prescriptive on language. As practicable can mean a lot of things. We talked a lot in our initial testimony about electrification and whether or not a utility would provide you with a letter that says that they can't provide you electricity. It would be practicable for them to be able to provide you with electricity. However, I question if you have a 4-well pad, whether running highline power for 4 miles is the best thing for wildlife, is cost effective, and is in fact practicable. And so I think we're not saying no. I think we're saying that a blanket provision that says that these are required, as we see in that 316A4 1 through 4, we see that as being a requirement at every site. And I think that's difficult for us to do. And so I think we just want some flexibility and to be able to make a demonstration that's clearer. So I think we're just asking for clearer language. I would also say that I think we leaned into most of those and followed up on Commission Chair Robbins's ask about implementation date. We talked about supply chain issues and other issues, but we can do everything else on the list by the effective date of this rule. And I think that we definitely aren't saying no. We're just saying that those 4 things blanketly applied are problematic for a large number of operators. Doesn't mean that they can't do half of them 50% or 70% of the time. It just means that we need some flexibility and an understanding of what is practical.
Okay. So even in the one I think that you've got the concern about, which is the 316, I thought I had it memorized, but I don't. 316A 1 through 4, 316-4A 1 through 4. Still says impracticable in that. So I guess I'm not sure where this, and we can argue about as practicable being the right term or not. So that's a fair argument, I think, in this rulemaking, but does that as practicable as in that? So I'm not sure this blanket concern that it is required in every instance, unless I'm missing something, is true.
I guess I'll have to go back and look. I didn't read those as being in the as practicable list. I read those as being required as a blanket requirement across the board in the ozone non-attainment area.
Okay, and I could be wrong too. Lots of different drafts, lots of red lines. I get confused sometimes with the red lines, but at least what I'm looking at, I think it is in there, but I'll move on from it at least, and maybe we can get some red lines.
Mr. Master, I would just add that I'm not the only one confused. I think, COCA's greater membership was confused and thought those were blanketly required. So however we clarify that, I'm all for it.
Okay. Thank you for that. The second one is this working pad surface concern, and I think Mr. Martin, you had brought that up, calling it Pandora's boxes. I think it's only Pandora's box, and the reason I say that is I think the request is for that working pad service to only apply to notice. At least that's my understanding of some of the stakeholder thoughts on that. And so I guess my question to you is, if it is only defined to be notice requirements, does that give you as big a concern?
Commissioner, go ahead, I'm sorry. I didn't mean to interrupt you.
And without going back and reading everything again, which I didn't have time to do before I asked this question, I think it may also be notice requirements inside disproportionately impacted communities refined even further. But I may or may not be correct with that one. So just thoughts on that, I guess.
Commissioner, I have to confess, I didn't read, if there is language on that, I didn't have a chance to read it again before testifying this afternoon. I can commit to doing so and getting back to you.
Okay, thanks on that. And then impact areas, and so this is another one, and I've said this before, and so I want to certainly, and I think you've already reacted to it to some extent, but I think what I heard is that, and often hear, is that operators want certainty, they want less process, they want like more clarity, and I understand that and I appreciate that. I guess my question is that by defining something from an impact area standpoint, resource specific impact area that has some clear rationale or science as to why that impact area is appropriate, and that is implementable, that impact area, for evaluating at least the potential cumulative impacts of an existing area, and not a setback, or doesn't have that tied to it. This is an evaluative tool. It seems like having some of these kind of determinations of like what is a pragmatic resource specific impact area rather than just a default and we'll figure it out in the pre-app meeting is going to create a lot less challenges, a lot less process, and a lot less time debating this in the application, and a lot less staff time from all the different relevant agencies than going with just a mile circle to be figured out at the pre-hearing meeting, which I think, at least I'm interpreting from at least feedback in this rulemaking process so far, is that inevitably going to get challenged in a lot of different scenarios moving forward. So I guess thoughts on that.
So there was a lot packed into your question, Chair, Commissioner, so I'll do my best and you can tell me what I missed. So it's great to hear you talking about implementability, if that's a word, ability to be implemented. And that's certainly something that's been at the forefront of industry's concerns about the scope of impact area. I'm not sure whether our approaches at the end of the day would get to a different result. But I think two things, I guess. One is it will be a challenge for someone, presumably operator and staff, come up with individualized impact areas per resource per OGDP, if we're talking about OGDPs. Excuse me, it's asthma season. So that's a challenge, but the benefit of having a default value, and we chose a mile. I know that there are certainly parties that would suggest a different default value, but the benefit of default value is at least gives you some place to start. I don't think industry is under any misapprehension that it will always end up at a mile for each of the different resources at each of the different OGDPs, but it provides a context from which one can start. I think it was Ms. Fury suggested that 1 mile might work for air resources. I understand other experts who testified suggested different numbers, but predictability and certainty, you're right, are absolutely at the forefront of industry's thoughts about this. And we think 1 mile gives you at least a place to start. Having said so, I've pondered for a few moments now, that questions from Commissioner Ackerman and Commissioner Robbins about 2.5 miles for at least for water. And it occurred to me that we might be able to narrow that question down if the staff have the resources and the time to ask the staff whether or not they have experience with releases of hydrocarbons reaching 2.5 miles downstream. I'm not going to hazard a guess at what the answer to that might be, but in a lot of places, 2.5 miles in a water course is a long ways, and it can include a lot of data points. So we keep coming back to the simple, consistent, predictable default of a mile, recognizing that there's room for disagreement on those issues.
Okay, thank you for that. I think that's my last question. I think Commissioner Oath kind of hit the other question I was going to ask, which is around the NOx piece. So thank you.
Further questions for the panel? All right. Thank you very much to the panel for the presentation, the information, and for the review of what others have said and providing perspective back. That's what rebuttal's about, and it helps refine issues. So we thank you for that.
Thank you, Mr. Chair.
Commissioners, let's talk process. We have a 4:30 hard stop. That's 20 minutes away. I would suggest we go ahead and hard stop now. What we have left is Chevron for 35 minutes of direct, Oxy for 36 minutes of direct, and then we're calling back Green Latinos for a couple of issues for questions and answers. So with that, we've got tomorrow and then 4 days the following week for deliberations. I believe will be done in the morning. Unfortunately, I also have another engagement that will keep me occupied until 10. So I would propose we start at 10 tomorrow, take the 3 cases or the 2 cases in chief, take Green Latinos for Q&A, and then amongst ourselves, we can start talking about process and next steps in terms of deliberation. Does that sound fair? All right, then I would suggest that this matter is continued until Friday, September 20th at 10 a.m. And we look forward to seeing everybody there. Thank you, everybody.